welcome to our conference, Intelligent and Autonomous Emergent Digital Technologies and the Challenges of Disinformation, Security and Regulation. My name is Ignas Kalpokas. I'm Associate Professor at Vytautas Magnus University and one of the co-organizers of this event. So without further ado, I would like to invite Professor Julia Kirshienė, Vice Rector for Research at Vytautas Magnus University, to welcome you to our conference.
Dear colleagues, good morning. On behalf of Rector Juozas Augutis and community of Vytautas Magnus University, it's my honor and pleasure to welcome this conference. Yesterday in Lithuania, we celebrated the day of regaining independence from Soviet occupation. And looking at the program of this outstanding conference, I just realized that if not the transformative political change more than 20 years ago, we would not have our Vytautas Magnus University, as the history of it closely related to the independence of Lithuania. As well, we would not probably have such world-class young colleagues as Ignas Kalpokas, which is one of organizers of this conference and who graduated and acquired PhD abroad and got profound skills and networks. Furthermore, we would not have such conference with cutting-edge topic, interdisciplinary program, and so many international speakers from more than 12 countries, including India, Canada, Greece, Estonia, England, Scotland, Belgium, Poland, Portugal, and 3 Lithuanian universities. Thus, because of this day, I want to say how much I appreciate this conference and all speakers, participants, and organizers for their time and efforts, and want to wish you good luck. Also, for all of this, we as university owe to you at least coffee and cake. So I invite you to visit Vytautas Magnus University and Kaunas as soon as possible. And for now and for all day long, I wish you to enjoy the intellectual party. Thank you so much.
Thank you very much. And I would also like to welcome the second opening speaker today, Kasparas Ruklis from IREX in the Baltics. And the floor is yours.
Laba diena, good morning. Dear Vice Rector, conference organizers and participants, first of all, let me say su kovo vieno likta to our Lithuanian colleagues, and this is a wish for yesterday's Modern Independence Day. On behalf of Media Literacy in the Baltics, a program of the US Department of State implemented by IREX, it is my pleasure to address you at the very start of this day-long exchange about the emergent digital technologies and challenges posed to our societies by disinformation, security concerns, and needs for regulation. Digital technologies have indeed changed the way we interact and do business today, bringing both enormous positive effects to almost every aspect of our lives, and also along with it, some unsolicited challenges. The rapid spread of unverified reports, fake images, altered videos, and disinformation, oftentimes automated, is among the biggest of them. The citizens can find themselves very confused in the midst of all this, often conflicting messages, and they require new skills to survive in the information environment that is highly mediated, saturated with so many choices. And sometimes even to make the best decisions for themselves on important everyday issues, be it political citizen choices, whom to vote for, social choices, whom to trust, commercial choices, what to buy, and even choices about the most precious thing we all have, our health, to get vaccinated or not to get vaccinated. Media Literacy in the Baltics program is designed to help people find the right answers for themselves. In our trainings and study courses on media literacy, we do not tell people what information to read or which channels to watch, but give very practical tips on how to process and verify information that comes their way and what to make of it. Not what information to consume, but how to do it, so that citizens are better prepared to critically engage with information and make informed, well-vetted decisions for themselves. IREX, being a global development and education organization that works in 100 countries around the world, has also had a pleasure working with the organizer of this conference, Vytautas Magnus University, which adapted IREX's Learn to Discern Media Literacy approach into a university course for future journalists and communication specialists called JEDI, or Journalism in the Era of Disinformation. The course has ended now with great results, and we hope that this curriculum will remain a permanent part of the study course for future journalists here in Lithuania, and not only. Communication professionals, especially journalists, are often the first line of defense against disinformation, because disinformation creators, both domestic and foreign, choose to target journalists first, because journalists are in a perfect position to spread information to mass audiences. It is important that they do not fall victims of ever-growing new tricks that disinformation creators come up with. There are many stakeholders in the information environment today: bloggers, influencers, public affairs and public relations players, militaries, marketers, and even automated machines or bots that can spread information. Our program still puts confidence in professional journalists who gatekeep and present information in the best possible manner known to us so far: objective, balanced, unbiased, and verified, and the knowledge and skills of information users who decide for themselves. I wish you a very productive day, and if I may, let me also wish you something that we are teaching to our volunteer Baltic youth media literacy trainers, and it is resilience. Be intellectually and also emotionally resilient. Between academic exchanges today, remember to take breaks, stretch, feel good, and be fully open to enjoy and accept the new ideas coming your way. And after all, new ideas are the driving force that is taking us further and forward. Good luck today, and thank you.
Thank you very much for this introduction. Good morning, everyone, and welcome at our conference, Intelligent and Autonomous. I'm one of the co-organizers and a PhD candidate at Vytautas Magnus University Faculty of Law. And we start the day with a panel focused on practical applications of the new technologies, new digital technologies. We have 6 papers in this session, and we will first proceed with the presentations of no longer than 12 minutes. Please strictly keep to the allocated time and be ready to share your slides if you intend to use any. After the presentations, the panelists will be able to kickstart the discussion, and then we will proceed with the audience questions. So the discussion starts only after all the panelists have presented. The conference on Zoom is being recorded and is also being streamed on Vytautas Magnus University YouTube channel. I invite the audience to write their questions either in YouTube comments section or here in Zoom. And without any further ado, I invite Professor Julija Kiršienė and Associate Professor Saulė Milčiuvienė of Vytautas Magnus University to present the paper, The New Paradigm of Energy Market Regulation, Impact of Digital Technologies. The floor is yours.
Good morning. I hope you can see my slides.
Yes, we can see the slides.
But okay, I can navigate them. So good morning to everyone, and thank you for joining the conference. It's really a great honor for me to share with you the results of our recent study. My name is Saulė Milčiuvienė. I am from Vytautas Magnus University, and I am going to present the study, which was conducted together with Professor Julija Kiršienė, about the influence of new technologies to the structure and regulation of energy markets. So the times when huge centralized generators produced most of the electricity are changing. Now, more and more electricity is produced from renewable energy sources. New technologies are allowing for consumers not only to consume, but also to generate, to store electricity, and to supply it even to the grid. Consequently, from energy consumers are emerging new very important electricity market players, energy prosumers. Lithuania National Energy Strategy predicts that prosumers will amount about 50% of all consumers in 2050. The increasing role of energy prosumers is emphasized in the 2016 European Commission legislative proposal on renewable energy and internal electricity market. The European Parliament and the Council adopted a directive on the promotion of electricity from renewable energy sources on December 2018. In it recognizing that only the changing role of consumer can meet the existing challenges in energy sector, and the European Union Commission put not energy companies, but energy consumer in the center of energy sector. The aim of research is to investigate the impact of technology to changing paradigm of electricity market regulation. Analysis will be focused on renewable energy prosumer in electricity sector and usage of solar PV technologies. The main task is to examine the concept of prosumer, to discuss the role and function of energy prosumer in electricity market, and to discuss main regulatory issues. Initially, the prosumer concept was developed by Ivan Toffler, 1980, in his book, The Third Wave. In this book, the author argues that in future, the consumers will produce more goods and services for self-consumption. Analysis of given definition of prosumers leads to the conclusion that there is no one definition of prosumer. However, all definitions have two same components, produce and consume. This means that the main feature of energy prosumer is the ability to consume and produce energy. All other named features, for example, individually or through collective organization for their own needs, are additional and can be significant only defining certain time of prosumers, but they are not required. It is important to stress that the word prosumer is not used in European Union legislation. The Directive on Common Rules for Internal Market in Electricity use the term active customer, and Directive on Promotion of Electricity from Renewable Energy Sources, renewable self-consumer. However, a renewable self-consumer and active customer obviously are energy prosumers, as we perform two required functions, consume and generate electricity. Also, they both can sell and store electricity. The active customer can operate only within its premises, as renewable self-consumer can be allowed to operate outside its premises according to the decision of member states. The rights of prosumer can be divided in two parts, operational rights and financial rights. So it's worth to discuss some operational rights. Above spelled activities enables the prosumer to choose among two options. The first option, the prosumer can become sustainable and strive to disconnect their facilities from the grid, seeking to avoid any costs related to grids, system maintenance, and stability. This option is not preferable, as would increase the grid maintenance cost for grid users. The second option, renewable self-prosumer, can actively participate in electricity market and contribute to the supply and demand management. However, only well-developed short-term market can ensure that prosumer will not seek to disconnect from the grids and will actively participate in the market. Another path is financial rights. So the European Commission seeks to create favorable financial environment for electricity storage activities, whereas they are not yet economically sustainable. They can play a vital role in supply and demand management. Therefore, the directive ensures that member states will not charge the prosumer for storage of electricity that they consume. However, every member state will decide on application of storage charge for stored electricity, not for self-consumption, but for sale. Second, the right not to be charged for electricity produced and consumed in the premises is not absolute right. The member states can set certain charges for generation capacities exceeding 30 kilovolts, or if necessary, to ensure the financial sustainability of electricity system. Third, prosumer still is not economically sustainable. So market-based support schemes are necessary for small-scale self-consumption systems during the transitional period. Despite the many advantages of electricity prosumer, its smooth integration into electricity grid raises many questions. The major challenge is related to difficulty to predict electricity generation schedule because of unstable sun radiation. It means that grid operator can hardly predict how much electricity will be supplied or demand from the grid. The second challenge is prediction of prosumer behavior, how much electricity and at what time the prosumer will use for his own needs or will supply to the grid. The balance of electricity grid is a major issue, as electricity cannot be stored in the grid. The amount of supplied to the grid electricity must be equal to the amount consumed electricity from the grid. The possible ways of solution can be usage of smart electricity meters that can predict network load based on historical data and projected consumption schedules. However, at this stage, we face major issues related to prosumers' right to the privacy and protection of personal data, as it becomes clear that according to the electricity consumption schedule, we can predict when the prosumer gets up, goes to work, goes to sleep, or are on vacation. The second question is related to the prosumer status. The question whether an energy prosumer maintains the rights and obligations of final consumer. European Union directive now guarantee the prosumer the status of consumer, but will the prosumer maintain this status as the volume of production grows? What criteria must be decisive in determining where energy prosumer must maintain the status of final consumer? So, to conclude, the emergence of new technologies has led to the emergence of new market player, the prosumer. To ensure its efficient functions in electricity market, certain actions should be taken. First, short-term electricity market should be developed. Second, adequate protection of the prosumer's rights to privacy should be guaranteed. Third, prosumer status and electricity market should be clarified. So thank you for attention, and that is our short presentation.
Thank you very much, Saule. Thank you for your presentation, and thank you very much for keeping to the time limit. We now move to a very different application of modern digital technologies and how these may facilitate access to justice. And I invite Inessa Stopler, who is a PhD candidate at Mykolas Romeris University and a lecturer at European Humanities University, to present her paper. The floor is yours.
Yes, hello, good morning. Can you see my presentation? It's a standard question now.
Yes, we can see it clearly, full screen. Thank you very much.
Thank you very much. Good morning again. Thank you for organizing this interesting event and having me today. My name is Inessa Stolper, and I'm going to talk, to be speaking to you today about how digital technology can be used to improve access to justice and in particular legal awareness. So my key message of my presentation is that technology is a powerful tool to enable change. So technology is already used for automated decision-making in administrative setting, employed in courts for administration of justice, assists in gathering digital evidence, and even provide ample opportunities for online dispute resolution system. So before COVID-19 pandemic, the discussion on the role of technologies in justice system was rather cautious and even sometimes futuristic. However, global pandemic accelerated the process of digitalization in urge to find solution to provide access to justice when movement and social contacts were and continue to be restricted. I would like to provide you with some background, why I'm going to speak in particular about legal awareness today. We commonly understand by legal awareness ability to make judgments about substance of law, legal process, available resources, and how to protect our rights. So simply speaking, in order to exercise rights, one must first know what those rights are. Legal awareness is also used sometimes as a metric to measure access to justice. So how do people know about their rights? Of course, there are a number of places such as school, university, websites of public institutions and non-governmental organizations. But honestly, how much a person without legal education knows about tax law, family law, contracts, dispute resolution? Maybe at this point you would say, well, if the person has a legal question, one can go and see the lawyer. And this is exactly the question which was researched by World Justice Project. The team questioned 100,000 people in 101 countries. So the results show that 49% of people experienced at least one legal problem in the last 2 years. 29% of people, roughly half, who experience a legal problem sought any form of advice, and this includes family members and friends. And only 17% of people sought professional legal help. So reasons for such a low number vary, but some of them include, firstly, people do not understand that the problem is of a legal nature and not just a bad luck. 16% of people reported financial difficulties to access legal aid. So as the result, 17% just gave up on trying to solve their legal problem, and 39% reported that legal problem persists. They either don't know how to solve it or they are in the process of solving it. So it's quite impressive numbers, isn't it? There is a large percentage of global population which does not receive or have access to justice. This problem is not in any way new, but can digital technologies help to address this problem? Or can they at least assist people in identification that the legal issue exists and this is not just a bad luck? Can it provide some basic advice when people do not have financial resources to seek legal aid? So my answer is yes. In order to open discussion on how technologies can help, I would like to demonstrate you very briefly 3 examples of existing solutions. One is from public field, second one is developed by research institution, and third one was originally developed for private needs, but already used in public domain. Of course, this is not an exhaustive list of possible solutions. However, examples will illustrate what options are already available. My first example is from public field. Civil Resolution Tribunal in Canada is an administrative tribunal which has jurisdiction over small claims. In essence, this is online court, which offers explorer expert system which operates without human intervention. The system uses a decision tree of questions and answers, but does not involve artificial intelligence. So it is capable to giving basic legal advice and is capable to draft a letter that can be sent to the person on the other side of the dispute. It is quite simple system. In practice, it looks like this on the slide right now. One has to select a question first, then system generates user-friendly legal explanation. Finally, it provides a number of options where to proceed. For example, negotiate or to find a legal assistance or submit a claim online without any legal help. So the notable fact is that the tribunal is fully integrated in a public justice system. So the decisions of the tribunal can be easily enforced as any other decisions. It is a bit specific because the aim of the tribunal is not only provide legal information, but also to resolve disputes. My next, however, example is the system which focuses on providing legal information and advising. So this is an amazing project started by the Stanford Legal Design Lab, which uses human-centered design and agile development methodology to design new solutions for legal services. It functions based on sort of simpler version of decision tree model. First, one has to select jurisdiction and question. In this example, I was choosing California. Then the system generates a summary document and a number of links where additionally situation can be assessed. So the system helps to understand legal rights and find legal assistance if necessary. I find it a bit difficult the website to navigate, but it contains impressive amount of user-friendly legal information. My third example on how technology for legal awareness can look like is technology which I think primarily was developed for private sector, but can be easily adjusted for legal awareness needs. I'm speaking here about a chatbot. A chatbot is a computer program that's designed to stimulate human conversation. A chatbot provides a predefined answers to very specific questions in very engaging manner. So how can we use chatbot for public awareness and whether it's useful at all? So this is how the law on quarantine of the Republic of Lithuania looks like. So the law was adopted in November and has been changed a number of times. It's not the most long and complicated law, but it's quite difficult to read by non-lawyers, as all other laws, of course, and even more difficult to track changes. So in Lithuania, we have specifically dedicated website for COVID-19 issues. This website employs specifically developed chatbot Vilte. So this is how the law on quarantine will look like if a chatbot is used. It is able to answer simple questions and advise resources such as list of private labs where to do PCR test. So it's 100% easier to access, use, and understand the law. Myself, I do have legal education, but I prefer to consult Vilte from time to time for COVID-19 related questions rather than reading the law. So to sum up, available digital technologies allow having at least 2 models. One is individualized assistance system based on predefined question answer. And second, more interactive chatbot integrated into a dedicated website or governmental and non-governmental institutions. Both models require creation of simplified version of law to make it user-friendly and without losing the essence. So technologies can make law more accessible, more usable, and more engaging. So as you see, there are tools which can be already used. So the question remains, why they're not used? To conclude, I would like to list some of the challenges in this field. Firstly, the first challenge is recognition that the problem exists and that we want to solve it with the tools which are already available to us. Secondly, of course, there has to be dedicated financial resources by the state to develop such system. I also do not exclude that companies in private sector might be also interested to develop such a system for a small fee. Thirdly, there has to be an infrastructure, and I think the biggest challenge is maintaining this infrastructure on continuous basis. And finally, when we're going to implement the system or we were going to have a more user-friendly system, there has to be training and information dissemination between population that such a system exists, how to use it, and what benefits it can provide. Thank you very much for your attention, and I'm looking forward for your questions.
Thank you very much, Nessa. And we continue the discussion with the paper on artificial intelligence in legal field, a beginning of a new era, by Gurjinder Kaur, who is an assistant professor, Department of Law at Guru Nanak Dev University in India. Welcome. You're on mute. Please unmute yourself.
Sorry. Yeah. Thank you. I'm Gurjinder Kaur, Assistant Professor from Department of Law, Guru Nanak Dev University, Amritsar, Punjab, India. I extend my warm greetings to all the respected dignitaries here, and to the organizer, I thank them for inviting me for presenting my paper here. The paper which I am going to present today is the topic is Artificial Intelligence in Legal Fields, a Beginning of New Era. I would not be using the PPT here because certain technical issues are there, so I'll be presenting it otherwise. So in the era of innovations, a way ahead is being progressed by the marketing feat of the concept of artificial intelligence. It has not only brought a revolution in the technological world, but have also given rise to the other field also to grow. So a law or a legal field is primarily considered as such one field which has moved by making nimble move, incorporating the potential dimensions with its application. When we talk about AI in its definitive world of meaning or definition, it is always ever evolving and developing. That is why the standard of intelligence also keep moving eventually to a higher standard. Here I would like to throw a light on the definition which is given by John McCarthy, stating AI as a concept of cognitive technologies. Now, what is this cognitive technologies? Basically, it is based on the three covers arena, that is ML, APIs, IR, and SR. Now, ML is the machine learning, which uses computer algorithms to make assumptions and predictions about similar data sets. API is the application programming interfaces, which uses AI to provide a predictive output from a standardized set of outputs. Along with that, image recognition and speech recognition is a cognitive computing and deep learning, which builds upon ML and uses pattern of recognition for cases like voice recognition and facial recognition. So the whole revolution of artificial intelligence fascinates everyone, and it's changing many aspects of our lives. All these patterns in AI has given rise to the legal field as well, benefiting its professionals on the different aspects, like from the common man to the judges, to the advocates, to the law firms, to the researchers, and to the academicians. If I state a report which has been given by the National Judicial Grid Data, of 2020 in India, it has this indicated that in the last decade, more than 3.7 million cases were pending in the various courts in India. So basically, what I'm trying to present here, or my focus is there on that what sort of a benefit is there of AI when we use this in the legal field, ranging from the common man to the judges, advocates, and the legal firms advocates as well. So here, the basic benefit which has been driven by AI is that it is a time-conserving method. So as I already stated, that through the report which has been given by National Judicial Data Grid of 2020, more than 3.75 million has been given as a pendency of the cases. The journey is from filing the cases to its judgments. It's very long and very draining one. So with the help of artificial intelligence, daunting tasks like the legal research, discovery, due diligence, contract drafting, contract analysis, they have become more easy. So the discovery or of these time about, the prosecution has to present the defense with all information and evidence that we have about the cases. Second benefit which is there in this regard is that it's being able to focus more on the complex work. With AI playing its role in the performing with the major tasks, the lawyers can focus more on the complexities of cases while the software takes care of the repetitive tasks. It is also cost effective because tasks like documentation, analysis, etc., used a lot of time and manpower as well, and hence there are the scarcity of financial resources which is being used. So with the use of AI, these repetitive and easy tasks have become more efficient and quick. Therefore, it has also led to the cost reduction. Now, as the AI is a data-fed machinery, better algorithm-based predictions can be there. This can be used by the lawyers to put algorithm to work, and those algorithms which can conclude the smart analysis. It can also contract analysis and drafting as well, and it can help in the decision making also. There are a few examples which will also clarify that how the artificial intelligence is there in decision making, and it's also paying its heed in the legal research. If I quote the examples from India, we have three, four kind of specific examples like Spot Draft is a software which can review contracts in minutes. Otherwise, it is a kind of task which will take days and weeks to go on. But the standardized software which has developed by the Gurugram-based startup, they have established Spot Draft by which a task of 2 week contract can be done in the minutes or in the hours. CaseMine is another kind of startup which uses AI to find out links between various case laws, provide a summary on those case laws, and also it helps make legal research more extensive in less time. Another example is also there, that is Practice League. This platform also empowers many business units with accurate reporting, fast delivery of legal services, data-driven insights to become the next business enablers of their organizers. But as we ponder upon all these kind of benefits which we have in the AI, but can we say this thing that with AI, with the artificial intelligence, the benefits has not given any kind of lacuna or the loopholes or the question which are unattended, that is not there. So if we retrospect the all artificial intelligence benefits, there are some core issues which are unattended and which are unanswered. And they are the basic canons of the jurisprudential aspects as well. I have identified, like there are a lot many other also, but I have identified the four issues here, which has not been covered as such uh, by the issues here. First, that when we use AI in the different manners in the legal fields, either that's for researchers or for the judges or for the lawyers or for the firms, how and what is the legal personality of the artificial intelligence? Can we accord the state of a person or a citizen to it? If it is not so, again, the next issue ensues from this, that whose liability is to be fixed? if any loss occur due to the negligence of an AI? Will the principle of absolute or vicarious liability applies in such state? If that is not so, even if liability is fixed or attributed, what sort of punishment could be attributed to AI? And this problems for its very basis set the stage of a new unanswered questions as to which theory of punishment would be reliant to take the basic objective sentience. As being compared with the humans, it would be retributive or pardoning or other kind of theories which are there for the punishment. So further, AII, when we talk about this, it puts embargo on the nature of the sentient which is attributed to it, rather it's civil or criminal. And again, it revolves back to the very first limitation of AI in the legal field of it, that is legal personality. So legal responsibility and personality has not been covered up in a very extensive manner in India. When we talk about the legal regulations here in India, as being a developing country, we are on a stage where the development and its use is rather more focused than its regulations. It's also not there that we do not have any kind of regulation here. We do have the Niti Aayog is there, their rules are there, certain kind of data bills are there, Information Technology Act is there, which is regulating all these kind of questions. But as artificial intelligence is working on the data, online data resources and processes, it is always called for having a specific kind of law for this. So by concluding my discussion, my paper presentation here, I would say that the approach toward AI should not be dependency, but it should be the extensive support. So I would like to quote here the quotation given by Justice D.Y. Chandrachud as well. He said that the idea of artificial intelligence is not to support the human brain or the human mind or the presence of judges, but it is to provide a facilitative justice. So what we need to ponder on the questions here is that with the benefit, we are heading toward the situation in which its recognition and regulation is also required. So that is what is required. That is all for the presentation today. Thank you. The questions will be welcomed.
Thank you very much for your presentation. And moving further, I'm very happy that we have at our conference also people who work in legal practice, and I'm very grateful that they find time to contribute to academic discussions. I see these interactions as very important and beneficial to all concerned. I invite, if I may, a dear friend and the president of the Lithuanian Young Bar Association, an expert attorney at law at Alex Baliūnas law firm, Dr. Edvinas Miškys, to discuss the challenges of new technologies in the legal profession. The floor is yours.
Good morning, Julia. Good morning, everyone. Thank you for inviting, and I would use the opportunity to actually thank Vytautas Magnus University for this kind friendship, and also invite every student to join our association, where we also speak about interesting topics, and you have the chance there. Going to the topic about the challenges. You know, for a few decades, there were myths that technologies are only for the experts, for the IT people. And I still remember those times when in CVs of lawyers or any other professions, you could see the skill as using emails or Microsoft. And now we are going much further, and this understanding could be also reflected in the history of some of the big companies. Let's speak about Kodak, which actually invited also digital camera, but at that moment actually didn't think that this is gonna be the future, or Nokia, which went bankrupt because they didn't believe in the technologies. So I believe more and more we have to think that technology is the part of our life. And firstly, before going to challenges part, there are many opportunities which we could use to solve social problems, gender, racial, wealth, equality questions, possibilities to provide legal services for lawyers with disabilities, for those who are on maternity leaves. The technologies could allow foreign lawyers to actually participate in legal processes. And we see with the pandemic that it's getting easier and faster. I believe many years ahead we shifted during this COVID process. The challenges, of course, we could divide them from very basic to very specific. So firstly, the basic knowledge. We all thought that lawyers should firstly understand the legal field. And this is the case for sure. But when it comes to technologies in our daily practice, there was a study conducted called the 2020 Future Ready Lawyer Survey in the United States, and it showed the difference between the advancement of technologies and readiness to implement it. While 78% actually said that they believe that technologies should be used in daily practice, although 28% stated that they are ready to use it. And I'm not speaking only about emails and Zooms, but there are many technologies which we could use. And it reflects to the companies which actually said that they would expect in a few years period that lawyers who provide legal services could describe what are the technologies they're using, are they safe? And knowledge about the use of technology could actually mean what should we choose, which platform to use. We all heard the rumors that Zoom was not secure, but now they actually fixed those patches. Then how do we protect personal data? Do we comply with GDPR, especially if we are practicing within EU? And then very, let's say, hard thing to do is to disconnect after hours. You know, when you work with clients, it's so tempting, especially if you have them on social media, to write you during the night if they have a question about your case. So how to disconnect from there, how to stay focused. And this is essential skill for future lawyer, I would say. Going deeper, the second challenge would be general knowledge about AI impact and technologies for legal services. Should there be liability when we use third-party systems and IP? And should we actually be responsible if the system gets hacked, or if we acquire certain systems which might have infringed the IP rights before? Later going, we develop artificial intelligence. Should we get the authorship rights? And should we consider direct or indirect damages? These are the basic questions which more and more clients gonna ask you. And you cannot say as a lawyer, you know, I'm very old-fashioned lawyer, I work with real estate and I'm not into technologies. In a few years, it's gonna change, and those questions in regards to technologies would definitely come to lawyers. The third challenge, I would say, is rather specific knowledge. And here I would mention deepfakes, and I'm glad to mention that in case you would be interested in that, we have co-authored with Julia Kalpokienė, Paulius Jurčys, and published the article at Oxford University journal. It's called Regulating Deepfakes, Legal and Ethical Considerations. And we go into more details there. But I would say if you are not familiar with deepfakes, that this is a term which refers to face swapping technologies that enable the quick creation of fake videos or images. And the problem is that they more and more become very realistic. So it's very good when it comes to creative purposes. You might have seen Mr. Bean presented at the Dior's commercial for J'adore perfume. And this is very fun, you know, or you can use some apps to put yourself into a famous movie. But those deepfakes and those technologies driven by artificial intelligence are also used for pornography, creating fake videos, financial crimes. You know that some technologies now use the faces to recognize you, and those deepfakes might in the future help someone to get into your account, get access to any technologies, any social media. So this is a threat, and we have to keep that in mind. The same technologies could be used for blackmailing. So Grabman, Shear, Meisels, and Sachs, this is a quite famous law firm, was hacked, and the hacker actually asked for $42 million ransom if they would not want the hackers to reveal the private information. So this is why it's very important also to look at this security part of the technologies, what we use. Another example was Tikhanovskaya, so Belarusian leader at this moment. She was supposed to participate in EU meeting, and someone faked the voice, and for 20 minutes everybody thought it's her speaking on behalf of Belarus. So this is very, very dangerous matter. And if we are going further, it could create the impact for democratic purposes. It could make a damage politician's reputation, create damage for the society, because you might vote wrongly. And we all heard about Cambridge Analytics case. There are many cases. Gabon country's army tried to falsify the president's image about his bad health and actually tried to overtake the position. In 2019, Pew Research Center revealed that two-thirds of Americans see this threat as very huge, and they actually do not see in this bunch of information which information is true and which is falsified. And with the emerging of technologies, this would be even further problems. Let's imagine if someone says that Pfizer or Moderna vaccines could kill people, and we see deepfaked video. So the lawyers here should solve many questions, from liability to how to qualify such crimes, especially if they become cross-border crimes. And with the absence of unified EU regulation and global regulation, it would be very hard to help. And the fourth challenge would go to legal trials. At the moment, we say that the court has internal beliefs based on the facts and provided evidences. But what if those technologies could actually allow you to falsify them and to make them very realistic? So I would say that in all the cases, we would have to have the experts who not only identify the person in the video, not only identify what was the, let's say, action made there, money transfer or such was there a crime, but also to certify if the legitimacy of the digital evidence. And the second problem I see in the trials is the identification of participants. I believe you also saw this funny video, which I'm not the cat, right? But this is the funny way. But what if there is a faked plaintiff which says, I want to take the lawsuit back, or someone fakes the defendant, which provides wrong statements, or a fake prosecutor dismisses the charges. These are the threats. So going to conclusion, I would say that we face new reality, and also for legal field, where Heo Lee, professor of University of Southern California, told to The Verge that any deepfake detector, is only going to work for a short while. In fact, at some point, there would be no possibility to say whether this faked video is true or not. So we will always have the problems, and as we had with the internet viruses, we have uploading, updating this antivirus, and then we go to virus site, they develop something. So in order to have new security measures, I would reflect to EU White Book and to evaluate all the risks through two categories, so critical sector and critical use. And I believe more and more we will have to do those evaluations. For the lawyers, it's not only good to know about certain technologies, blockchains, smart contracts, deepfakes. This is a new reality, and in order to provide good advice for the clients, we need to understand the business, we have to identify the risks and propose mitigation solutions. So technologies shall become a usual part of lawyers' workday, and I believe all the people who are here already know about technologies, so let's spread the word. Thank you.
Thank you, Edvinas, for your presentation. And staying on a very practical topic, I invite Assistant Professor at International...
Hellenic.
Yes, sorry.
Not a problem.
You went into presenting mode and my text disappeared. So that's fine. That's fine. It's great. So I invite Assistant Professor at International Hellenic University, Greece, Dr. Komninos Komnios, who is also an attorney at law, to discuss digital justice, the use of predictive justice tools. The floor is yours.
Julia, thank you very much. You pronounced everything correctly, and I'm impressed. Thank you very much. Thank you, Ignas, dear organizing committee. I would like to thank you warmly for offering me the opportunity to participate in the intelligent and autonomous debate with my presentation on predictive justice tools. Let me start. I will skip in my introduction any definition on artificial intelligence, what artificial narrow intelligence or what artificial general intelligence is, but I'm forced to give you a very short definition concerning predictive analytics. So predictive analytics in short terms are algorithms aiming at making predictions about future outcomes based on historical data and techniques such as statistical modeling and machine learning. As you may see from this slide, artificial intelligence is increasingly used in the legal sector as well. We all have heard terms like predictive policing, which refers to systems that make predictions about the occurrence of certain crimes. Here, the aim is either to clarify crimes promptly or even prevent them in advance. But in addition, recently, it is very trendy to also discuss the use of intelligent analysis tools for evaluation of court decisions. The aim here is different. The aim is to try and forecast how decisions will be made in ongoing court proceedings, or what solutions can be expected from the higher courts in the case of legal questions that have not yet been completely clarified. So this use of predictive analytics in court proceedings is known as predictive justice tools. I decided to focus on two existing systems. there is an infamous project that deals with the prediction of decisions of the European Court of Human Rights in Strasbourg. This system is based exclusively on automatic text analysis, so it uses natural language processing. I consider this system probably not suitable for general use, and the reason why is that, first of all, the quality of the predictions is reduced by the small number of available European Court of Human Rights decisions. Moreover, the analysis is limited to facts as they are formulated by the court itself. This means that the analysis is possibly influenced in terms of content by the desired result of the court. In order to address this problem, there is the proposal that information which was already known before the decision of the court, such as, for example, the statement of the claim, could also have been used to address this issue of the analysis being influenced by the facts formulated by the courts. The other existing system is a system that was developed to predict the decisions of the US Supreme Court. This system uses the so-called random forest method. We heard some points about the forest method by Inessa, I believe. So this system is actually quite successful in terms of accuracy because it can predict with an accuracy of more than 70% whether the Supreme Court in the United States will confirm or overturn the decision of the courts of first instance. In this system, there is a large number of decision factors that is being used and evaluated. Even the political opinions of the justices is under consideration. Moreover, the system also evaluates the tendency of the judge to overturn or confirm the decision of the courts of first instance. So through machine learning methods, the trees learn from training data, and this increases the reliability of the predictions that are being made. So the question arises, is the system which is used for the US Supreme Court suitable for continental Europe, for the civil law court system? In order to address that question, one should take into consideration the very important differences between the various legal systems. As most of us know, the US common law system is based, among other things, on the stare decisis principle. This principle requires that cases follow the precedents of other similar cases. So it binds courts to follow legal precedents which were set by previous decisions. However, in continental Europe, we have most countries follow the civil law system, and the civil law system does not follow the stare decisis principle. It is based on the application and the interpretation of statutory law. So, given that our system in most European countries is based on the interpretation of the law, and the law changes more or less often or less often, this poses a big problem as regards the use of the system in civil law countries. So there is an important problematic aspect since the assessments appears to be much more difficult in continental Europe than the prognosis of the propensity to deviate from precedents of the US judge. One could argue that in traditional fields of law, a prediction may still be possible with limited effort. However, in cases of new legislation, prediction of the result of the interpretation of the law appears to be much more complex. So what can we do to address those problematic aspects? Well, the random forest method of the US Supreme Court system may be an instrument suitable eventually for the civil law countries. However, there is the obvious need to adaptation. It should be adapted to the interpretation of the laws. Besides earlier rulings, this system would also have to be enriched with additional information. For example, one could use the associated legislative material, for example, the explanatory reports of the law, or the legal positions taken by the judges concerned in the academic literature, Even the philosophical orientation of the judges would be helpful in order to adapt the system in the continental court needs. What are the practical benefits of predictive justice tools? More or less obvious. Better accessibility of the behavior and the direction of decisions of the courts. The predictive justice tools can be used as an auxiliary instrument for lawyers, with which they could potentially spot promising cases, or even recognize the judicial decision patterns used by the courts. Moreover, the predictive justice tools may assist to quickly answer the questions of the existence or non-existence of an infringement. Ideally, this could lead to a shortened process duration through prioritization on the side of the courts. In what sense? Clear cases would be decided quickly, leaving more time from problematic cases. At the same time, potential plaintiffs could be encouraged to file suit and not be deterred by the fear of lengthy proceedings. And last but not least, the use of the system may even lead to prevention of legal action. The weaknesses. A very big weakness is the risk that deviations between the facts or changes in the law may not be detected by the system, so that incorrect forecasts may be made. Moreover, a big weakness is that currently the fact-finding does not take place by the system. The investigation of the facts underlying the legal question is still to be made by humans. Another problem is that in many legal orders in Europe, we have the so-called free appraisal or free evaluation of evidence. Under this principle, the court is the one that has to make its own decision about whether an alleged fact is true or false. As you can understand, this poses a big problem, a big weakness in the system. And another problem is the lack of data quality and lack of data quality. At least in Greece, we do not have access to decisions of local or regional courts. We do have access, but very limited. So there is a small percentage that is being published in that respect. As regards the problematic aspects, it is also questionable in terms of legal policy if the use of such systems by the courts is desirable. It is obvious that they are very helpful. They can help the courts in pre-sorting cases and be a very useful auxiliary instrument for overburdened civil judges. However, there is a big danger that has to do with the protraction of legally complex disputes, as these could always be postponed. Then there is the issue that a technical pre-selection of pending proceedings according to their complexity would also collide with the fundamental right to be heard. Many scholars claim also that the use of those systems may undermine judicial independence as well. Legislative reactions. I will tell you only one, so as to keep with the time limitations. In France, the French legislator has already dealt with predictive justice tools, and in Article 33 of the Justice Reform Act, they introduced a partial ban on this technology in the legal context. Actually, violation of this French law can result in up to 5 years imprisonment and a fine of up to 100,000 euro. Many scholars are against this ban, as you can understand. It is claimed that it is unique in the world, and the legality of this ban is also seriously challenged. I will skip the background and conclude with my personal view on the subject. Personally, I feel that we should focus less on forecasting and more on analyzing the huge number of judicial decisions. In my view, at least within a legal order, all judgments could be collected in a database, evaluated and categorized within the judicial sector using the methods I described above. So after the receipt of a new case and an individual preliminary examination by the judge, in which the essential points of law are identified, an automated comparison with the previous case law could be carried out, which would reveal discrepancies or similarities. So the judge, through the system, spots the facts, the essential points, and the system after an automated comparison with the previous case law reveals discrepancies and similarities. Such a system would be, of course, very useful in facilitating the work of the courts, but it would also make a significant contribution to the uniformity of the case law and thus of the legal system. Likewise, judicial independence, which is normally constitutionally protected, would be preserved. So the advantage is obvious: reduction in workload, reduction in the number of appeal proceedings. Thank you very much for your attention.
Thank you very much. We're supposed to hear a presentation by Simon Elma, who is a PhD candidate at the University of Tartu in Estonia, but unfortunately she fell ill this morning and is not able to join us. So we move to, I thank you for all of your engaging presentations, and the range of topics covered in this morning's panel is very broad, and we can see that technological advancements impact different spheres of life and indeed of legal practice and justice systems. So to kickstart the discussion, I invite the speakers to briefly share their comments after listening to all of the panelists, and perhaps briefly ponder on the issue whether we are ready and prepared for these new digital technologies and whether we are quick enough to adapt to the changes that these technologies bring. So if there are any volunteers to start the discussion, you're welcome. If not, we can go in the order that you presented. Inessa, would you like to start? Just any comments or questions to other speakers?
Thank you. Firstly, thank you very much for all your interesting presentations. It's true that we now clearly see that there are many developments in this field, but I've also noted a little bit that there are some small aspects that technology has an impact in legal field, in justice system, a little bit here, a little bit there. I myself am a bit struggling with having a clear picture whether we can use one technology only, or we're talking about automation of some processes, or can we talk about some kind of a supermind which will assist in judicial field, in administrative cases, in legal aids, and so on. So I guess I have a general question to all the speakers today. What is the future of technology in legal fields? How do you see it as an assisting tool, or can it also substitute some of our daily tasks, as we just saw in the presentation about the predictive justice and how it can help the judges to deal with their daily tasks? So what's your opinion? Where are we heading with all this?
Let me start, Julia, if it's okay with you, so as to address the very interesting topic that Inessa has pointed out. Inessa, first of all, let me congratulate you for the wonderful presentation. It was I was thrilled. Well, I knew about Canada, but I learned a lot, and I would like to congratulate you on that. Now, my fear is not the fear of substituting humans or legal professionals in the field. To tell you the truth, when we started the discussion about the blockchain technology, I spotted the happiness of many people coming from the IT sector telling me, oh, you know what, it's the end of the lawyers, that it is approaching soon. I believe you have heard that already. They felt that our professional life coming to an end. Well, I propose that we lawyers exist for thousands of years, and we have overcome many difficulties. So blockchain is a challenge, but not something that poses huge problems in my view. What I feel and fear in that respect is the discrepancies in regulation as regards the use of technology. There is a huge problem of sometimes over-regulation in the field, which may pose a problem in the evolution of those technologies. But on the other side, there is the need of some governance. Julia and Edvinas discussed about their paper that I will personally seek and find to read as regards the problems of different legal systems and their approach on the subject matter. Within the European Union, we have the benefit of some form of uniformity, at least in some points. However, I believe, for example, issues that our colleague from media posed, what happens with legal personality in artificial intelligence, what happens with liability, very, very important issues. So in a nutshell, I don't believe that technology will replace us in the legal tech field. However, I think that we should attend the legal discrepancies in a uniform way so as to avoid any problems in the evolution of that very important technology. Thank you.
If I may add, I totally agree. Thank you for good expressed arguments and your view. I also would not be afraid that someone would overtake lawyer's job. You know, artificial intelligence, although we always threatened each year, but we know Siri could handle one question, and not only very good answers could be provided, it's very limited. But at the same time, I'm very happy that more and more boring works would be overtaken. Administrative works, which take a lot of time from lawyers and any person. So why not to give it to artificial intelligence? It's very effective. The only concern I have for the future is who shall control the technology. And we know that we implement artificial intelligence into many spheres, one of them being justice. And we already saw a few examples. For example, Amazon, they actually tried to implement artificial intelligence technology for labor, so HR matters. And if I'm not mistaken, within a few months, artificial intelligence learned that women are in a bit of disadvantageous situation because they leave for maternity and they are not maybe approaching some high career. This is why the technology started to not to hire women. And this is a huge problem because at the moment, artificial intelligence is being learned through previous examples, previous data. And until we teach the system how to think critically what we humans have, it might give not the result we want. So these are the questions we will have to ask ourselves: who shall control it, how to check it, and in the end, it should be still be the judges, the lawyers who take the last decision. So artificial intelligence could provide certain solutions in the trial, for example, but the last word should be of the judge. So this is the case.
So, Gurjinder, what are your thoughts? Are we ready for the future with technology?
Maybe I can jump in here.
Yes, sure.
More time to think for our speaker. I just want to briefly comment on what Edwin has just mentioned. because it's tremendously important topic, and we've heard so many discussions on whether the technology or artificial intelligence can be biased, can it discriminate, and so on. And there are indeed a number of examples how some things can go wrong, and really wrong. I think recent example in Netherlands also a great demonstration what happened in automated decision making in social security field. However, I'm always struggling with this one question that I want to raise right now. From who technology learns these things? It's, it doesn't have a feelings, it doesn't understand words, it's struggling to distinguish between table and chair sometimes. So how come it is discriminating? So maybe it's not only technology who's imperfect, but also human beings who are not perfect in this respect. And we also can be biased and discriminatory from sometimes and don't really, maybe even we don't realize it. So it is very important question that we need some kind of a body which will oversight the technology. But I think it can be something similar as in human to human relationships. Just a brief comment.
Yes, that's a very good.
I do agree with you that it is not only the machinery which you said that would not be giving the whole effect, but we're also lacking in the few parts. But yes, I don't think that we should be afraid of the artificial intelligence or the advent of this, because maximum the things which is controlled by humans are also being regulated by the humans. So what is the need of the hour is that the more regulations should be there, not only in the country, individual country, but at the international level also, because data which is received by and perceived by the machinery, by the AI, that is from all over the world, not in specific field only. But yes, in law field specifically, when I just ponder upon the few of the streams of the laws, there can be a very regulated AI decisions, well-planned decisions in contracts and commercial laws. But when it goes to the family law and these kind of issues, I won't think that there must be much reliant on the AI decisions, because unless we develop the technology that they can think and rethink and design over it, but decision could not be that appropriate by the machines. The humans are having the emotions, machines are not. So that is what need to be care of, that all the which are there in legal field, the streams specifically, could not be dealt by AI. Thank you.
Saule, you looked at the issues of technology in a very different field in supply of electricity. Do you have any insights there? Are we ready for technological advancements, or are there any injustices that technology bring? What are the flaws there?
Yeah, thinking about technologies, I always think that these new technologies we are putting, we are looking for the place where we can find them a suitable place in the system, which was without these technologies. And if we could think, if we could forget something which we was learning all the time, and have a new look at technologies, maybe it could bring us not the evolution, but revolution in some things. So I think it would be useful not to put these new technologies in the constraint which we was learned early, but to find them some new insights. Of course, it's hard, it's very challenging, but this is the way I think one day the new technologies will emerge in all daily life. It's in all these fields, justice, market, and so on. So it would be my insight.
Yes, that's a very good point, that we have to leave the constraints of the past behind us and then look outside of the box. And I can see that we have questions from the audience, and Ines you've got a couple of questions from the audience. And the first one is by Dimitris Tselis, a lawyer from Greece, who congratulates all the speakers. And his question is, are there any statistics that about how effective the Canadian system is, and does the decision tree system fit the cause?
Mm-hmm. Okay, thank you very much. Maybe I can try to answer this quite a precise question briefly. So when we talk about the civil tribunal in Canada, we always have to think about two aspects. Because firstly, the tribunal provides legal information. It's a one thing. And another thing that they do, they solve disputes. So access to legal information or the use of this system, sometimes it's difficult to assess, and we need time to assess how many people use it, what's the effect, what is their user experience about this. I must say that the tribunal did a good job disseminating information, including social media. They were very much present in Twitter and explaining that, oh, now we have new functions. Come and see it yourself. It's a bit unusual for the court, because we don't really often see the courts, although they're trying to be more engaging, but to such extent that and then announcing what new features do they have. So if you have a look into the yearly report for the fiscal year from 2019 to 2020, so in 2017, 5,000 people visited the website. So it's when they firstly established themselves and used the Solution Explorer system. This is where the system informs the user about services and about law and what to proceed, also helps to negotiate. In 2019, 54,680 people used the system. So it's from 5,000 to 54,000 people who visited the system and tried to use it. So it's a little bit of statistics. It doesn't really help to understand whether the information was useful, in fact. But there is a clear increase from 5,000 to 54,000, so people at least use it or visit for their own purposes. What concerns the cases submitted to the tribunal and resolved in the tribunal, again, in 2017, they received 300 cases. And in the last period, in the last year, they received 5,800 and solved around 6,000 cases. So it is getting more popular, the services of the tribunal, and it's about to see how do people feel about it. There was a little survey somewhere in the middle of this period about how do people feel about the system, how lawyers as well feel about the system, because the system is self-service. It doesn't really require legal assistance there. So people are more or less happy. There's no statistic on that yet, but generally, when we rate the website, they were quite positively assessing the services. And I must say that lawyers were also very happy. They understood that maybe there will be a little decrease of number of people who are using legal services, but on the other hand, people were still approaching lawyers with more complicated questions. And so they don't come with a simple question, but if they want to double check whether they are following a good direction, whether the decisions proposed by the system is correct, so they sometimes visit a lawyer for this issue as well. So we can also see a little bit of dynamic here where the people trust the technology. If some portion of people feel like consulting still with a human being, whether the decision that they're going to take is correct indeed.
Also, Ines, you mentioned a bit, but perhaps you could follow up. There is a follow-up question asking of examples of legal awareness tools, and it's Kristina Vesbergaite asking. So
yes, thank you for the question. I see that the question is about whether we know any successful and proper examples of tools in legal awareness. I must say it's a very difficult question indeed. It looks simple, but it's difficult because we can only see sporadic examples of the use of such systems. Well, the main reason is that there's a very little research in this field on how people interact with the system and what system fits better. Yeah, so which one works better? And even less examples of implementation of such systems. So it looks that assessment right now is more on trial and error basis. What works, what doesn't work, what people react to, how people assess their experience and so on. And we need time to collect data about that and conduct more comprehensive research because still these systems are fairly modern and new. However, there are very clear dynamics in this field I can see. One is an integrated into justice system model. Canada is not one example here. There's also, I can think about example from Netherlands. I'm a bit afraid to pronunciate the name of the system because still it's Dutch, I'm not very strong in this. So it's Rechtwijzer kind of system, hopefully it's correct, which is also a website for online dispute resolution in the field of divorce, consumer protection, disputes with government. They also handle employment dismissal, debts, and so on, so such questions. So the website helps also citizens to diagnose their legal situation and whether to proceed further with the claim. There was a survey of how people feel about this platform, and the results show that the platform, or majority of the visitors of the website, rate the website positively, so that they're okay with what the services are. So this is the first dynamic, and I think it's quite useful when the system is integrated into the justice system. And the second field where we see more and more developments is the development of applications. So I didn't talk about it today, but there are a number of applications which are available on the market, which also help with legal information. What concerns the assessment, whether it's a good tool or not, we here stand on the same ground. It still requires some more research to identify which tool is better, but I don't think that it will be very different from what we have right now. Rather than we can build on the experience which is already in place and see what didn't work or where we can adjust a little bit the models used right now to improve the experience of our citizens.
Thank you very much, Nessa. And we have a question from Ignas on a very contentious issue, and it's addressed to all of the panelists. And what do you think about predictive justice? So big data assisted sentencing and parole decisions and predictive policing. Is this the future? So opinions of all the panelists are welcome. Edwin, would you like to share your thoughts on this to kick off the discussion on this matter?
Well, it's definitely the future that such technologies would support the decisions. As I mentioned previously, I still believe that there should be the impact and final decision of the judge or authorized body, because, you know, as they say with the markets, previous results do not necessarily correspond to the future, results, and it might help to, let's say, predict the final decision, but as we know, all those decisions are changed according to the facts, according to our understanding, and what was previously as the dogma, it might change in a few years. So I'm not sure if in the near future the technology would be so smart to actually think of new circumstances where this rule could be applied. So, yes, shortly, I would say this would be a help tool, but not as a final tool to take the decisions instead of the judges. Except maybe for small cases. We already see the implementation of AI technology in Revolut, for example, and this is one of those cases where if you have the issue with the payment or someone was stolen, so you can simply write in the chat box, and the system decides whether you're right or not, and might, let's say, pay you back the money even without the person being involved in this. So for those small administrative cases, for sure, people would use that. But for civil and criminal cases where we need more involvement of different evidences, I would not see this happening near soon.
Well, I think with all the technology, it might be very appealing to increase the use of them, because they can make everything seem easy and effective and cost effective, especially. But we need to be cautious about the social and legal injustices that those systems can create, and we might not notice, or it might take a long period of time until someone notices that these injustices have been created. Who would like to follow up?
If I may, Julia,
yes, sure, go on.
I totally agree with Edvinas. I'm in the same direction. I feel that they can be used, and they will be used as an auxiliary means, but they will, and I believe they should not replace human judges. The point that I would like to stress is the issue of the evolution of jurisprudence. If a computer or an algorithm is supposed to decide upon a matter, that means that the case law will be the same all over again and again and again. However, the circumstances change. Not only legal provisions change, but the circumstances of life change. So it is, in my opinion, the decision to replace a human judge through artificial intelligence means that practically our case law will be the same forever, which is totally unacceptable since our societies change. In that respect, I see a use of the system as an auxiliary means. Of course, there are many ethical issues and legal policy issues that one should also address in this field, as regards, for example, the policing story, the predictive policing story, where there are also more delicate issues that one should take into consideration. And to make a last point, I'm certain that in trivial, bagatelle things, as the Germans say, the use of artificial intelligence will be a fact very, very soon. For example, in the so-called payment orders, there is already some form of automation. And in that respect, the use of artificial intelligence is not only obvious, but may be needed. That said, I believe that we should focus more on analyzing the decisions than forecasting the decisions. Thank you.
Thank you for your insights.
Yes, I really do agree with Dr. Edwins and Dr. Kamenis. They have clarified the point very beautifully, that yes, the human brains could not be substituted by AI. Yes, that is there. But again, Dr. Kamenis, when in his presentation, he said about predictive justice, that when precedents are there, the state diseases are there, we do analyze on them, and then AI also take up that data and analyze the case on the basis of that. So that is what we can say, that facilitative justice can be taken or drawn up from that, but it cannot substitute the human brain. totally. So we need to have a balance between AI and the already existing system here. Thank you.
Thank you very much. It seems that we are all in agreement so far that humans will still be needed. So it's good news for all of us, and that we need to seek this delicate balance to ensure that we don't fall in any pitfalls using too much technology when it's not adequate for to be used. Inessa, any thoughts?
Well, I also absolutely agree with what have been said so far. Yes, it's difficult to imagine that artificial intelligence, at least at this point, can substitute human judge. And on top, we have legal also issues here, because if I can't recall right now the article, but we have a explicit prohibition from GDPR, from EU regulation on automated decision in the justice system. So there has to be a supervision, or there should be a final word by a human being. So from the legal point of view, at least right now, it's impossible to introduce an artificial intelligence which will judge on the issues. If just to think a bit on the future, in the future, there is a lot of discussions on whether we can implement, for example, a system where the artificial intelligence can be used as a judge of first instance, and then we can have a human being as an appeal system. So, for example, if we do not agree with the decision of the of artificial intelligence, we can appeal it to the human judge, which will take into account social developments, maybe, and maybe the necessity to change a little bit the practice, and not just render the decision based on existing cases. But it exists only on the level of the discussions right now, trying to think about the advantages and disadvantages of such system. But right now, I think it's difficult to imagine, also from the regulator point of view, that we will be going to this system. However, as it was already pointed out by Dr. Communist, that there are areas in judicial field which can be automated already, and which require less intervention from the judge.
Thank you. Saula, any thoughts?
It's, of course, I think it will be a big help for future development, but we always have to think about this human things, because all artificial intelligence cannot deal with emotions, and it's the most biggest issue. And how to compensate its interaction in judicial system, where to some extent this emotional part, which is inseparable from human being, can be compensated. I think it's the biggest question. So it would be my insight.
Well, thank you very much. I have one more quick question. I think everyone on this panel are lawyers or work in the legal field, legal academics. What are your thoughts? Are universities prepared to deal with the digital technology and issues that those technologies bring in respect to education? Are students being adequately prepared for this new technological era? Any thoughts on that?
I think that the students are the group which are the most prepared to deal with these new technologies, and as universities always tend to be more conservative, so I think it's a huge chance for universities to go forward and to be the leading group in these technologies, because the students really are wanting to try and are capable to deal with them.
Thank you, Saule.
Well, if I may, Julia, digitalization is a trend. If you check with the academic offices all over the world, there are brands and logos like digitality, blockchain, all over artificial intelligence. So everybody is of course, discussing the matters. So the universities hopefully are adapting. Interestingly, I think I should share with you the small revolution as regards digitalization caused by the COVID pandemic. There was the need to use technology in fields that we have never thought that it may be used before. And we see that in our everyday life, every day a new governmental website is being presented to deal with one specific problem caused by the COVID pandemic, not only on the sector of education, but in every sector of our lives. So they introduced measures to start new companies very, very easily online, as if this was not a need 1 year ago. Now you can create and establish a company very, very soon due to the pandemic. So in a nutshell, I feel that at least in Greece, as Sol said, we are a little conservative in adopting artificial intelligence in everyday programs. But the need is here. The students have great demands, and the pandemic is being used as a catalyst, and things are evolving very, very quickly. Thank you.
Thank you. Gurjinder, what is the situation in India? What are your thoughts?
Here also, the pandemic has taught all of us, along with the students, that we need to just go into this space more, because as the pandemic has closed all the universities, colleges, but now in India, at this point of time, like if I quote my example, my university is open. We go to university daily, and offline and online, all the streams have been going on. And students are much into this thing that now that all the persons who could not attend it offline, they can be online. So AI again is one of the advantage for them also and for us also. And I would just like to quote one thing here. All are here from the different countries, and I think that we much owe this to the pandemic and this digital technology advancement. Otherwise, it might have been there that if pandemic had not been there, we had not turned to this virtual mode otherwise. So I think this is going to be an advantage for all of us, and we'll be learning it.
Yes, indeed. Thank you very much. Edmund Sinessa, do you have any thoughts on that? Anything you want to share?
I can start here. Well, two things I want to say. Firstly, I absolutely agree that it's a trend right now. Although the pool of people which are interested in digital technologies and law still quite closed, it's not all the academics who are trying to understand what are the developments. I work in the university, and maybe I'm the only one who is interested in this topic. But well, we'll look at our presenters, experts who participate in this conference. So there are people who are interested, who are doing a very good job, and they're doing research, and will definitely bring this research into their home institutions. And they will share that there is a need maybe for a topic like this in the program, in the formal education of lawyers. Or I believe it will develop as a field in law, in fact, law and technology with time, which will embrace all the topics which relate to technology, and maybe even we will have to introduce a small technology and, for example, intellectual property rights, technology and contracts, and so on. Now, in every subject, there will be a module dedicated to technology and law. That's the one thing. Another idea is I also have a small topic on law and technology in my course. I teach to first-year students on computer-based legal research, which is basically should equip students with skills how to do research. But I thought that maybe also introduction into law and technologies is very important for students. So I see the reaction of students who are much better in technology than I am. They use all sort of social media, all sort of tools. They're very, very excited, and they are interested in what kind of opportunities there are. It also generates the great interest to law, that law is not as boring as maybe sometimes students think. It's, it has an action, and it's something connected with what they, how they conduct their life every day. Because, we were looking at the tools which can track your posts in social media and collect evidence for the court. So it was really thought-provoking for students. What do they post in those social media, and how this can be used afterwards for dispute resolution and so on. So I believe university will adapt to the development of technologies, and we will see more courses, more modules, and students themselves, they are quite interested in the subject matter. So this is also our future of future lawyers, future academics, and future researchers.
If I may add, thank you, Inessa. It's very interesting, and I totally agree on that. What I see that for us, a bit more maybe mature, we need to learn about technologies, whereas the students are already grown up with technologies. For them, it becomes natural. And my Christ daughter, she's still 13, but in some cases, I believe that she understands much more, and she says, well, let's do this and that. And that drives the force, and actually to change the understanding of the lawyer, that a lawyer is not only the one who needs to understand the law. And it was a huge trend that a lawyer should be a business partner, meaning that he or she needs to understand the business part. Now there is a new trend to understand the technology, and although in the next decade it will be a trend, yes, to have the lectures on that, but after that I believe it would be totally natural. What we at the moment learn, that the basics of the legal field, right, civil law, where it all starts. So it will become natural thing to speak about technology in this case, and the clients would definitely ask the lawyers to think about those questions. And as we evaluate the risks at the moment from pure legal thing, or maybe some business risk, the technological part would not have to be forgotten. And also not only to advise the clients, but also what we use in the law firms, what we use in universities. And we see more and more hacks of different databases. And even, if you have asked me a few years ago, is it okay to use Microsoft Exchange servers? I would say definitely. Microsoft is a well-known company. Now we hear about many hacks on that. So the question is, should we go to computer cloud-based systems? And then if we move to those systems, who have the access to that? So more and more questions would come from technological side, and what something used to be not so important, you have the password and that's okay, right? But now it's not enough, and those questions and responsibility for the lawyers, for universities, would come to that as well. So I would predict that we would have more professions, lawyer and security experts, lawyer and programmer, because a lot of those programs would have to involve the lawyers, not at the last stage. They would have to have in a team on the development, how to make a non-biased technology, how to make a legal technology which reflects all the requirements. And so the importance of the lawyer would grow as the technologies emerge. And I'm very happy about that. I see the bright future, especially for the students just go into that.
Great thoughts, Edney. I think, yes, technology literacy is important. And I think the younger generations will be more technologically literate than we perhaps are. And I thank all the speakers and also the audience for joining us this early morning and for engaging in discussion. I invite you all to remain with us throughout the day. And also I kindly remind the panelists that you are all cordially invited to the evening networking session, which will take place on MS Teams after the evening keynote address. So this will start, this networking session will start at approximately 7:15 in Eastern European time, which is 6:15 in Central European time or 5:15 in UK time. Bring a cup of coffee or a glass of your favorite fizz, and let's continue informal discussions tonight. And now there is 5 minutes till the first keynote of the day. So there is time to grab a coffee or a snack, and see you all in 4 minutes now at 11. Thank you.
Thank you very much. Bye-bye.
to our conference. Just to reintroduce myself to those who have recently joined in. My name is Ignas Kalpokas. I'm Associate Professor at Vytautas Magnus University. And this morning, it is my pleasure to introduce the first keynote speaker of the day, Professor Andreas Hepp. He is Professor of Media and Communications and head of the Center for Media, Communication and Information Research at the University of Bremen. And in addition to holding various visiting positions in internationally renowned institutions, he is also author of 12 monographs in total, including most recently the mediated construction of reality and deep mediatization, both of them greatly recommended by me and hopefully by my students as well. So, Professor Hepp, thank you very much for agreeing to join us, and the floor is yours.
Thank you very much. It's a pleasure for me to talk at that conference. I just start my screen sharing. Okay. Good. Thanks a lot for your introduction, and also thanks a lot for the invitation. Within my presentation, I want to speak about what we call deep mediatization and how it relates to questions of automation, automated media, or the term I will use across my talk, comRobots, communicative robots, as a concept we prefer to explain what's going on. An idea or relation, the idea for this concept is to put a stronger emphasis on the processes of automation that occur across the different kind of media. So, background of my presentation, as it was already said, is my latest book on deep mediatization, and here especially the chapters 3 and 4. However, I will go over the argumentation of that and put emphasis on some rather recent developments. The structure of my presentation is as follows. I will start with a short explanation of what deep mediatization means and why it is a help to put questions, as you were discussing in the panel before in a broader context of transformation. Then I will focus in the second part of my presentation more in detail on automation and what we call communicative robots, and then reflect on what this does mean for agency in a deeply mediatized world. Finally, I will come to a conclusion highlighting 3 core issues from my point of view. So let's start with the first part of the presentation. What means deep mediatization? Generally spoken, mediatization is a concept to think about how far the change of media and communications on the one hand relates to the change of media, of culture and society on the other hand. So this is a basic understanding of mediatization. When we go more into the detail, deep mediatization is a concept to grasp an advanced stage of mediatization in which more or less all elements of our social world are deeply related to digital media and their infrastructures. Just to give you an example, if you think about a financial market, we cannot understand what a financial market nowadays is without referring to digital media and their infrastructures, as many, if not most, of the financial products nowadays are calculated, negotiated, and so forth on the basis or by the help of digital media. Deep mediatization relates to in all 5 broader trends. One trend is what we can call differentiation of digital media. So originally there was the idea that digital media might mean that everything should merge to one kind of super medium, the computer. Something different happened. We nowadays have a lot of different media devices, however, which are all digital based. And this brings me to the second trend. This is the trend of connectivity, which means that all these different kinds of media and even things we in former times did not understand as media, like, for example, cars, smart cars, are increasingly interconnected by or through the infrastructures of the internet and mobile communications. An increasing omnipresence means that in more and more social situations, these media are present because of mobile communications. Paths of innovation, increasing paths of innovation means that the cycle of innovating these media increases. So all of us knows, having smartphones, after 3 years, we cannot use our smartphones anymore if we want to have the latest apps on them. And finally, there's a trend to an increasing datafication, a fundamental shift, because we don't use nowadays media, media anymore only for communication. In the moment of time when we communicate by the help of digital media, they are at the same time means of data generation. In the beginning, thinking about mediatization or media-related changes when it comes to digital media was much related to two concepts. One is the concept of the network. So it was the idea of the network society, for example, Manuel Castells. The other is the concept of assemblage, the idea that we must think about in a different way how human practice come together with technology. So something Latour especially pushed. Nick Coudry, me and others recently put against these two large concepts, the third one, referring back to the process sociology of Norbert Elias, and this is the concept of figuration. So from our point of view, it's a help to understand present changes with the concept of figuration, because it addresses problems we have with the concept of assemblage and network, but on the other hand also takes the advantage of a network thinking and a thinking of assemblage. So in short, the problem of the network is just to describe anything as a network, which results in the problem that very often the specificity of particular social structures is forgotten. The problem of the concept of assemblage is to understand everything as flat, the whole society as flat and not as structured. Thinking more in figurations is an interesting way of overcoming these problems. So basically, a figuration is a particular constellation of actors. Just think about a family, a group, a work environment, a company, and so on. These actors relate to each other by having particular roles, by realizing particular practices which are constitutive for these figurations. And nowadays, these practices are deeply entangled with digital media. So, for example, if you think about a group of friends, how you live friendship nowadays, how you organize your meetings with other friends, and so on and so on. This is deeply entangled with digital media by using apps for this, by using the mobile phone for this, and so forth. Furthermore, each figuration has a particular frame of relevance. And by this, we mean more or less the mindset of the people who are part of this figuration. So when you're within your family, of course, you're the same person as someone being in a group of friends or being in your work environment. However, in the moment of time, when you're at home and with your family, you behave in a different way because a different frame set is of importance for you. And here there's a fundamental difference, for example, to the concept of network, also to the concept of assemblage. It is an emphasis on the fact that the differences within the social world are made or built out of the meaning structure we as human beings construct and produce. From such a point of view, we can understand the changes with deep mediatization as a complex process of refiguration. So refiguration means the transformation of figurations. On the one hand, this is an internal perspective, and on the other hand, the interrelations of figurations. This is more an external perspective when it comes to a particular kind of figuration. Just easily, or in a nutshell spoken, our families, our companies, our circles of friends change, transform with the mediatization, and also the interrelations between all of them change. When we discuss more in detail the refiguration by deep mediatization, one can put emphasis on three crucial points. One point is in this external perspective that we have many new interrelations between these different figurations. So think about, for example, a platform like Airbnb. It relates very different figurations as a platform which is accessible across many different countries. Also, it produces data across very different figurations, accumulates this data in a particular way, and produces new kinds, or can be used to produce new kinds of meanings by the help of this. Second, we have the emergence of new figurations. We have figurations that emerge around particular kinds of platforms. So let's say, for example, the figuration of Uber drivers, which is constructed around a platform of Uber. And last point is the transformation of existing figurations. This is the example I started with. So how families, groups of friends, companies, and so on change in the process of deep mediatization. I cannot go into the details here, but my idea was to give you a broader understanding of what is going on, at least from the point of view of media sociology, to go more into the details of automated communication, or what we call communicative robots. So the point, the argument I want to make is, it is not really a help when we just focus on the chatbot, when we just focus on the platform of automated decision making. If we really want to grasp what's going on, we must contextualize this in that broader context of deep mediatization. So when we start, at least from the point of view from media and communications, one might pose the question if all is about bots. So this at least was one of the big discussions in media and communication research over the last 3 years. What you see here is a visualization of the different kinds of bots which should be active in the internet. If you go here into the detail, it's much more complex, because many of the so-called bots are just scripts to collect data, for example, for search engines. The point I want to make is that it's less just about talking about bots. It's much more about going more into the detail of automated communication and contextualizing automated communication further. Automated communication, as one might say, is or automation is a key aspect of digital media, as in the moment of time when digital media are based on algorithms, they are also at least partly designed to function automatically. This is the idea of an algorithm, and because of that, some scholars, like for example Napoli, push the argument to think about digital media as automated media. If we zoom into this, we realize that automation can be on a very low level, which is basically, technically spoken, just scripts. But it can be also on a much more complex level, which is machine learning, or AI as particular forms of machine learning. Just to give you some examples for this, we can start with social bots, which are somehow quasi actors on platforms. Social bots act open or hiddenly as actors on these different platforms. And interestingly, Gale and Barkatieva pushed an argument which we should not forget, and this is the argument that bots work only, or these kinds of social bots on platforms like Facebook, Twitter, and so on, can only work because these platforms already structured human communication and human behavior on a level that it is possible that some technical tool can act like a human actor would be. So the point is here already about we cannot understand social bots really if we just focus on the social bots. We must reflect social bots in the context of the platforms they act on and how these platforms already structure human practice. From the point of view of technology, social bots can be very easy scripts which just scrap data from other interactions of humans and present them as a new form of communication. But of course, they can be also much more complex phenomena. Another example are what we call workbots, which is about the entanglement with journalistic practice. So workbots are more or less particular platforms which automatically produce stories within journalism. Very often they are called robot journalism. It is about an automated observation of what's going on in society, a production of particular kinds of contents, and its distribution. Again, we can have a more detailed look on the technology behind, and very often the technology behind is to use data from particular databases, very often public or open databases, and then scripts algorithms which present stories or information alongside or on the basis of this kind of data. We all know in the times of pandemic, these kinds of automated story production. Think about all the different corona dashboards and the stories which are the short information which is produced around these different kinds of dashboard information. This is more or less automated content production. So not one journalist updates increasingly everything. It is produced automatically, and it's very easy to do this. So we have from the SAMKI, together with the Hans Bredow Institute in Hamburg, we also have one experimental platform for local journalism, which has one bot which just communicates the most recent data on corona. So this is the way how we find what we call workbots in the field of journalism. Furthermore, we have of course much more complicated systems like artificial companions. So you can think here about systems like Echo, Siri, and so on. They are thought, at least from the beginning, as an assistant in life with a language-based interface, which relates heavily to the infrastructure of the internet. The technology behind that is that data from the internet and digital traces is used to produce the information and the communication which goes via such systems to their users. These are just some few examples which, from my point of view, highlight that we are confronted here with a much more broader phenomenon, and which are a strong argument not only to focus on these single aspects of the phenomenon, but really try to get a more broader understanding of what's going on. And this is exactly where our concept of communicative robots, or comrobs, comes in. So what are comrobs? Comrobs are automated communication media. And the point here is really to talk about communication media. So it is less a question if the machine can think, It is much more a question if the machine can communicate. So think about the examples of the easy scripts I presented to you. That's not rocket technology. That's really low-level technology. However, it is a situation where it seems that a machine can communicate with humans. So the crucial point here is that ComROPS is something different than, let's say, AI in the sense of machine learning. It's a much broader phenomenon we have to have in mind. Basically, ComROPS are media in media. That means ComROPS typically act as media in or in relation to media. So like, for example, social bots on platforms, or like, for example, Siri, which is related to the infrastructure of the internet and the information which is accessible via this infrastructure, for example, on World Wide Web pages. ComROPS are also in that sense an overreaching phenomenon because it relates to important things. On a first level, we can argue that ComROPS are about automated communication. So this is how they appear to the user if the user realizes that it is a form of automated communication. But there's something else going on, and this is the automatic generation of data on the basis of this communicative act, which we can understand as some form of communicative automation. So thinking about ComROPS, as you already heard in the last panel, one crucial point is agency. And if we start thinking about ComROPS from the point of view of mediatisation research, and especially a figurational approach within that frame, the core argument is to say it is not really a help to think if the machine or if the script, if the ComROP might have an agency on its own. It is much more about reflecting these new forms of hybrid agency which emerge in figurations where such ComROPs come together with humans. In this sense, it is a help to contextualize ComROPs in the frame of extended agency theory. Extended agency theory is one approach or one way to think about agency, which is able to reflect agency beyond the individual. And very often, or very early, this kind of theorizing reflected technologically based systems, like, for example, Hansen did it in that piece from 2009, which I quote within that slide. If we follow the arguments of extended agent theory, there are two key points to highlight. So the first key point is the point of joint agency, which means to overcome dichotomous thinking or modeling, which reflects on the one hand human agency and on the other hand the agency of the machine. So that's not the point at all. Yeah? The point is to think about joint agency. So the question is how a new form of agency comes up, develops in these different kinds of figurations. And this, as a second point, brings us to a point to reflect concepts of responsibility or of intention in a different way. The point, for example, is not if a script has responsibility or if a ComROP has responsibility. The point is the question, which new forms of responsibility do we have in relation to such ComROPs? And here exactly, approach of figuration or figurational approach is a help, because we have a starting point to think about this kind of hybrid agency as a figurative agency. So it's an agency which develops within the figuration. And the point here is that process sociology, which was working with the figurational approach for many, many years now, was for a long time able to think about figurative agency. So for example, if you understand a company as a figuration, of course, a company has an agency of its own, which is more than just the sum of the agency of the individual actors being part of this figuration. So we already have a very strong tradition of thinking in which we can theorize also the new kind of agency which we have with comrades. So basically what you see here again is the figure I use to visualize a figuration. Basically, we have some kinds of specifics in such hybrid figurations, figurations which are built also by the help of comrades. First of all, we can say that the constitutive practices of such figurations are intertwined with automatically based technical systems. So think about all the examples we had in the panel before. It is not just about a point that systems make decisions on their own. No, it is about the point that humans together with systems do something. So this is the crucial point of entanglement here. Second point is that when it comes to the frames of relevance, and that is the sense making, there's a fundamental difference between comrades and humans. So while these systems are goal-oriented, they are not sense-making. So what we always can say is that the part of humans in such hybrid figurations is the production of sense. So what does it mean in the end? And finally, as I already put forward, we can think about such figurations as supra-individual actors. So a figuration as a whole builds a particular kind of actor. And of course, within this supra-individual actors and their agency, technologically based systems or comrades can be a part of this agency. So the point is not to think about comrades as something separated from human practice, but always something which is embedded in human practice, because otherwise it's just meaningless. It has no meaning at all. And it develops, therefore, its agency in such hybrid figurations of super-individual actors. This brings me to my conclusion, in which I want to highlight three core arguments. My first argument is that it's not technology alone that develops agency, but it is the hybrid figuration. So we should have our look, we should focus on these hybrid figurations and not as on technologies alone if we want to understand what's going on. It is the question of how do the figurations of law change, transform when such technologies become part of. It is not the focus on what is the automated decision making on its own. Or if we refer back to journalism as one widespread phenomenon, it is not about robot journalism which replaces people. Such a perspective falls short. It is more about how does journalism refigure when such work bots become part of the practices of journalists. Of course, it means a lot of changes in jobs, but I would say the loss of positions in journalism has another reason than comrades. Second core argument is that comrades play a role in the entire process of mediated communication. So they are part of the observation of society, they are part of the production of content, about the distribution and of the use. It's a very broad phenomenon, and we have to understand this phenomenon in its broadness. And from my point of view, empirically spoken, it is about describing these different forms of hybrid agency that emerge in the whole process of communication. The third argument I want to make is that we can say that journalism as law and as many other social domains are only one case within this broader process of transformation. And it's necessary to analyze the particular changes of this case as part of a more comprehensive refiguration of society due to deep mediatization. Thank you very much for giving me the opportunity to present here my thoughts, our thoughts. I stop now my screen sharing and look forward to your questions and comments. Thank you very much.
Thank you very much indeed. And I would invite everybody to ask questions. You can either use the raise hand tool on Zoom to indicate that you want to talk, or if you would prefer not to talk, you can type in your questions in the comments box, and I will read those questions aloud. Now, first of all, while everybody else is thinking, I have at least one question of my own. So first of all, your presentation has got me thinking how we as conference participants have been kind of reframed in this new situation through the functionalities of platforms like Zoom and everything. So to your mind, have the pandemic lockdowns deepened mediatization even further? And if so, once we emerge out of the pandemic, are we going to suffer from media fatigue and will look for more direct encounters, or will we be used to media so much that we will stay in this very deeply mediatized environment even further?
Okay, well, thanks. Yeah, from my perspective, mediatization relates in two senses to the pandemic. So the first thing is that we all experience the pandemic itself as a mediatized thing. So before the pandemic started, we had scripts in mind how the pandemic would go, because all the films we did watch even long before on Netflix or whatever. The pandemic itself was communicated to us all the time by the help of media, and especially by the help of data journalism. So it is a construction of data, which again and again is presented to us. It is very much about, and this is the third point, about collecting data. So very often the human practice in relation to the pandemic are explained and discussed by the help of automated generated data. So I just can take one example. In phases of the lockdown, questions of mobility are in the public discussed on the basis of the mobile phone data. So how often do people log in different regions of a country, and so on and so on. And the third point, the fourth point, and this is maybe from my in my perspective, the most important point when it comes to the results of the pandemic for the process of deep mediatization is the point of imagination. So we always, through the whole pandemic, imagined digital media and digital infrastructures as a help in the pandemic. Yeah? Think about, in the beginning, there was this discourse around the world about COVID-19 apps. So if we would program the right apps, we can handle the pandemic very easily. Google, Apple invested in, the European Union invested in, the German government invested in. Well, now we know it did not work. Yeah? The same thing as online commerce is imagined as a solution of the pandemic. We all should buy online, and of course we do if we don't have another opportunity. But for local enterprises, building up their own platforms and so on was thought as a way of how to solve the problems within the pandemic. Just two examples. We can continue with many other examples. The point I want to make is that the pandemic, from my point of view, pushed forward a Silicon Valley discourse we already had before. And this is the discourse that technology and media technology is the solution for many social problems. And from my point of view, the reason why the pandemic is a push of deep mediatization is not that we just meet here on Zoom. I'm quite sure if we could travel, most of us would prefer to meet in a physical place. This is not a point. This is not a push. The big push is a push on the level of imagination, that we all became much more related to a discourse that media technologies are a help of solving problems. Yeah? And this is a discourse, if it's spread across society, this makes a big change, because we then again and again in the future will have a look on the next latest media technologies to solve something. Yeah? A long answer for a short question, but background is that I just finished a German translation of deep mediatization. So this is what you can do during lockdown. You have more time for doing things like that. And this includes a longer introduction on reflecting deep mediatization and Corona.
Thank you very much. I think that was a really interesting answer. And I can see that Miglia Barikite has her hand raised. So please ask the question.
Hello, everyone. Can you hear me? Hi, and hi, Ignas. Long time no see.
Yep.
So thank you, Andreas, for your talk on hybrid figuration. I have a question that is a bit more like a conceptual question, I guess. When I listened to your talk, I couldn't stop thinking also about Donna Haraway and her thoughts on situated knowledge and hybrid agency that she kind of described already in the 80s. And I was wondering sort of how is your concept on hybrid figuration different or similar to Haraway's ideas on hybrid agency that for me sounds very sort of similar in terms of their kind of interconnectedness between humans and non-humans. Yeah, so perhaps you can reflect on that, would be interesting. Thanks.
Okay. Yeah, thanks. Well, first of all, I tried in my presentation to highlight that there's a longer tradition of discussing hybrid agency. So this is nothing new, I would say. Also in sociology of technology, there's a longer tradition. Of course, in a short presentation like that, you can only quote some of the authors. And the one I selected, I thought might be interested in that context because he quite deeply discusses also questions of responsibility. But now more specific to Haraway, I think the big difference is why I really estimate the work of Haraway. She has not really a theory of society and the transformation of society. Yeah? So this was never ever her interest. Also not on all her writings about a cyborg and so on and so on. And what at least my interest is, but also the interest, for example, of Nick Kudris and others I work together with, is more understanding media-related changes as a part of the transformation of society at all. And then a concept or an approach of figurational sociology is quite a help, because by that you have a kind of tool alongside which you can investigate very different social domains and compare the transformation which is taking place there by the help of this. So you have a set of categories, a set of concepts, which allow you to reflect in a comparative way what's going on. And we are in the process of doing this empirically. So at this moment of time, we have one research, it's called package, which is a crazy term, Paket, funded by the German Research Foundation, doing this now for the process of public communication. So where we focus on what we call pioneer journalism, which is about how the figuration of journalism itself transforms. Then we have one project which is about the figurations of journalism audience relationships, and furthermore then the figurations of the public, so how everything comes together with the practices of users. So you have the chance to investigate in a much broader scope which kind of transformation goes on. And this is my interest, and I think there figurational sociology has a lot to say, because the crucial point of figurational sociology is it doesn't think in entities, it thinks in processes, so everything is a process. Yeah. And it is quite easily to integrate questions of technology because they were very early a part of. So if you look back, many thinkings, for example, of Latour was originally inspired by process sociology. But the strength of process sociology, from my point of view, is that it remained with questions of power. So they are interested in, or process sociology is interested in, what all this all means for power within society. And there again, you have a very good, a very strong concept, which I did not discuss today, because it would have been too much. But this is the concept of power balance. So the idea is that you have in and across each figuration balances of power. And balances of power means that power always goes from at least two sides. Yeah? So if you have a director, you have to have people who follow the director. Yeah? So you have a particular kind of balance of power. And if you relate this back to Comrobs, the crucial question is how do balances of power change in figurations, in hybrid figurations? So what kind of power is associated with the system, and what kind of power is associated with the human practices? And these are questions referring back to Haraway, where she just was not interested in, which is fine. So she pushed other things, and I think she was very important in her times. So especially with her argument on the cyborg. But it's a different kind of scope she had.
Thanks.
Okay, we also have a few questions, written ones. So first of all, Dimitrios is asking, journalists bear a responsibility for their work. Is there a standard on responsibility for the work that's done by bots?
Okay, this is exactly a question I think from perspective of hybrid agency, you must or should ask this question differently. The work done by bots is always done in hybrid figurations. So it is not just done on their own. They're always embedded in the work of editorial offices, for example, editorial work. And so the crucial question is, how is responsibility or joint responsibility organized within such editorial offices? And if you look on that question empirically, of course, there are in the practice of existing figurations, we can figure out various models of how to handle this hybrid agency. So one point is to make explicit what within this kind of coverage is produced by bots and what is produced by humans. This is a tendency we have now. The second thing is, if you look more in the internal work of data journalism, they build it up structures of how to handle this responsibility. For example, again, by scripts which communicate errors or possible errors to the journalists. So for example, very often these systems have embedded scripts that if one data item pushes up very much, that the related data journalist gets some information, there's something going on. Or if a script which scraps data breaks down for a particular kind of reason, again, the journalist gets a message to look. So the question here is really, these are from my point of view, very good examples for that kind of hybrid agency. And the crucial question for me is, how is responsibility organized in this hybrid situation? So this is how I would look on.
Okay, we also have another question by somebody who's referred to as a number. So the question they have is about the fate of old concepts in communication science and sociology. So for example, how should we change our idea of the public sphere?
Okay. Yeah, this brings me again to the general advantage of a process sociological approach. So it is deep enough rooted in classical sociology to build up bridges, but it's because of its process orientation, at least from my point of view, ahead compared to many classical concepts, because it introduces us to another thinking about society where social entities are not understood as separated from the individual, but always constituted in the coming togethers of different individuals. So process sociology does not make a separation of the individual and the society which is grouped around it, but understands everything from the beginning as a figuration. So the individual is constructed in figurations, but figurations at the same time are constructed by individuals. If you relate this now more in particular to the public sphere, I would say, of course, we should stay by concepts like the public sphere in the sense that they describe a particular space of communication which is accessible for people without a high level of barriers. However, or the interesting thing is that we again can understand public as a particular kind of figuration. And this brings us to a thinking, to say, okay, what is the actor constellation of a public? By which practices is a public constructed? How are these practices, for example, entangled with commonwealth? What is the thematic framing of a public? So how do we define public? Is it just about a political communication, or is it also about other kinds of communication and so further? So from my point of view, the advantage of this process sociology is that it introduces us to a thinking which makes us able to discuss quite different social phenomena in a way how we can relay their description to each other, and in a way which is very much oriented on questions of change and transformation. So for example, the point of process sociology is not to say that we always have change. Of course, we always have change. Tomorrow is always different than today. The crucial point is transformation. So when does change means transformation in the sense of structural change? So when does change mean that on a fundamental level, figurations are different? So The actor constellation is different, the practices are different, or the frames of relevance are different. And if we relate this back to the public, this is the crucial question. So the point is not the change of public in the sense that we will discuss something different tomorrow than we do today in the public. The crucial question is something else. And it's the question of the transformation of the public. Does the actor constellation change? Do the practices change? Does the entanglement with technology of these practices change? Do the frames of relevance change? So this is, it's very easy to relate this kind of thinking to established concepts of media and communications, but it gives them a different, how can I put it? A different orientation, a different push, and a different ability to investigate the latest forms of transformation. Hope this is a help.
Thank you very much for your answer. There's one more question by Auxa Balchitiene. And the question is, who should take the power and responsibility of deconstructing the imaginaries and visions embedded in every new technology?
I also read, I just not think to grasp the core point of this question. Okay, I tried by that way. I think questions of power are always, and responsibility are always related to processes of negotiation within society. So we always have power, we always have responsibility, but a crucial point is who has power against whom and who has responsibility for what. In this sense, the first level of analysis is to say that we all have the responsibility. But in the lines in between, I read, as a background of this question, an implicit question, what particular kind of responsibility does academics or do academics have? Am I right with that? Okay.
Okay.
And there my answer is, now really referring to a paper or chapter of a book I'm writing together with a colleague of mine, Wiebke Loosen, about pioneer journalism and our investigation of pioneer journalism as a figuration. And I think this is a very good example. If we use the concept of pioneer journalism to be able to criticize and not use the concept of innovation. Because the argument is to say pioneer journalists are people who are accepted by the field of going forward. And the crucial point we have about that is that very often what I introduce is nothing which survives. Is even maybe not even a new kind of technology, but nevertheless around them a discourse of continuous innovation is constructed within the field. And from my point of view, I would say the problem of us as an academic would be if we just would take concepts from the field one-to-one and do research on innovations in journalism. We just reproduce the concepts of the field. And by this, we do not open up a space of reflecting about the field critically. And for us, for example, an interesting or an important question is the point how far pioneer journalism results in the fact that particular discourses and concepts we know from which have the origins in Californian ideology spread across, let's say, all European newsrooms. And by that relate the idea of innovation of journalism to particular understandings of society, which we maybe, if we think about from a more critical point of view, or from the point of view of power, do not want to have. A society which addresses services to the individual, for example. Or a journalism which purpose is to deliver to the users. Is this the understanding of journalism we do want to have? Question mark. And we can only discuss questions like these if we are careful with the concepts we develop as academics. And at the same time, if we are sensitive to the concepts which are used in the field, in the sense that we reflect them, we ask ourselves, why do they use these or that concepts, and which purpose does this concept have? So this is the second level of answer I would have, which is of course rooted in critical media sociology, but this is what I stand for, and I'm happy to be.
Okay, perhaps the final question then would be from me, because I can't see any new questions. And it is going to be about limits, because it's the end of the talk anyway. So one of the things that just popped up in my news feed this morning was the story about a digital artwork selling for $60-something million at Christie's, and AI-generated artwork also exists, and again at Christie's it has sold for, I think, $500,000 or so. From a very different perspective, things like AI-powered sex bots or sex toys, at the very least, are also on the market. And these are both things that are usually considered to be kind of deeply human. So is there a limit to digital automation, or do you think we're going to kind of push those boundaries ever further?
Okay. I think both are good examples that they remain related to the humans. So sex, robots do the sex not with themselves, but humans use them to have sex, which has a long, long history. And why not use technology for that? I really don't see any point about that, in the sense that this would be something absolutely new. The same thing is AI-based art only gets the meaning by humans. And if it is sold for a high price, it is sold for the reason that it is a particular kind of communicative act which produces meaning. Coming together with humans, which means somebody who buys arts like that buys this kind of art in the knowledge of what kind of art it is, and in the knowledge how it relates to a discourse within society, reflecting the role of AI, of automation, and so on within society. So really the point I would like to make is systems like these, they are meaningless in the sense that they just don't have any sense beyond human practices, or they develop only their meaning when they come together with us as human beings, or when we as human beings are together with them. And so from my point of view, of course, comROPs and other forms of automation will spread across society, like, I don't know, social media have spread. But maybe not so much things will change as we expect. No automated system was able to predict COVID-19. And Google Trends we can use now looking backwards, reflecting about COVID-19, but forget the narration of Google and other companies that we can predict our future by the help of these technologies, or that these technologies even might rule our future. I really think these are myths coming from Silicon Valley, and we should remain critical against such myths and look on what's really going on. And here I come back to my argument. What's going on is that we have these new forms of hybrid agency, these new forms of hybrid figurations, and by this human agency, first of all, changes. And this can be for the good. We can make something good out of it. and it can be for the bad. We can make something bad out of it. And this is, for me, the crucial question we should think about.
Thank you very much. I think it was a really insightful talk and we benefited greatly from it. So thank you for agreeing to be part of this conference. It has been really a pleasure.
Thanks a lot. Thank you very much.
You're welcome. So next, we are going to move straight to panel number 2 because it's straight on 12 o'clock here, Eastern European time, or 11 Central European time, or different time wherever you are in the world. And this panel is dedicated to challenges of governance. And the first speaker in this panel is going to be Filip Biały, who's assistant professor at Kazimierz Wielki University in Bydgoszcz, Poland, and also visiting fellow at University of Cambridge, and I think he previously held a similar position at the London School of Economics and Political Science. So it is a pleasure to host you at our conference, and the floor is yours.
Well, thank you very much for the opportunity to speak today, and congratulations to you for being able to construct such an interesting agenda for this conference. Over the last couple of years, we have witnessed a broad discussion on the processes of implementing artificial intelligence and algorithms into decision-making in various spheres of our life, including politics. And in that debate, we have already moved from discussing abstract ethical ideas to formulating regulatory proposals and indeed implementing new laws that aim at harnessing technology. What I find missing in those debates is a very fundamental reflection on what is really at stake when we talk about the implications of artificial intelligence and algorithmization for democratic politics. I hope that by the end of my presentation, we will be able to better understand what are the values that are at risk as a consequence of replacing imperfect human decision-making with algorithmic tools that promise a much better effectiveness. So I would like to approach this issue from the perspective of political theory. Political theorists are interested in concepts that furnish our political imagination. And by analyzing meaning of those concepts and the way they are connected with each other, we hope to learn whether our understanding of political reality makes sense, or are there some crucial problems with the coherence of our views. Political theory is also about critical examination of the ends of our actions. So I think that here in particular, we talk about asking whether we are fully aware of these ends and whether those ends are compatible with our values. While concerned with concept and values, political theory has many different methods at its disposal, and the one that I would like to use today is called an intuition pump, and it comes from the toolbox of philosophy. An intuition pump, and the name was coined by a philosopher, Daniel Dennett, is a type of thought experiment that helps us focus on a particular aspect of the problem we want to consider. By presenting ourselves with some kind of dilemma or imagined situation, we are able to pump, as it were, our intuitions that we can next analyze in a more rational manner. Probably the most famous intuition pumps would be the trolley problem or John Searle's Chinese room, that is strictly related to the problem of artificial intelligence. An intuition pump that I would like to offer to help us think about the political implications of AI and algorithmization is a concept of predictive democracy. By predictive democracy, I mean something that we could call an ultimate form of algorithmic governance of politics. So let's imagine a society in which there is no need to vote in the elections because the preferences of citizens are known in advance by combining thousands of data points on each person. Imagine a society in which powerful algorithms are being used to make the most important decisions related to the allocation of government's resources. Imagine that these algorithms are no longer biased, but perfectly aligned with social values. As a consequence, people no longer have to rely on ineffective politicians to represent them and make decisions. There are no parliamentary quarrels, and there is no corruption that would derail the political process. The algorithms make sure that people's needs are addressed in the most effective manner. Now, these are not very far-fetched ideas that are present in some of the recent proposals in favor of algorithmic governance. I am taking them here to the extreme, but that is precisely what intuition pumps are for. So let's start pumping our intuitions. First, let's see what are the underlying assumptions of the idea of predictive democracy with regard to an understanding of the concept of politics. In principle, ideas of algorithmic governance or government by algorithm seem to be based on a very limited conception of politics. Politics is perceived as a mere tool of allocating goods or satisfying existing preferences. And to be sure, such an idea of politics has a long tradition. We find similar sentiment in the famous title of Harold Laswell's book, Politics: Who Gets What, When, and How. But confronted with such an understanding of politics, we should now ask what are the other roles democratic politics plays. I will limit myself here to 3 points. First, we will readily realize that politics is not just a mean to redistribute goods and thus satisfy existing preferences. It is also a way of expressing our current preferences, of negotiating them, and sometimes changing them. It means that politics is about preference formation. So those preferences are not always present before we enter political process. Second, democratic politics as a sphere of both contest and deliberation is not only about preference formation, but also about expressing support for political institutions. So the very fact that people engage into politics is a sign of the affirmation of democratic process and a source of legitimacy of the institutions. In predictive democracy, such an engagement would be considered obsolete, which in turn begs the question, what would be the source of legitimacy of that system of government? Third, participation in politics, but also having representation in it, is a source of the sense of agency and belonging. That in turn allows people to think about society not in just individualistic terms, but also in terms of community and common good. By pointing out those 3 dimensions, I wanted to show that algorithmization of political decision-making would result in a displacement of politics as we know it. It would not solve, but rather deepen the current crisis of legitimacy of political institutions. So, furthermore, we should also perceive the possibility of algorithmization against the backdrop of general competition of democracy with authoritarian modes of government. If Western states would focus just on effectiveness of decision-making, they would face questions whether we should adopt a more authoritarian political model, especially so when we remember that many democracies have recently proved to be less effective than China in tackling COVID-19 pandemic. And lastly, ideas of algorithm governance for democracy should be viewed in the broader ideological perspective. So they seem to be an expression of a neoliberal understanding of politics with elements of meritocracy and a libertarian idea of minimal state. So in conclusion, to finally answer my initial question, what is at stake when we talk about the consequences of AI and algorithmization for democratic politics? I have been trying to argue that it is the very idea of politics itself. I would say that today we are facing the following dilemma. Do we want to have a more effective decision-making process, hoping that by being able to better satisfy people's preferences, our political systems will be able to thrive? Or do we want a system that might not be as effective, but would instead give citizens a sense of belonging and agency, allow them to actively debate and change their preferences, and thus express the support for democratic institutions? Now, we will try to solve that dilemma, and by that we may discover that these are not the only two alternatives, and there may very well be a third way. Or we will discover that our current understanding of politics is flawed and unrealistic and needs to be redefined. But my hope is that at least we are now better positioned to understand what is the value of politics. Whether it is a value we should defend is yet another matter, the one that I am leaving to you to decide and maybe discuss it further during Q&A.
Okay, thank you very much for your presentation. And I didn't tell that before, and I apologize. But regarding the questions, first of all, we will have all our presenters speak, and then the floor will be open to everybody, either writing those questions in a comments box or raising your hands, and then having the opportunity to voice your questions live. Now, having said that, let us move to the second speaker of today, who's Irene Cousigou, and I'm immediately sorry for the absence of my knowledge of French pronunciation. She is senior lecturer at University of Aberdeen, and she is expert in public international law and cybersecurity law, and she's also had experience working in Paris, Heidelberg, Mannheim, Max Planck Institute. So hopefully we will get another insightful presentation today. So Irene, the floor is yours.
Thank you very much. Thank you for having invited me to this conference. I prepared a PowerPoint presentation I would like to share with you.
Please do that.
So can you see it?
Yes, everything's great.
Okay, great. So I will not talk too much about international cybersecurity today, but more about French law, and namely what France tried to do to limit the impact of false information or fake news on the electoral debates. So my title of the topic I will present to you today is the following: the empowerment of platform users against online disinformation, the French legislation on the fight against the manipulation of information. So I'm taking this French legislation as a case study to see what can be done, not only in France, but in many other countries to fight online disinformation. So first, a few words about the background. In 2017, during the last presidential campaign, emails from Macron's close collaborators were hacked. So Macron, as you know, is a French president, and at the time, he was one of the candidates for the post as a president of the French Republic. The Macron's leaks, as they were called, were included in many tweets and disseminated very quickly. And the aim of the Macron leaks was to impact on the reputation of Macron and therefore to prevent his election. As we all know, Macron was nevertheless elected, so the Macron leaks didn't have any negative impact on him. Nevertheless, once elected, Emmanuel Macron called for a new legislation addressing false information spread online with the purpose of influencing electoral behavior. So following this wish of the President Macron, the ordinary and organic laws of the 22nd of December 2018 against the manipulation of information were adopted. So the difference between ordinary and organic laws is that an ordinary law is a simple law, as you all know it, and an organic law is a law that is a bit more important in the hierarchy of norms in France. So an organic law is a law that deals with a constitutional provision. So the organic law simply incorporated the provisions of the ordinary law into what is related to the election of the French President of the Republic. So I will focus in this paper on the ordinary law, knowing that the organic law simply repeats what the ordinary law states in relation to the election of the French President of the Republic. Those laws were submitted to the Constitutional Council, that is Constitutional Supreme Court in France, that declared both laws compatible with the French Constitution, subject, however, to certain reservations related to their interpretation. Indeed, France is, of course, bound by the right to freedom of expression that has a constitutional value, and the French Constitutional Council tried to reconcile, on the one hand, the objective of the laws against the manipulation of information, that was to secure the honesty of elections, the honesty of the electoral debate, and therefore of elections. So there was a need to reconcile this objective on the one hand, and on the other hand, respect for the right to freedom of expression. The right to freedom of expression can be, of course, limited, but only if it is really necessary and if it is proportionate to the objective. So now I want to assess the different means set up by the law against the manipulation of information to fight this information online. First, this law, the ordinary law, I will focus on that now, created a judge sitting for urgent matters. It means a judge that can adopt provisional measures pending a trial. This judge may prescribe to online public communication services any measure to halt the dissemination of inaccurate or misleading allegations or imputations, or if you prefer, false information likely to alter the honesty of elections. So at first sight, it looks like this judge has important powers, but it's absolutely not true, because the interlocutory proceedings set up by the new law were and are limited in scope. Indeed, for the Constitutional Council, the new interlocutory proceedings can only relate to digital information whose falseness can be objectively demonstrated, whose incorrect or misleading nature is manifest, and which have an evident risk of altering the honesty of upcoming elections. Furthermore, the dissemination of that information must be deliberate, artificial or automated, and massively transmitting by an online communication service. Furthermore, the interlocutory proceedings are limited in time. Indeed, the judge for urgent matters can act only during the 3 months before general elections or referendums to which the new legislation applies. Furthermore, and more importantly, the judge for urgent matters has only 48 hours to rule. So considering this judge will only address the most serious cases of false information that has an obvious negative impact on electoral debates. So to conclude on this, the judge created by the new legislation, and I think any other judge in any other democracy, can have only limited powers to suspend or suppress digital content. And this is because, of course, of the necessity to respect the right to freedom of expression. Another means we can think of to fight against the dissemination of information online is to counter foreign media. that disseminates false information. In order to do this, the new French law gives new competences to the Superior Audiovisual Council, that is the French Broadcasting Regulatory Authority. And this authority is independent under French law and enjoys decisive powers. So the new ordinary law on the fight against the manipulation of information gave to the Security Council the power to suspend, interrupt, or prevent authorization to broadcast to radio or television services controlled by or under the influence of a foreign state. So again, we may think that this council was given important powers to counter the dissemination of online information by media controlled by foreign states, but it's not true because the Superior Audiovisual Council can act only against information that is incorrect or misleading and for which falseness can be objectively demonstrated. So only a few information can be targeted by the Superior Audiovisual Council. Furthermore, its intervention can be limited for political reasons. Indeed, we may imagine that this council, or I think any other independent authority of any other state, will be reluctant to act against audiovisual services controlled or influenced by a foreign state, because this may trigger a reaction from the foreign state against France or any other state to which the independent authority belongs. Finally, a last means set up by the new legislation was to give obligations for transparency to respect by online platforms. So there are two kinds of obligations for transparency. First, strict obligations for transparency to be implemented by online platforms during the 3 months before general elections or referendums. So here, online platforms must, for instance, provide their users with information about the identity of the natural or legal person who sponsors information of general interest presenting a link with an electoral campaign. So the aim for this transparency requirement is to give to the users of online platforms the possibility to assess the reliability of information, in particular of sponsored information. Furthermore, there are other information requirements that apply permanently, and online platforms do have margin of appreciation to implement those information requirements related to the transparency of information that may compromise the integrity of upcoming votes or disrupt public order. So first, online platforms must establish a reporting mechanism. So it means that users can report false information covered by the new law to online platforms. And then online platforms have a choice between several measures to increase transparency of information they store or disseminate. For instance, they can increase the transparency of algorithms. They can also increase the transparency of content from companies, press agencies, and audiovisual communication services. They can fight against accounts that massively propagate false information. So in other words, they can close those accounts. They can also support media and information literacy. However, here too, I think that the intervention of online platforms is limited for legal reasons. Indeed, under current French law and under current EU legislation, there is no obligation to monitor information transmitted or stored and to report information to public authorities or to take down information. Indeed, online platforms are not reliable for the content they transmit or store, and therefore they are not obliged to monitor the information they disseminate. More generally, I think that imposing on platforms an obligation to search for and to suppress false information may result in the suppression of harmless information, and this would be contrary to the right to freedom of expression. Therefore, ideally, the removal of illegitimate or unlawful digital information should be overseen by a judge. So I'm coming to my conclusion. So what is the solution to fight against the impact of online disinformation or fake news, in particular before important events in a democracy, such as elections? I think that online platforms should respect transparency requirements imposed by the French legislation I talked about, or they should have transparency requirements to respect in other states. Furthermore, I think that there is a need to better educate citizens for responsible use of mass media and social media. And this is exactly what the law against information manipulation did, because it strengthened media and information literacy in schools for children. So if those two solutions are followed, I think that citizens will be better equipped to critically discern misinformation online. So in other words, there is a need to prevent the impact of false information rather than to act a posteriori and to suppress this information, because then it's too late and it may also be contrary to the right to freedom of expression. So thank you very much for your attention, and I'm looking forward to your questions.
Thank you very much for the presentation. And now we move to our third speaker for today, who is Kim Barker from Open University in the United Kingdom. She's a senior lecturer there, and she's also a member of the Executive Committee of the British and Irish Law Education and Technology Association. So, Dr. Barker, please, the floor is yours.
Thank you. Just going to share my screen. Can you see the slides?
Yes.
Excellent. So thank you to the organisers. I think the presentation so far have been fascinating, and I'm going to hopefully add to that with a slightly contentious, controversial suggestion that we should think differently about how we regulate our digital overlords, and we should put more emphasis on trust in the regulatory mechanism, trust in the regulation that we're asking the government to introduce, but also a greater element of trust that all users should have with other users, and as part of that, trust in the way in which we're asking platforms to self-regulate and take on a greater regulatory burden. So when we talk about all of the online harms, all of the online content problems we've got, what we see quite contemporaneously is that we have something of a content crisis. We've got lots of concerns about lots of different issues online. We've got lots of reports of terror-related content, of hate speech, of online violence, of online abuse. There have been a number of reports just this week in the UK about violence against women and the impact that online hate and the trolling impact that has on those women and their lives. And we talk a lot about harm, and we talk a lot about consequences, and we talk a lot about regulation, and we talk a lot about what we want platforms to do. And there are lots of things that lots of governments and different regulatory bodies are also suggesting we should think about in terms of duties of care and in terms of what we want these platforms to do to make the online space a safer environment for everybody. The problem with that is nobody has so far been able to pin down exactly what responsibility is for the platforms. And the discussions we have seem to pinpoint specific things, like we want them to be better. We want platforms to be safer spaces. We want certain forms of content to be taken down really quickly. We want people to be able to enjoy these spaces as safe spaces and have all of these things. And it seems to me that what we're actually wanting is to have everything in a perfect world. And what's missing from that discussion is how we actually go about that. because it's not just about the platforms, it's not just about the technology, it's not just about the law, it's about enforcement, and it's also about the users, it's about the human aspect. And a lot of the problems that we get when we talk about regulation and digital safety and online safety come because there is this element of immediacy when we talk about the online sphere. What we want from platforms is a knee-jerk immediate reaction. We want them to control content, but at the same time, we want to maintain freedom of expression. So in the balance, what we don't talk about really is how we strike that balance and how we can deploy different mechanisms to make sure that the platforms and the internet broadly works for all of us. And so what's missing in the myriad of regulatory steps that we see are things that are a bit of a misnomer. So we've had platforms suggest self-regulatory mechanisms. There's been a lot said about the Facebook Oversight Board. There's a little bit starting to be said about Twitter's so-called Trust and Safety Council. And while both of those are from two of the biggest online platforms where some of the most prolific problems emerge, both of those so-called quasi-courts present different challenges because, to my cynical mind, they are not necessarily forms of self-governance, but actually what they are glorified PR exercises. They're designed to make us think that the platforms are doing something. And the choice of name, I think, is particularly fascinating with the Oversight Board and the Trust and Safety Council, because they form very different narratives to some of the narratives we're seeing from regulators, particularly in the UK, but also at a European level with duties of care and due diligence obligations being talked about in the Digital Services Act. Other places have done things differently. So there's a myriad of different regulatory steps that we're talking about, but actually, again, none of it really seems to be joined up in a particularly cohesive or holistic way. There are also lots of problems with some of the things that we tend to see happening as a good reaction, if I can put it like that, in terms of we get moderation involved. Some things are taken down because it breaches policy. The problem with the automated filtering systems is I don't think we can have full trust and confidence in them to do their job appropriately and not interfere with freedom of expression and the ability to say certain things. And so there is always a need for a human element of it. I don't think technology is there yet. Don't think we have full faith in it to allow things to work, to tackle some of the problems, but also to do it in a way that works in conjunction with the legislation and the regulatory obligations that we want these platforms to take on. So it's almost two extremes to the debate. On the one hand, we're overcomplicating it by talking about everything in different ways. And at the other end of the debate, we're oversimplifying it by just saying we want everything to be better and legislation is the magic bullet for that. I don't think legislation is the magic bullet for that. And I think if we look to instances in New Zealand and Australia where they've got different iterations of the eSafety Act and they're working on another, that suggests to us that actually what we don't need is this idea that we can have one piece of legislation and it will deal with all of digital regulation and there won't be any further problems. That is not the answer. So it can't be that there is just one piece of legislation and we leave it and we don't do anything else for 20 years. We've seen that by doing that, e-commerce directive and its liability model massively out of date and no longer works for the technology that we've got. So when we tackle the digital overlords and the content crisis that we're currently facing, there needs to be this constant process of doing things. Law is traditionally reactive, and in the context of online regulation and digital technologies, I don't think we've really been as proactive as we could be. But equally, in the UK, we've been talking about digital safety since 2016, 2017. We don't have legislation on it yet. At an EU level, we've been talking about it for 2-3 years, and it's not, excuse me, anticipated that legislation will be actually agreed upon and the wrangling will have finished at a European level until 2023 onwards. So all of these debates, whilst particularly timely and contentious now, are going to rumble on. And by the time the legislation is introduced, there are going to be bigger problems that legislation just simply does not address. So what can we actually do about it? Well, it's an interesting question because there are lots of things caught up in this bigger debate, right? We talk a lot about self-regulation, we talk a lot about what we should do. And the big problem, it seems to me, that's what's missing in all of the discussion about all of the regulation of all of the online platforms is an element of trust. We don't trust each other as individuals to do the right thing online. We don't trust each other in the way that we might offline. So lots of things happen online that you necessarily wouldn't do offline. You wouldn't necessarily be as abusive to people you don't know in the offline realm, if I can put it like that. And that poses different multifaceted regulatory paradigms and also different multifaceted regulatory expectations. The human element is the element missing in draft legislation and the draft legislative proposals. It tackles content to an extent, it tackles platform problem to an extent. What it doesn't do is actually address all of the human elements to it, right? So we think that we can go around and expect automated systems to address some of the problematic content, and it does, but there is still a human element to that. Do we trust those automated systems? No, because we still need a human oversight body at the end of it. And even where there is a human oversight element to any form of moderation, there is still then the ultimate, well, I disagree with that decision if content has been taken down, and so there is then a further route of appeal. And that is a good thing because we don't want to interfere with expression. But at the same time, if we had greater trust in the systems and greater trust in the legislation and greater trust in the regulators, then maybe the systems that we are expecting to do great things in terms of regulating content might handle the problems slightly differently and in a more feasible way. And I think part of the problem we have with the monitoring discussions about whether there should be a monitoring obligation or not is all about trust, right? So all of these platforms have huge amounts of information about us and what we do. But at the same time, do we really trust them with all of that information? Is the legislation that we're attempting to draft trying to do far too much by imposing a duty of care and codes of conduct and seeking to regulate content and imposing all sorts of different regulatory models? The one-size-fits-all approach, I don't think, is particularly helpful. And I think part of the real issue is that we're overlooking what it is we're expecting this legislation to do versus what the legislation should be actually capable of doing. I think we have a tendency when we talk about online content and online platforms and digital technologies to expect the law to solve the problem. And the law very rarely solves the problem. The law can only start the debate on things. It's not the be all and end all, because at the end of it, there is still something that needs enforcing, and there are still debates and questions and issues that need resolving outside of what the legal drafting can actually be capable of achieving. So maybe when we talk about different forms of regulation for online content, we need to think about what it is that the platforms want us to think versus what it is that we want the law to do to tackle the real issues. And when we look at some of the things they are doing to try and address some of the concerns that regulators have raised about them, Facebook Oversight Board, it suggests that there is some kind of element of oversight and legitimate control within Facebook. And I think given the way in which that oversight board has started to operate this year, additional concerns and questions are raised about that and its legitimate processes. What role does it have? Can it really hold Facebook to account in terms of what Facebook decides about content on its platform? The other question, of course, is Facebook's many, many different tangles in different platforms. It is a giant, and is one oversight board which itself funds really anything other than a glorified PR exercise? I would suggest not. And I would suggest that Facebook is trying to get us to trust it to do the right thing on its own platforms by representing itself through a mechanism that we can all recognize and respect. So it's calling itself an oversight board, but it's set up very similarly to a judicial body, even though it's self-funded by Facebook. Do we trust it because it's representative of a judicial body holding Facebook notionally to account? Similarly, Twitter, I think, wants us to trust it to deal with the content on its platform. It's making big steps to suggest that it's dealing with issues. But is it really? Calling its own in-house oversight group, Trust and Safety Council, again, is designed, I think, to make us think that we can trust it in terms of what it does with content. And then when we look at legislative mechanisms, they're doing similar things. They're replicating this message that there is somebody somewhere that cares about what happens online, and legislation can solve that. Different forms of regulation can solve that. So we have trust, we have care, we have oversight, we have suggestions that all of the platforms and all of the legislative discussions that are going on are all designed to make us trust in some way these platforms and that we can actually regulate. But when we think about trust, there is no element of trust in any of the draft legislative proposals. It's not something which has been talked about significantly. And when we talk about trust, what we really need to get to the heart of is, are we confident in the rules and regulations we anticipate can control these platforms? And are we confident that there is integrity in what they are doing internally with their own insight and oversight and control mechanisms? I think a bigger part of the discussion really needs to fall on aspects of trust. Do we trust them? Do we trust the regulators? Can we really trust that the law will do what we think the law can do or not? And I would suspect actually that the answer is no, because it's not just about the law and it's not just about the platforms. It's a broader social question of what we do and don't do online and what we are expecting to be able to do online. So it's a very contentious issue, but I think part of the regulatory paradigm we're trying to create is missing the element of trust. I don't think we've discussed it sufficiently, and I look forward to your questions and or provocations on it when we come to the Q&A. Thank you.
Thank you very much. And I think I'm going to also bring in one example that was just given in the chat box. So Kasparas Ruklis is giving an example of automated content regulation gone wrong. When in Latvia last week, Facebook took down a post by a famous Latvian poet who spoke about the Prime Minister of Latvia, Mr. Kariņš, and that was interpreted as a call to warfare or violence because Kariņš, the surname, means little fight or little war in Latvian. So probably the system interpreted it exactly like that. Now we're going to move to the fourth panelist today, and that is Ilona Posedushna from the Jagiellonian University in Krakow. And the floor is yours, Ilona.
Good afternoon to everyone. I'm honored to present some findings of my master's research on the military implementation of narrow AI and, above all, the new challenges it generates to the United States technological superiority. I will only highlight the numerous specific possibilities of military use of AI, as my esteemed colleagues will offer a deeper insight into this topic during the panel at 3 p.m. Instead, I'd like to draw attention to a different issue, the issue how to make this military use possible. The key use is not the various ways of applying AI into military operations. The key problem is building the talent pool of researchers and engineers as the prerequisite to AI applications and consequently to the strategic advances coming with them. As recently as 2016, the United States of America was an undeniable leader in long-standing artificial intelligence research. Currently, the US primacy continues, although the successes of the People's Republic of China have also been noted in recent years. In particular, in growing numbers of citations of Chinese researchers in leading journals and their increasing impact on the international scientific debate. First, I would like to talk about the quantity of a talent pool. Second, about American technological advantage and the role of talent quality. And third, how these challenges to American technological superiority relate to the military implementation of narrow AI. In the first part of my speech, to provide context, I'll present the results of an analysis of the research potential of the United States and China in recent years. Research talent is one of AI's key inputs, so we'll take a look at where US stands in terms of global AI talent pool and the foundation of its current advantages. For this purpose, I'd like to compare the quantity and quality of American and Chinese research talent pool based on the data from the Conference on Neural Information Processing Systems, one of the most prestigious conferences in the field of AI research. Despite the obvious limitations of this approach, for example, it is only one of the leading conferences, it also has a major advantage. The conference gathers the leading researchers that currently are the most active in the field. As we all know, publication in leading scientific journals like Machine Learning or Journal of Machine Learning Research is a demanding long process, which makes it more difficult to evaluate the dynamics of emerging talents in the field. NIPS has an average acceptance attendance rate of approximately 21% in recent years, which means that it is a competitive conference. The data obtained on this base show that in the group of scientists conducting the most allied AI research, about 60% are currently affiliated with US institutions. However, among the top 20% of AI researchers, every fourth person comes from China. Interestingly, more than half of these Chinese scientists are currently employed in American institutions, and about 32% remain in China. It means that Chinese-born researchers conduct a small portion of the most allied AI research, but a substantial portion, about a quarter, of top-tier AI research. The analysis of the NAPS attendance also showed that for now, Chinese-born researchers end up choosing the American direction. On the other hand, the change in technological ecosystem in China encourages many top-tier AI researchers to stay in the country. Over half of all top AI researchers are US immigrants or foreign nationals, and most of them are from China or India. It is certainly too early to draw far-reaching conclusions about migration trends, but recent moves by the US authorities, such as restrictions on the issues of visas for Chinese graduate students, may have negative impact on the potential for attracting researchers from China. Why is the talent pool so important? First, because it is one of the elements of the American technological domination in the world. Therefore, the next step in my talk will be to present the phenomenon of the American technological advantage. The US Department of Defense in its records refers to the period of US technological dominance in the world as offsets. Here, offsetting means balancing the potential strengths of the opponent with one's own technological advances. The first offset included the technology of nuclear weapons and intercontinental ballistic missiles. The second offset included the creation of stealth technology and precision-guided munitions. Offset strategies are examples of Cold War thinking, when Americans did not have to match Soviet military's man-for-man numerical advantage due to their technological advantage. The first attempts at Chinese strategic responses came with President Jiang Zemin's announcement in 1993 of the need to win local wars under high-tech conditions. Such a shift in Chinese military doctrine came after the USA demonstrated the devastating effectiveness of high-tech weaponry against a less advanced adversary. Today, one needs to confront the third offset based on AI. The principles of it were reflected in the 2018 US National Defense Strategy. The key elements of this strategy are autonomous learning system, or machines that can adapt to changing circumstances, and human-machine collaborations. The third offset is targeting several promising technology areas, including robotics and system autonomy, miniaturization, big data, and advanced manufacturing. As mentioned before, Chinese efforts to develop technology, modernize the armed force, and increase defense spending began in the 90s. These efforts come in various forms, most recently the form of AI implementation capabilities. Chinese planners aim to inject AI into every grid in their operational systems at all levels in order to exploit this strategic frontline technology and create a step increase in military capability. For years, scholars have been trying to answer the question, what determines the state of the armed force at the time? Presumably, they depend both on real material events and factors and on the subjective perception of reality by states. In this sense, both the American and Chinese beliefs in the possibilities of AI should foster the competition in this field. To put it simply, the more the Chinese believe AI, big data, human-machine hybrid intelligence will be the central features of the emerging economic and military technical revolutions, the more they will want to engage in these areas. This, in turn, could encourage the Americans to respond with the balancing efforts. However, the success of offset in the era is not only determined by scientific progress at US top technological universities, but relies on successful and broad implementation by all relevant branches of national military force. There is general consensus among researchers that right now the next big breakthrough in fundamental research seems less likely, which shifts the focus more towards applied research. Most importantly, we are probably still many decades from developing general AI, which refers to system capable of human-level intelligence across a broad range of tasks. Some experts, while acknowledging the revolutionary advances in narrow AI, argue that they will not lead to overall development of strong AI. Discussions on the future of artificial general intelligence remain at the core of the modern scientific debate. But for the time being, we come back to the main challenge of this talk, the talent pool. If we accept in the foreseeable future success in AI relies on application, then we can assume that today the strategic advantage may be gained not by the most innovative country, like the USA, where scholars will seek the AI of tomorrow, so-called next generation deep learning, but by the country where the AI of today will be implemented on a large scale in security, industry, or business. Such application requires two elements: the abundance of big data and the large pool of engineers capable of mass producing the algorithms, not necessarily highly paid Silicon Valley professionals, but skilled craftsmen. Therefore, an issue of the current AI capabilities that can already be implemented in the area of security is worthy of consideration. And in the last part of the presentation, I would like to consider how the aforementioned challenges to American technological superiority relate to the military implementation of narrow AI. Currently, AI research is underway in the fields of intelligence collection and analysis, logistics, cyber operations, information operations, command and control, and a variety of semi-autonomous and autonomous vehicles. Attempts are also being made to adapt technology used for peaceful aims, like in business, in military industry. But this research requires continuous systematic improvements and a lot of testing before their results can actually be used on the battlefield. In intelligence and surveillance, AI algorithms can act as identifiers for hostile activities among big data. An example of this is Project Maven, created in 2017, a plan for cooperation between the American DoD and technology giants such as Google, Microsoft, and Amazon. It is worth noting that the project raised ethical concerns regarding the dual-use dilemma. We believe that Google should not be in the business of war, employees of the corporation said in an open letter. Soon, the company decided to leave Project Maven. In the area of military logistics, the real potential of AI has not yet been determined. More advanced research is being conducted, for example, in the field of predictive aircraft maintenance. Research into the adaptation of commercial autonomous vehicles technology for military purposes is also a priority. The latest final report of the National Security Commission on AI was released in March this year. The work lasted for 2 years. And commissioners identified 4 main pillars of interest orienting their recommendation: leadership, talent, hardware, and innovation investment. It suggests a wake-up call we needed and paying more attention and resources to AI development and implementation. In fact, I share this report's author's conclusion in my analysis. This work warned the US military's technical advantage could be lost within the next decade without accelerated AI and emerging technology adoptions. Summing up, I would like to refer to the key challenge with which I started today: human talent. The US National Security Commission on AI concludes that talent deficit is the government's most conspicuous AI deficit and the single greatest inhibitor to fielding AI-enabled technologies for national security purposes. US needs to build entirely new talent pipelines from scratch. The digital age demands a digital corps. US needs to win the international talent competition by improving both STEM education and system for admitting and retiring highly skilled immigrants. Thank you.
Thank you very much for all of your papers. And now the floor is open to questions. And straight away, there were two questions asked by Ilona, our last presenter, to Philip, our first presenter. The first of those questions was, are there ways out of the crisis of liberal democracy through the implementation of emerging technologies? And the second question, does effectiveness versus participating dilemma only lead to techno-pessimistic solutions?
Well, thank you. I think that the questions are actually very closely related to each other. And I would like to be more optimistic in my answer, but unfortunately, maybe because I am mainly interested in this critical approach that political theory offers, I see rather problems with technology than the solutions. And if I may connect my answer with the two papers of Irene and Kim, because they were talking about issues of regulation, and that actually we need to move from thinking about the possibility that we are able to solve our problems just by regulating technology, and we should take into consideration things like education and trust. And I agree that these are tools for improving our situation. And the optimistic answer to the two questions would be, we can maybe perceive technology in a more optimistic way as long as we have social trust and ability to educate the public. So I agree with those two answers. But my general sense is that we have problem with both of those things, with both trust and both our educational systems. And again, those values or those things are closely related to each other. The trust to our political institutions is in Western democracies at a very low point, maybe at the very lowest point in the recent history. And I'm afraid that there is no easy way out, no easy way to build that trust. And I don't think that, on the other hand, our educational systems are capable of improving the situation. So I would very much like to offer a more optimistic answer, but for now I am very concerned that we, not only as a society at large, but also as a people who are actually engaged in understanding what is going on, we are still very far from making sense of the situation to ourselves. So I think that what we as researchers can offer in that situation is to improve our own understanding of the very complicated, very complex interrelation of technology and society, of those ideas of individuality, of agency, and so on, and only then we will be positioned to address all those issues. So that would be, I think, my general answer, and I'm again very sorry that it is not very optimistic.
Okay, thank you very much for the answer. Now, I don't see any pre-written questions, so my next question would be probably to both Dr. Kuzegu and Dr. Barker. And the question is, how much leeway, in your view, do national governments have when negotiating with online platforms regarding regulation and other matters? And what do you think is the takeaway from the recent Australian experience? So maybe in order of presentation, Irene, could you be the first to answer?
Yes, thank you for your question. I did not hear the end of the question because you were cut, so I don't know if it was because of me or if it was a general issue. So could you please repeat your question?
Yes, so how much leeway in your view do national governments have when negotiating with online platforms? And what is the takeaway from the recent Australian experience with Facebook?
I mean, it's a difficult question. I mean, normally, of course, states should have a leeway because states are supposed to be sovereign. I mean, so I'm coming back to my background, that is public international law and not only French law. So under public international law, states are sovereign, and therefore they should be able to regulate online platforms. However, what we see now is that practically states are not as sovereign as they would like to be. So theoretically, they argue they are sovereign, they are able to regulate platforms, they are able to regulate cyberspace, but theoretically, it's not true. So theoretically, they should have as much leeway as they would like, but practically they don't because of the practical power of online platforms. So online platforms are more powerful than many states. So it's why there is a need to cooperate, not because states particularly want to, but they need to cooperate with online platforms, so to regulate cyberspace, in particular the dissemination of information. So I'm a bit pessimistic. I don't think they have actually practically a lot of leeway, although they don't want to acknowledge it. So we are probably transforming public international law and the international system in its entirety. So I don't know where it will go, but it looks like states are not practically sovereign anymore. And international law needs to change and need to take this into consideration. So there is a necessity for cooperation with online platforms. Now, of course, I'm coming back to what Kim said. Is it possible to trust online platforms? So is it possible to cooperate with private entities that are not necessarily driven by public interest, but by commercial interest? I think we have to, actually, we have to trust them because we don't have for the moment any other choice. So, yeah.
And Kim, what's your take on that?
Yeah, so I think it's a fascinating question. I think in a perfect world, governments would be able to dictate to the platforms and they would say, you know, this is our sovereign territory, this is the law, if you operate here, you have to comply with the law, and if you don't, there will be consequences. But I think Irene's point is incredibly valid. I think it's all about power, and I think at the minute, the power lies very much in the hands of the corporate entities, and I think it's been allowed to go too far in that direction. I think for whatever reason, there's been acquiescence or a kind of resigned acceptance that platforms are dominant, but their time will pass and something else will become dominant instead of platforms. So at the minute, I think if we want to actually tackle it, cooperation is the only option that we have, because we need the platforms on board to actually do some of the things which are more soft law than full enforcement regulation. But at the same time, there needs to be something behind that. So if they're not willing to comply, there needs to be the kind of the big stick to beat them with. And I think we see with the Australian example with Facebook that actually when a platform is pushed and its revenue stream is kind of put at risk, they are willing to almost come back to the negotiating table because their corporate interest is so significant and their financial resources are so important to them as an entity that actually they are willing not necessarily to give in, but to bend a little bit. And I think that might be the start of an interesting shift in the power dynamic. I think the Australian example is one, but I think also instances where Google have had to modify their operations somewhat are also quite fascinating for the future of regulating platforms generally.
Thank you very much. Since nobody else seems to be asking anything, I will continue my own interrogation. So my next question is to Ilona. And so in your mind, what is your take on the recent report by American tech leaders recommending the Biden administration to embrace autonomous weapons systems? And also, why do you think it has proved so controversial? And should it have been so controversial?
Thank you for your question. Of course, it is controversial because it is a question of ethical guidance and use of it in different fields. And in particular, we are talking about security field. There are many researchers that have done their research on these questions, but my insight is that we are just not ready, and we have not enough time to implement our real research possibilities to use all these features, and it could be also really it could be really problematic for society to accept those guidelines.
Thank you very much. Anybody else? Right, okay. Maybe I will still have to dictate the show. And my next question then will be to Philip. So one of the areas where reliance on data and algorithm have been really both expected and in some cases lauded is the response to the coronavirus pandemic. So, for example, our government here in Lithuania is priding itself on always relying on data scientists and so on, and algorithms to kind of negotiate the pandemic environment. What do you think are the benefits or drawbacks of predictive algorithmic governance in the context of the
well, thank you. I think that there are certainly areas of our social life or of our economic life where those tools of algorithmic governance have a proper place. So I think that the response to COVID pandemic is one such place that we can really take advantage of those tools. So I'm not maybe worried with those things that work well. I'm more worried about the places in our society, the problems that are tackled with the use of those tools that society is not aware of. And politics is certainly such one area that we don't exactly know what is the extent those tools are being used. So I think that those ideas that I previously mentioned, for example, a concept of effectiveness that is like built into the technology itself, can very well translate into a very positive use of the technology to tackle particular issues. And I have no doubt that that is the case with relation to the pandemic. My worry is about politics, about the activity that has been traditionally perceived as something that needs our agency, needs our presence and participation. And I don't feel that we have knowledge or control as societies over the extent to which the tools are being used in the decision making. So in general, I think that if we will know what are those uses, what are the issues that we tackle with the use of algorithm governance tools, it will be fine, will be okay. But we need to be able to understand them, and we need to be able to educate society and to ensure that society will trust to have trust not only to those tools, but also to people who implement them and to people who try to, in a way, supervise those tools.
Thank you very much. I would like to once again urge and encourage other people to ask questions, because I could be asking questions all day if we had time for that, but maybe you will get tired hearing only my voice all the time. Anyway, I had originally written my next question under Kim's paper, but I think both Kim and Irene would be really competent to answer it. So my observation as a media scholar is that we are increasingly moving from screens as interfaces to virtual reality environments as ways of interacting with the digital world, and platforms such as Fortnite are becoming extremely popular, and there's increasing talk of the so-called metaverse, and so the VR environment is really primed to be this next big thing. And in your opinion, is that bringing new regulatory challenges, or are we dealing with more of the same just on steroids? Maybe Kim, you could start.
Yeah, thank you again for the question. I think it's a really interesting one. So my default position is it's not a new challenge, it's just a new medium. It's a new way of doing what we're doing, and the issues that we are experiencing will persist, albeit perpetuated in a slightly different virtual form. So my hope would be that the regulatory debates we're having now at a European level and a domestic level would address that and have some element of foresight, so that we're not in this situation again a decade from now where we're tackling the big questions. But I think the reality is we're not yet in a place where we can think about regulation that would work for different forms of virtual interaction. And I think we're still very obsessed, and I think obsessed is the word, with content rather than form. And there is a reason for that, because that's the issue that's the most dominant at the minute. But in a realistic world, that debate will shift, and it won't just be content that's a problem. Form and content will become a problem in virtual reality environments. So I would like to think that there is a more holistic approach to regulation. And I think if we are forward-looking, then we need to build that in so that there's some element of future-proofing, because we can't constantly go through a period of 20 years with a static piece of law and 7 years of debate and then 4 years of legal negotiation, because by the time we get to the point where law is on the books, it's completely out of date and doesn't work anymore. So again, a fairly pessimistic answer. In a perfect world, we deal with it appropriately now, but I think more of the same in terms of regulation, and virtual interfaces are the way forward. But whether or not we're equipped to regulate them appropriately at the minute, I think probably not. And I think for the imminent future also, probably not.
Thank you very much. Irene?
Yes, thank you very much for your question. I think it's a new challenge, actually. So what we are doing now is to implement tools we already know, but this implementation does not work. So for instance, ideally, suppressing content online should be overseen by an independent authority, so by a judge. However, given the amount of content online, it's not possible for several human beings to oversee everything that can be seen online. So it's impossible. So we're applying a technical tool that is well known to information that are disseminated at a very, very high level that we did not know before. So yes, there is a challenge not concerning the tools, but more the implementations. So maybe we should then change the tools, because obviously they are not appropriate. And it's why we should delegate what states were doing traditionally, maybe ensuring freedom of expression to online platforms. So there's a need to delegate state powers to online platforms because they would have the tools and the power to implement those tools, what states can do with their own public organs. So it's why, yeah, we have to cooperate with online platforms.
Thank you. Since I can't see any forthcoming questions, and because probably you are already tired of hearing me, I would like to offer the floor to the presenters once again. If each of you could provide a very short 1-minute summary of what you both presented and what you've heard from other people, what to your mind are the main takeaways of this panel? Just 1 minute from each of you as a wrapper. So Philip, maybe let's go in the order of presentation.
Thank you. Well, I tend to think that really what is at stake is this issue of trust. And I would try to think about all those different problems that were discussed by all the panelists in this session and also in previous sessions, that we should have a much broader look at the processes of digitalization. So we should always have in mind that they are going on in a much broader environment, also ideological environment, also economic environment, in which there are problems with the trust to politicians, trust to institutions, but also with the trust to people to each other. So my main takeaway would be think to go beyond just those topics of digitalization and think about them in this broader concept that I hope political theory and me as a political theorist could help you with. So I could offer you some insights about the ideological background of those things. And I would be happy to learn from you about, for example, law or media perspective of those processes. And only in such a way, in such an interdisciplinary, I think we will be able to tackle those problems.
Thank you. Irene?
Okay, thank you. So I took this new legislation on the fight against the manipulation of information, in particular before important elections, as an example of what can be done in law to prevent the dissemination or to react to the dissemination of fake news. And the takeaway of my paper is that the law is actually a bit powerless to address the issue of fake news. So if we give powers to a judge or to another independent authority, these powers can only be limited, at least in democracies that must respect the right to freedom of expression. If we give to online platforms the power to suppress information, this may also impact on the right to freedom of expression. So the solution is not curative, it's not to suppress content, but to react before the dissemination of this content, or to limit the impact of that content. So it's why I focused on educating citizens so that they are aware of content that is not trustful. And of course, those citizens must be helped. And therefore, what online platforms can do is to be more transparent about the origin of the information. For instance, if information is sponsored, they should give the identity of the person who sponsored this information. So there is a need for more transparency, and there is a need also for educating citizens so that they can critically assess what they see. But the traditional tools, so the intervention of a judge or another independent authorities, a posteriori, once the information is online and is seen, do not work. This would be my takeaway.
Thank you. Kim.
So I think my key message is we need to think more carefully about all the aspects of what we're asking the law to do. And we need to think quite carefully about what we want the law to do and what we think the law is capable of doing. And I think we need to not think that just a piece of legislation is a solution, because it's not. I think the broader takeaways from the panel as a whole, we can learn a lot from different disciplines, asking the same questions and answering them in different ways. And I think the only way that we get a holistic solution to all of these societal problems, and they are social problems affecting all of society, is to do a bit more of holistic thinking and to not look into disciplinary lenses. In a perfect world, we don't have solutions, but I think we're just beginning to unpick some of the real issues. And it's important that we keep the debate going, because these issues aren't going away. And that's kind of my takeaway. We're not done yet. It's a work in progress.
Thank you. And Ilona.
Summing up, there are many challenges when it comes to implementing new technologies. First of all, the challenges related to the principles behind the production of algorithms and their use. And I would like to thank my previous speakers for these insights. As for my analysis, it falls within the discipline of international relations. And first of all, I would like to point out that the currently widely discussed military application of artificial intelligence have a common denominator. They are people, talents who will work on it. A state that is able to keep them will have better potential in the future.
Okay, thank you very much. Once again, it really and truly has been a joy moderating this panel. And I hope you stay on for subsequent discussions. I think we deserve a short break, and indeed we have time for that until the next panel, around 10 minutes. So panel number 3 will be on artificial intelligence and legal personality. So it's going to start at 1:30 here, Eastern European time, or 12:30 Central European time. So please do stay tuned in, and I hope we will have more insightful discussions. The next session will be chaired by my colleague Julia, whom you already met in panel 1. So let's meet at exactly the next half hour, so in 9 minutes time. Thank you.
Thank you.
everyone. I think it's past, so we shall start our next panel. Welcome to those who have joined us only now. I'm Julia Kalpokienė, a PhD researcher at Vytautas Magnus University Faculty of Law, and I'm a co-organizer of this conference. And the topic of this panel and this conference in general is of interest to me, as I myself in my research look at AI and what challenges it brings in terms of legal regulation. So we have 4 papers in this session, and we will first proceed with the presentations, and then so please be ready to share your slides if you intend to use any. After the presentations, the panelists will be able to kickstart the discussion, and then we will proceed with the audience questions if we have any, and I hope that we will. So the discussion will only start after all the panelists have presented. Just a quick reminder to those that have just joined us, the conference on Zoom is being recorded and is also being streamed on Vytautas Magnus University YouTube channel. I invite the audience to write their questions either in YouTube comments section or here in the Zoom chat. And we start this panel with a paper on an intriguing and a contentious issue. Are the existing conceptions of punishment applicable to artificial intelligence? I invite Professor Edita Gruodytė and Associate Professor Tomas Bergmanas from Vytautas Magnus University Faculty of Law to present this paper. The floor is yours.
Good afternoon for everyone. It's a pleasure to be here. Thank you, first of all, Julia and Ignas, perfect organization and also interesting speeches. Thank you for participants. And our topic today about consequences, because mostly the first part of the presentation was oriented to what's going on with AI. And our aim is to discuss if existing sanctions in criminal law are suitable for artificial intelligence. Of course, taking into account, do you also know, because Thomas is making presentation, but somehow it's difficult. Such aspects as subjectivity and actus rea and mens rea are not discussed in this presentation because they are rather well developed in scientific literature and of course because of time. And given the current socio-technological arrangements, we are not arguing that it is time to make artificial intelligence systems directly subject to criminal law. But in our opinion, it would be useful to discuss the matter further, taking into account technological development as such. And in this slide, you see 3 different examples in order to engage you thinking about criminal law and about criminal consequences, because in each case, consequences are such that if done by a human being, of course, criminal liability should be applied. And I just will say that the first example is the real case, and it was in the Switzerland, famous case, probably. Of course, this time it ended without punishment of anyone, because this was some certain project issue related with exhibition, and because of proportionality and the principle to know, at the end, Switzerland dropped criminal charges and released both to the owners as such. But those examples illustrate that we may have, and we will of course have problems, and we already have certain problems, for example, with self-driving cars, and that criminal liability is one of the issues we should discuss further. And the question arises if and what theories of punishment could be applied to artificial intelligence as such. And as we know from scientific literature, of course, there are many theories of punishment, and sometimes they are classified differently, but we took the view of Gabriel Holloway, which he took in discussing about theories to liability of AI, and there are 4 of them. As you see, retribution first as such, and usually the one which goal is causing certain suffering to the offender. So it's through emotional feelings and for evaluation of the past behavior of the criminal as such, and social legitimacy of revenge and some catharsis to society and victims. And knowing status of artificial intelligence at this stage of development, even though there are a lot of discussions about feelings as such, but still they are not developed at the moment, and this theory is not applicable, at least at the moment. The next theory is deterrence theory. It's related to prevention aspects, but still its prevention is through feelings, so through fear and intimidation of expected punishments. Focuses on mental intimidation as such of future behavior of the offender, and again, as it is grounded on feelings and artificial intelligence is not the one which has them as we imagine it should have in order to be punished using those theories, it is not applicable at the moment. And the last two theories, rehabilitation as such, already the word itself connotates what it means, but it's aimed to treat the internal root of the problems that led offender to delinquency and certain reasons or circumstances, which means that we should apply something for offender in order in future not to re-offend, but going to the roots of the crime. So for example, if it's artificial intelligence, so we may find out that some programming was wrong and that we may fix this machine. And the last theory is incapacitation one, which means physical prevention of the offender to commit the offense. And traditionally, usual punishment for human beings, it's imprisonment or capital punishment. Of course, in Europe, it's not already existing, but still in some states of United States and, for example, in China and in some other countries, you may find that such sanction is also used. And Thomas will tell you in the details if such sanctions are possible for artificial intelligence in the status as such. Thank you for your attention.
Okay, thank you. So I will take over. So, yes, two theories of punishment are considered to be more viable and possibly applicable in relation to artificial intelligence, so theory of incapacitation and theory of rehabilitation. As certain analyses are already done in this field, and in order not to repeat them, let me add just certain additional insights and thoughts, and mainly focusing to incapacitation theory. So first of all, on the possibility of, so to say, to completely finish with the AI as a matter of incapacitation. So in the field of human beings, that is analogous to the capital punishment. In the field of legal persons, that is analogous to complete closure or dissolution of legal entity. So we know that a capital penalty to physical person is a matter of his or her ultimate end and elimination from physical world. From religious point of view, we know only one human being who has possibly resurrected after his death. But from the scientific point of view, we know that human resurrection of this kind is not possible. So, however, the question is whether we could make the complete parallel with artificial intelligence in this place. How it could be this way, so to say, eliminated or dissolved or finished, especially having in mind that it could be, for example, maybe copied or illegally maybe, or recreated in the future, maybe even accidentally. Also, what about the possibility to retain the parts of the so-called of eliminated technology or killed technology, if we would say so, especially if they have certain socially important value? We know that we could not require from the physical person convicted with capital penalty to donate his or her body parts after his or her death. It is a matter of his or her autonomous decision. would we apply the same principle here or not? Especially from the utilitarian point of view, the parallel might be rather inadequate. In the case of human being, the approach to leave this decision solely to the convict is based on humanistic presumptions, especially related to human dignity. But however, in the case of AI, if those presumptions remain, and having in mind that AI is not a human being, maybe more utilitarian approach could be taken in this case. Now, speaking about partial incapacitation, in human world, it mainly functions as imprisonment or certain other forms of deprivation of liberty. So in the case of possible punishing of the AI of this kind, the vision of imprisonment as just deprivation of liberty of the offender is really oversimplified and requires clarification. First of all, imprisonment authentically is very spatial and physical, not mental one. It is related to certain real physical activities and entities like prison as building and human person and physical body. It never entailed the deprivation of the liberty or freedom to think, to rationalize. Good example here could be the extract from famous movie Shawshank Redemption, where incarcerated person was listening to Mozart in his head while in carcer, and then later commented that no one could take that liberty from you. Therefore, deprivation of the liberty of AI is really very different process. To call it imprisonment would be equal to very radical change of the concept, leading to conceptological mess. In some sense, as a matter of the deprivation of liberty, it is more the matter of deactivation, and it happens not so much in the field of physical activity, but more in the field of so to say, intelligent activities, which is very different matter from human persons' imprisonment, where vice versa, mental activities are even encouraged in the form of having the libraries inside prisons. And one more remark, what concerns the theory of incapacitation is related to international aspect. For example, what is the impact of the recognition of capital punishment or imprisonment of human being by other countries? Essentially, it does not matter at all, as the death of physical person or imprisonment is what happens in one place. However, in the case of AI, it may not necessarily be the case. For example, AI as technology may be implemented, exercised in different countries, jurisdictions. And if one of them decides to impose capital punishment or imprisonment to AI, the same, although not maybe identical AI, may still remain very much alive or free in another jurisdiction. Of course, here the matter of technology is important. How much every different AI will be really an individual being, how much it will be living in different jurisdictions as the same AI or the copy of AI, and so on and so on. Anyway, it shows that regional jurisdictional matter here may be important, and possibility to really impose incapacitated punishments to AI may require global jurisdictional conglomerations and agreements. And very final short point in relation to rehabilitation theory, not incapacitation of punishments. Rehabilitation is two-sided process. Societies take steps to rehabilitate a person, and also person rehabilitates or takes steps of his, her own will to rehabilitate himself or herself. So how we will be able to discern that the second side or step really happens in the case of the AI? Is there a possibility that AI's alleged ability to self-learn also covers the ability to rehabilitate in this context? Or is it not the case that it is still only the matter of changes, so to say, initiated by external factors, as, for example, programmers under the court's order? So to finish, all these are questions to be answered as we will develop AI and will be willing to foster this process, and that may require a certain very specific articulation of the place of AI in the realm of criminal law, and specifically punishments, and even up to the invention of very different new conceptual ideological framework. Thank you.
Thank you very much. That's a very interesting take. And I look forward to a discussion after all the presentations. And and I am invited researcher and a PhD researcher Orianda, both from Catholic University Leuven, Belgium. The floor is yours.
Oh. Hello, can you hear me?
Yes, we can hear you and we can see you.
Apologies, I had a little problem. Despite COVID times and we think of AI, sometimes technology is still not working quite well. I hope you can see the screen as well. We will be very short and concise in 12 minutes. So thank you for the kind invitation and the kind, very interesting conference on liability of AI. So as mentioned, we work at KU Leuven on, both of us work on legal ethical aspects of artificial intelligence and especially on questions of liability. Now, what will we discuss today? We will of course discuss several elements, but very shortly we will give a short overview, 1 minute presentation of the EU initiatives on liability, because liability is one of the most important pressing issues at EU level. As we mentioned, criminal liability, but also tort liability and product liability. I will then go to some pending issues and we will give some food for thought and hopefully some provocative statements that can lead to debate, because we are very different. We see different matters and we have different views on certain elements, which is quite normal in academic world. But me and Oria, we do not specifically share the same views. So I look forward to the discussion. So Oria will first start with the overview.
Thank you very much, Jan. So we know that liability for AI is a very pregnant source of concern in the legal world and legal sphere, I would say. And it's also a source of concern for a lot of policy stakeholders. And so at the EU level, you have a lot of different initiatives that have been launched on the AI liability implications of AI applications or AI-enabled devices, et cetera, et cetera. And it started in 2017 with the much famous now European Parliament report with recommendations on civil law rules for robots, which more specifically and famously considered granting legal personhood, electronic legal personhood to robots. Which we will be discussing afterwards, so it will be interesting to have a discussion on that as well. And the Commission also set up some expert groups on the Product Liability Directive and the New Technologies Formation. And in November 2019, a report on liability for artificial intelligence in emerging digital technologies was published and first identified a number of liability challenges with regards to AI and its associated application, and also proposed certain normative evolutions. You also have a number of policy documents, most specifically the white paper on AI and the associated report on safety and liability for AI applications that was published by the Commission in February 2020. And you also have most recently a European Parliament Jury Committee proposal on a civil liability framework for AI, which was published in October 2020, and for which also we have some strong opinions on, and that we hope we'll be able to discuss in the Q&A session afterwards. So some of the identified pending issues are directly in relation to the implementation of the Product Liability Directive. And that has been pinpointed in a lot of reports, a lot of studies. For instance, one of the main points of attention is, do we include software within the notion of product, of the Product Liability Directive? You know that Article 2 of the Product Liability Directive, which has been transposed into member states' law, applies to all movables plus electricity. And so it seems to entail that non-tangible items will not fall under the scope of the Product Liability regime. And in Belgium specifically, we refer to tangible items only within the legislative act. But we know that AI systems heavily rely on software, and so that question is highly relevant. And a differentiation may be done between embedded and non-embedded software. For instance, embedded software, we refer to embedded software as software that would be put on a tangible, a physical medium This could be subject and could possibly fall under the product liability directive because it would be considered a product. But non-embedded software, which could be important, for example, in connected vehicles, over-the-air software updates, for example, would they be considered product? Is not that sure, and probably not. So one of the recommendations is that maybe we should include software explicitly within the realm of the product liability directive and amend the product liability directive. The second element of difficulty is the uncertain characterization of defect for AI-enabled products. Know that the Article 6 of the Product Liability Directive states that a product is defective when it does not provide the safety which a person is entitled to expect, taking into account all circumstances. And so this criterion is rather vague. It refers to the consumer expectation test. It gives a wide margin of appreciation to judges. And when we apply this to AI-enabled products or devices, we can legitimately ask ourselves what the safety expectations would be for AI systems. We don't have much experience. We don't have much, experience when it comes to these AI systems creating damages. So we would have to rely, for example, on different circumstances, such as the presentation of a product. This presentation of product is a circumstance that can allow us to assess the defectiveness of a product. And for instance, the manufacturer will probably pay great attention to this presentation of the product. So for instance, if the producer presents a product as being extremely safe, then this could increase the legitimate safety expectations of the public at large, and then therefore increase liability exposure. On the other hand, if the producer clearly indicates the possible risks of the product, then the safety expectations could be lower. And this could also mean that the uptake of this technology would be lower as well as a consequence. This all poses a lot of different difficulties for the victim. And also the victim will have a very difficult burden of proof. There are a lot of evidentiary issues with regards to proving the defect when AI-enabled product causes damages. The last element under the Product Liability Directive that poses a number of difficulties is that the victim may not, even if the victim is able to claim a basic claim on proving the defect, proving that it is a product, the producer may shield itself against liability by invoking certain defenses, such as the state-of-the-art defense or the later defect defense. And these two defenses would shield the manufacturer or producer, more specifically, against liability. For example, if we talk about the state-of-the-art defense, the producer is not liable if the defect was not discoverable at the time the product was put into circulation. And so we know that these are very complex technologies, and this could possibly be a successful defense for the manufacturer or the producer. Just a few also elements on the later defect defense. You know that this defense states that when the defect appeared after the product was put into circulation, then the producer may not be held liable. And we know that with AI-enabled or machine learning-enabled devices, products, these systems may evolve over time. They have dynamic features, specifically in runtime operation. And so the defects could appear afterwards. And so this could possibly be also a successful defense for the producer. You also have the questions of software updates. How would we qualify them under the Product Liability Directive? And that's something that has to be further assessed as well.
Okay, so Orion showed that the Product Liability Directive, which imposes liability upon the producers for defective products, causes challenges. This regime has been addressed and regulated at the EU level quite extensively, as you know. Now, what we see is actually when it comes to tort law and the liability of the operators, the fault-based liability, product liability, there is a big debate at the EU level. A lot of initiatives, we've seen this on the slides. The problem is that tort law and liability, contractual liability, but especially fault-based, negligence-based liability, the operator's liability remains national law. So even if the EU regime would adopt many proposals, still it relies on concepts like negligence, force majeure, undue reasonable care. But these concepts have to be interpreted in national law. This actually means that we have a tort law dilemma. So I call the tort law dilemma, which means that the concepts are proposed at the EU level, but ultimately it are the national judges that have to adapt them, apply them, and interpret them. So this actually creates a problem, and this is according to my view, and me and Orion, we disagree somehow on this, and we might have a discussion as well later with the participants. I think that the EU should not adopt EU legislation when it comes to tort and product liability, because it creates this tort law dilemma, and I think this is problematic. So either you can be very specific, and this is what we call, it's maybe better to have some targeted minimal changes, some targeted approaches. For example, the question, is product a software a product, yes or no? This would be a very easy question via course. It could come via prejudicial procedure to the European Court of Justice to get an answer. So we do not want a whole regime on liability in AI, but more a targeted approach. My opinion, and me and Orion, we disagree somehow. We have interesting discussions, but we can have them later in the chat as well. Another one, and on this one we happily do agree, is that if the EU wants to intervene, I think there should be a specific attention to the burden of proof. Because you as a consumer, it might be well interesting to have a liability regime for operators or for producers or other parties, but eventually the question remains that it is a consumer that will have to show that the product was defective. It has a consumer that has to show that something did not work because it's problematic, that it incurred damage. Now, this is, of course, very difficult for consumers who are not experts in AI, who need access to these systems, who do not get the information because of the black box. So I think instead of adopting a whole legislative framework, I think the focus should more be on the burden of proof. Of course, there are already some national solutions, but again, I think there we should pay some attention to make sure, how do we compensate victims of AI-caused damage? This is the food for thought and debate that we could have. Brings us to the very short conclusion. There's been much attention on tort law and AI, as we have been showing. We do think that there's more legal research necessary on some essential concepts of the Product Liability Directive. No, the time of general frameworks is over. We need specific answers. When is a product defective? Is software a product, yes or no? Very concrete, useful answers. We also think that there should be benefits regarding the burden of proof. We need to find this proper allocation of the burden of proof. In 2021, hopefully, of course, COVID will be over very soon, but also we wait a lot for these regulatory initiatives and case law, which are expected to be adopted in 2021. I would also ask, and this is, I think, the perfect forum to do so, to think outside of the box. The legal personality, Orion mentioned it. So far, the consensus is we do not give it to AI systems. They do not legal personality, but I think that we cannot exclude this in the future. We should think about granting these systems, and this provocative statement, some rights and duties, as we do give to companies. Of course, I'm not talking about moral rights. I'm talking about like legal rights and duties to compensate the damage, to contract law. I think this is that we should maybe consider this. And then finally, I think the most important one is, we talk about AI. We work on AI, many of us, on a daily basis. But what you see is that like the general public does not follow in this story. I think data literacy is really a key issue, and eventually judges will have to, especially with tort law, which is so national bound. In Belgium, it's all about case law. Well, judges will have to determine whether the concept is defect. Will have to apply when an operator is fault, when a user did not apply reasonable care. But these also need to be trained somehow, need to be able to have the tools to make this decision. If you would like to have more information, I do a little final promotion. The book on the left has just been published by me and Cedric van Leenhoven, Artificial Intelligence and the Law. Contains about 19 chapters covering several legal domains affected by the law. And we would like to thank you, and we very much look forward to the discussion.
Thank you very much. You touched on very interesting issues, and I look forward to a very engaging discussion after the presentations. And I think data literacy that you mentioned is very important, and I'm happy that I'm not the only one saying that. I mentioned that in the first panel when we were discussing. So let's move on and continue with the researchers from KU Leuven. And I invited PhD researcher Mikita Petic to present the paper on new actors, privacy and security in AI-enabled 5G networks. The floor is yours. And no need to rush, so take your time.
Okay, you can hear me, I hope.
Yes, we can hear you.
Great. Thank you so much for inviting me, and I'm happy to present. I hope you can see the screen already.
Yes, we can see your PowerPoint.
Great, thank you. On new actors, privacy and security in AI-enabled 5G networks. Specifically, we're going to talk about legal challenges. So AI is a relatively new, and we can even say hyped technology nowadays. And the same can be said about 5G. So we're going to talk about two very popular and hyped technologies. And that's why, because they're going to impact our lives and they're very important. First, I need to highlight some important innovations in 5G networks, specifically that this is a very new, enormous ecosystem. It's not an old mobile network like 3G or 4G we knew before, but this is rather a new, complex system combining multiple elements, multiple vendors, actors, and companies which are going to take our data, ensure communication, and then what happens with this data? That's what we're going to discuss today. 5G is going to enable the collection of immense amounts of data. Why? Because 5G is going to rely on IoT devices, Internet of Things devices, to collect that data at a very large speed and then process it in a cloud-based computing resources, also employing edge computing technologies. In order to ensure the proper work and the high speed of such communication and also processing of these immense amounts of data, 5G is going to rely on virtualization. So to put it very easily, 5G is going to push the information more into the cloud, so more into the internet, where all of this information, all of this personal data is extremely vulnerable to all kinds of attacks. All kinds of adversaries, also subject to bugs and software failures. And this is a very particular security problem. Also, 5G relies on various relatively new technologies, such as edge computing, software-defined networking, network function virtualization. And what is important and interesting for us today is artificial intelligence and machine learning solutions, which are mostly used in order to optimize the functioning of the 5G network, but also for analytics and certain predictive technologies. How this functions, how this data basically moves in 5G networks, especially in AI elements. So from user, data is gathered by IoT devices, can be a mobile phone, can be a sensor, a camera, whatever, and then data is transferred via 5G mobile network to cloud computing facilities. So it is important to understand that 5G, as I said, is a huge ecosystem. So we might say that, okay, cloud computing facilities are also part of 5G. However, those are different actors present here. Usually when we are talking about mobile networks, we mean mobile operators. And that is true in this case. However, when we're talking about cloud computing facilities, not so many and hardly any mobile operators have their own large cloud computing facilities or cloud services. And that's where we have to rely on third parties, say Amazon, Google, Microsoft, Chinese operators like Alibaba Group, but it's subject to many, many constraints and many problems. And then this data from cloud computing storages is transferred probably almost instantly in a matter of milliseconds to an AI-based solution. So a piece of software which then analyzes this data, and in most cases personal data and like health or transport data, and then provides feedback after properly analyzing it, considering all the possibilities, and also, and this is a bit of a tricky question, using this data for machine learning, feeding on this personal data in order to upgrade its own algorithm and then apply it further. And this is subject to regulation, but so far we do not have a very clear picture on how this is going to happen. There are a lot of applications of artificial intelligence and machine learning in 5G networks, and some interesting ones are prediction of attacks and suspicious network activity, activity and anomaly monitoring, namely whenever some anomaly connections happen or anomaly spikes in exchange of data somewhere happens, virus and spam analysis, and then optimization for efficient concentration orchestration and optimization of the network as a whole, so data is transferred faster and at a more reliable, in a more reliable way, and then forecasting the usage of network resources. The last point is related to basically monitoring the activity of real people, of users, and predicting that, okay, maybe at night users are not going to use videos or mobile network resources that much, but then during the day there are certain spikes. In the morning we use networks more, while we're working we rely on these networks more, and then again in the evening probably a spike and then it falls down. And all of these points, they are related to monitoring user activity and again feeding on personal data, because suspicious network activity, well, that's the activity, human activity, user activity, even although they may use some hardware or software in order to attack someone, like hackers. And the same is related to virus and spam. AI will have to go through all of that information, go through basically messages and analyze them and see whether they are spam or whether this file is a virus, or maybe it's a piece of confidential communication. And that's where European Union law in our case applies. And we go from the, say, highest level, such as European Convention on Human Rights and Charter of Fundamental Rights of the European Union, which guarantee us things like privacy and confidentiality of our communications, privacy of our lives. And then we have more sector-specific pieces of legislation like European Electronic Communications Code, NIS Directive. Currently, we have e-privacy directive, which regulates the sector of electronic privacy specifically. But recently, we had a new proposal by the European Commission on e-privacy regulation. So we see developments in this field, and who knows, this year or maybe in coming years, we will see an introduction of a new piece of legislation which might change things in this relation. And then we have General Data Protection Regulation, GDPR, which is also quite famous and a bit of a cornerstone in this regard, since it serves us as a basic law, general law for privacy and data protection in the European Union. So how do we connect all of those points I described earlier about artificial intelligence, suspicious network activity, AI feeding on personal data, and some of the GDPR requirements? There are certain security and privacy challenges in 5G in general, not specifically related to AI, but definitely relevant for it. First of all, it's a major enabler for the IoT, Internet of Things, and we have various use cases, remote surgery, telemedicine, smart homes, etc. And this gives you an idea that a lot of sensitive data, like health data, will be transferred via 5G networks. So it is extremely important to protect it so that none of the adversaries can attack it and steal the data or cause a data breach. Secondly, 5G will enable to connect everything to the internet that can be connected. Now we have phones and watches and telephone, laptops, all of those traditional devices, but very soon we will have fridges and smart cars, smart fridges, smart electronics. So we will be surrounded by those IoT sensors and IoT devices. Even if you personally will not own such a device, maybe you will even refuse from owning a smartphone, other people around you will. And we will have this problem of omnipresence of IoT devices and the problem of privacy in this connected world, where despite maybe being a conscious objector to IoT sensors or wearables, still we're surrounded by cameras and devices which, whether we like it or not, are going to analyze us. And then we have reliance on cloud storages, vulnerable to attacks. We have stricter standards for handling and processing this data, since sensitive data is protected more under GDPR than say, usual personal data, but anyway, there is a strict regime for both. And then we have a problem of high precision geolocation in 5G. However, there are also challenges related specifically to the application of AI, which are connected to these general challenges, which are that large amounts of data is required to train AI models. If we want to have a reliable algorithm, a reliable piece of artificial service, then we have to feed a lot of personal data. Obviously, many AI solutions vendors think, okay, we can take 5G networks, there is a lot of data there, a lot of activity, we can feed on that. But then we have a lot of problems with consent. Are all of those people, do all of them give their consent to their data being used to train an AI algorithm, AI model? Most likely no. And then we obviously have a problem of security of such neural networks and AI services. They feed on large amounts of data, they feed on sensitive data, but are we sure that we can protect them? Because if they amass all of this data, they store it in, let's say, one point, then it's of course easier to attack this one point and take all of this data since it's going into one place. And as I mentioned, we have a problem with giving a valid consent, which is Article 6 of General Data Protection Regulation. Before we process any personal data, we have to obtain a valid consent, meaning willingly given through an affirmative action, as GDPR requires. And we have to take it obviously before such processing takes place, which in case of 5G network will be a bit problematic. This might prove to be a major problem in case of 5G and AI, because I simply turn on my phone or I walk outside and I'm already subject to a lot of sensors feeding on my data. And then it's obviously inability to obtain a valid consent by multiple data processing actors in the value chain, which is Article 7 GDPR. What does it mean? I give my consent to a mobile operator to take my data in order to ensure communication or a video call or possibly gaming, but I do not specifically give this consent to an AI vendor to use this data for other purposes than ensuring communication. And obtaining my consent for the purpose of optimizing network activity or improving reliability, that is too vague, because I end up giving up my data for some AI algorithm to a company I don't know about, and I don't know where it is located. Is it in Europe? Is it in the US? Is it in China, in Russia? Who am I going to sue in case something happens? Who is going to defend my rights? Then we have a major problem of privacy by design, which is Article 25 of General Data Protection Regulation, which requires to embed the privacy principles at the very architecture of any software or any business processes related to personal data processing. This means that including artificial intelligence developers, they have to think about protecting my privacy and my personal data while they are just planning the architecture of such algorithm. And I doubt that many vendors do that, even in the European Union. And obviously outside of it, there is a major conflict there. I mentioned the problem of jurisdiction already, and also the problem of applicable law, whether this AI solution provider is subject to EU law 100%, or if they're US-based, they are subject only to the US law, since they provide their service online, and this processing takes place, for example, on the server in the US or in other non-EU jurisdiction. And then obviously we have coordination, competing interests, and different privacy goals problem when different actors, mobile operators, AI solution providers, third-party application developers for 5G gaming or calls, all of them may have different privacy goals. They're not unified. They're not subject to a certain rule, one rule. They may be competing, and for example, a cloud service provider may be unwilling to provide the whole information about their structure to the mobile operator in order to protect their commercial secrets, obviously. And that's where we have a huge conflict, and we cannot ensure transparency, which is required by GDPR. It is also related.
Just a short, just to interject, we're still on your first slide. So if you're changing them, we can't see them.
Oh my God, you should have told me before. Well, this is, I don't even know how should I ensure this. Maybe. I will then jump to the last most important slide. Hope you can see it. Can
yes,
you
we can see it. Yes,
related?
we can see
Well,
it now.
that's what I was talking all this time, basically. Well, I hope you can see the points on the screen, which I mentioned, the articles and the problems. And I've mentioned the privacy and security architecture, one of the last points, and we have a problem with that since there is no single architecture we need to abide to. And then there is a problem of joint controllers and processors. GDPR requires us to basically explain and tell to our users who is a controller of data and who is a processor of data. So again, who is responsible, who is liable for any problems which might occur. And that's where we have a problem, since this data travels all the way via mobile operator to cloud service provider to AI solution vendor. And well, we are not sure how can we ensure that there is a appointed controller and appointed processor. And again, what is the liability of, for example, AI vendor in this case, or cloud service provider hosting an AI service, and how all of this is related to personal data, and how can we ensure the efficient protection. Thank you, and I'm very sorry for this confusion, but well, at least you can see this most important slide with the most important points now, and I'm very happy to answer any questions and any suggestions you might have, any ideas on this topic. Thank you.
Thank you. Thank you very much. And I can see that there is a discussion going on in the chat, but we will, I hope we will discuss it here as well. We were supposed to have one more presentation by Hiba Alessa, but I can't see, I think we don't have the presenter here with us. So it means that we will have more time for the discussion. So if Hiba connects, then we will proceed with the presentation, but at the moment we will start with the discussion. And I thank you for your very engaging presentations. And to kickstart the discussion, what are your thoughts on how shall we proceed with artificial intelligence regulation? And it's been touched upon in the presentations, and it is right. Is it right to seek how to apply existing laws and concepts to artificial intelligence? Or is it time to seek new paradigms and perhaps new suitable regulation that would be tailored to regulating AI? And also it could perhaps lead to discussion whether national laws should be applicable and are better suited to regulate AI-related issues, or do we need to look into regional instruments, or perhaps it's only if we have a global consensus that we can effectively regulate AI. And I believe there is no straightforward answer to this, if any, and but perhaps this may inspire discussion. And feel free to comment on your peers' presentations as well, and I invite to proceed in the order the papers were presented. So Edita and Thomas, you're welcome.
Okay, thank you for interesting question. Maybe I'll start the discussion and colleagues will join. So, of course, looking for example, from Lithuanian law perspective, and of course from criminal law perspective, because I am professor of criminal law. So criminal liability depends on subjectivity as such. And as the colleague asked us who presented the issues on product liability, it's clear that there are many problems at the moment. And of course, a lot of discussions are going on if artificial intelligence should be provided legal personality as such. And in case it's provided, no problem to give criminal liability for it. But at the moment, it's not possible. And of course, subjectivity is related with duties and obligations and certain criteria which artificial intelligence should reach. At the moment, it's going on that still it has not reached such stage of development in order to provide it. So such will be my answer in short.
I can catch up.
Yes.
So yeah, how to say, if we are thinking about liability of artificial intelligence, so ipso facto we have to think about then how to impose it, and then ipso facto we have to think about punishing artificial intelligence. But initially it sounds really very mad or insane idea to punish. How you can do it at all, to punish artificial intelligence. It's really very, very different matter, so to say. And we still, all those theories are very much based on essentially anthropocentric paradigm, that it's human focused, and even if we make parallels between legal juridical persons and artificial intelligence, still, you know, behind juridical persons we have human beings. And in that light, artificial intelligence is very different matter. It's like it might become autonomous, you know, and also its intelligence. It's if you think about certain like deactivations and incapacitations of artificial intelligence, we are not speaking about physical. Should speak not about physical processes, but more about this intelligent kind of mental processes. I don't know. So the idea is that I think really we have to think about some completely different conceptual framework if we want to really start to think about liability of AI, and then, you know, consequences of this liability as in the form of punishments, you know, or maybe no punishments at all. I don't know. So it's open terrain, so to say.
I think that definitely the question of legal personality is something we have to think about, and I know that many people disagree, but I think we should. And the comparison with the companies, yeah, it's the same. It's you protect people behind the companies. Why would you not protect people behind innovative AI systems? I mean, this is just the thought that I have. Why should we not consider to grant legal personality to have to allow innovation to create social welfare? Of course, there's many contras, and I'm quite aware of this, that it might create discrimination, that there are several other problems. I know this, but I think that the debate on legal personality, and by extension, for example, punishment of AI, is often emotional. It has to be legal and not emotional. If you look at it like legally, then there's several arguments. And if it would then be ethically and emotionally, well, I don't know, in the 60s, we had a Dred Scott's case in the United States where it was said that slaves are the property of the owner, but still it changes. So why, I think at one moment we may consider also legal personality for AI systems, because I think, I'm not a criminal law expert, but I'm a civil law expert, that the current existing liability frameworks are, with some slight modifications, are already sufficiently able to deal with the consequences of AI. I mean, we have the Belgian Civil Code. It was adopted in 1830. It's been like, it survived cars, it survived the industrial revolutions, it survived other technology, it survived blockchain. It will survive AI as well. But with there are some minor modifications necessary, but we do not need a whole new legal framework, I think.
To jump into the discussion, thank you for your very interesting insights. When it comes to how we regulate AI and what we regulate through AI, I slightly disagree. I still think we need well, when it comes to legal personality, I think that some of the current legal mechanisms, we still have legal categories to which we can attribute liability through some of the legal mechanisms. So I don't see at this moment, but I understand your arguments. But in my opinion, I don't see the added value of creating a new category, legal category for attributing liability. And when it comes to the liability regime itself, so I mentioned in one of the slides, you have a European proposal for a liability framework for AI, which sets, and I think we agree with Jan, that sets like a one-size-fits-all liability regime for all high-risk AI applications. And that's not relevant, I guess, in our opinion, because you have like sectoral specificities. Each sector has its own risk profile. Some sectors already have like relevant liability mechanisms. In my opinion, I still think we need a European approach, a sectoral one. For example, in autonomous vehicles, you have a lot of different regimes which change from one country to another. It can be fault-based, it can be strict-based. So no fault-based liability or compensation laws. I think we still need some kind of legal harmonization to allow the uptake of such technologies that may be beneficial to its users and to third parties, etc. Yes, that's what I wanted to mainly say on that. I think we still need a European approach. However, we can look into certain countries that have certain liability mechanisms that could be applicable to, for example, autonomous vehicles, for example. Strict-based mechanisms typically are, which do not require a victim to prove fault, are more or less apt in dealing with damages that involve autonomous vehicles. So we could inspire ourselves from these systems, which could potentially prospectively work. But I still think that we need legal harmonization to overcome this fragmentation at the EU level.
But if to add a little bit, we are still more thinking about that in the civil law, so to say, framework about liability. So our idea was more from the perspective of criminal law. It has very different rationale behind. We impose sanctions because of certain social, so to say, reasons. Whether it is applicable at all, or we just have to completely close that, so to say, sector in relation to artificial intelligence. So only civil law, only civil liability, and that's it, finished, or we can step into the domain of criminal law and punishing artificial intelligence for social purposes, so to say, to rehabilitate, to what are the other, to retribute.
May I ask you, I think it's interesting, how would you punish an AI system? I mean, I can see like how you would allocate liability, but you cannot, how would you punish it?
But that's what is articulated. Some scholars already tried to articulate that, how to do it. And if it sounds a bit fantastic, of course, but
yeah, but how? Out of interest, I just want to know, because I'm not a criminal lawyer, so I have no idea how like punishment for AI systems would work. So it's just out of interest, what do they suggest, these scholars, to punishment?
Legal persons are already punished, There are certain analogies with incapacitation theory perspective. Maybe Edita can add.
And if I could add, so in the Europe itself already, at least in theory, there is regulation that in certain cases, legal person without establishing faulty physical person could be punished and is punished. At least I saw evaluation of Greco and etc. institutions which say that dominates such models in Europe, at least in theory. And in Lithuania, for example, after enactments of new criminal procedure law, such possibility, of course, only in theory, is already here. So if we may punish legal person without establishment of faulty natural person, so also it could be situations when you may find that, for example, autonomous artificial intelligence made something and the whole discussion is going about the case when you can't establish guilty or fault from natural persons who are controlling or using or producing autonomous intelligence. And sometimes really looks like fantastical issue, but there are many scholars discussing the matter, what's and how. And this discussion started from the document about civil issues. the first one in your slide, which said that AI will be autonomous in certain cases and existing models don't cover it. So that's why. And maybe we didn't say at the beginning that our aim was to discuss the matter when we talk about autonomous AI, which is not the case, I think, in practice at the moment yet. Because user liability, the producer liability, etc., it's no problem. If we say that, we prove that they were negligent, for example, or intentional, let's say, created some autonomous AI for killing, for making crimes, etc., then they are as such liable. And the European position is that AI should be instrument in human hands, but we know that in China and US, they are dealing with different models. So that's the problem.
That's a very interesting view. And I think this may lead to another question. How do we, if we have certain rules, how do we motivate either the owners or developers of AI, or in case of autonomous AI, AI itself, to actually ensure compliance? And I think this criminal liability is an interesting, for AI, for autonomous AI, is an interesting concept, which perhaps could lead to ways to ensure compliance if AI knows of certain consequences that may arise in certain respects. But then I think that Mikita touched upon, and it was very interesting, cybersecurity issues. And what if someone tampers with artificial intelligence, and how quickly can we notice that it's been tampered with? And are we ready for artificial intelligence and fully autonomous artificial intelligence? Mikita, perhaps you could touch on the previous question and also on this one.
Yeah, thank you. I guess I have this question, and I also have a question from Dr. Kalpokas. I guess I will answer it a bit later. Regarding whether we are ready for AI, I would say we are never fully ready for any kind of technology, right? We take advantage of atomic energy. And I was born in a city which suffered from Chernobyl disaster. I was born in Kyiv, in Ukraine. So we might say, well, we were not ready for nuclear energy, for atomic energy. We're not ready for AI. So, but does this mean that we shouldn't take advantage from the AI, that we shouldn't benefit from it? I would argue that we should. And we do what we can. And I think the European Union does even more than any other country in a way, by ensuring the proper use of AI and imposing liability. Sometimes we are even talking about the problem of excessive bureaucracy and excessive liability. Like in case of general data protection regulations, many companies claim that, okay, we have so many safeguards and we have so many procedures to comply with, which jeopardize our business, but they do not necessarily lead to ensuring the protection of human rights or users' rights. So I would say we definitely need to experiment with AI. We definitely need to go further with it. We need to test it in a sandbox like we do now. But sooner or later, in order not to lose competitiveness with China or the US, we have to economically weaponize it, not necessarily militarily, but apply more and more once we understand more and more of it. And obviously develop more policies in order to ensure liability and mitigating the risk. I think Jan and Orion, they talk a lot about ethics and have a very a number of very interesting points. And I also listened to Thomas Bergman when he spoke of criminal liability, which is definitely an important point, where we have to develop a strong civil liability, a strong criminal liability in the EU. But again, as in case of the EU, in case of 5G, the topic I spoke about, a lot rests on national jurisdictions and national courts. So we can speak about some system only when we achieve harmonization of laws. That's first point pointed out by Orion. And secondly, when the Court of Justice of the European Union adopts some single approach to tackling these issues, and only then we will see, okay, we have some system which is more or less clear and what we can expect from the court. I had a question from Dr. Kalpokas. Do you think I have
Yes,
time?
if you're happy to address it, I could read it out so those that are following us on YouTube could follow the discussion as well. So the question is, some media theorists today refer to humans as part of human data technology assemblages rather than distinct standalone individuals. So do you see something similar in your research?
Before I started working on 5G, I worked on human ICT implants, so the legality of turning ourselves into cyborgs. And I guess this is more in line with the question of Dr. Kalpokas. The short answer is I believe that we shouldn't play science fiction here, despite my absolute love for science fiction genre. When it comes to law, we do not see that as of now. We see obviously human and we see data and technology, or we want to see as simply tools we use. But if we go back in history, say to Grand Duchy of Lithuania, how were the households taxed in that time? How many chimneys did you have? That's what mattered. And how many riders, how many knights can you present on the battlefield? That's what mattered. And in a way, we can draw a comparison with data and technology today, that it doesn't really matter who you are or what's your personality. For companies, mostly matters how much data you generate and how valuable you are from this point of view. And that's where we have these issues like if you're a public person, then you're stripped of certain rights, and then you are indeed more merged like a human data assemblage. But if you're a private person, you have in a way more rights, you have more grounds to defend yourself. So this is a very flexible concept. I would argue that from the point of view of law, we need to remain more consistent and not to fall into science fiction fantasies. But at the same time, we have to reflect the reality. That's why we have this flexible system of, it's a bit of a rude way to say, but stripping some people of their rights, bloggers, public figures, politicians. And well, that's how it functions. I hope, again, the court can bring a bit of a more strict and clear system to this.
Thank you. Anyone would like to respond or follow up?
I can join a bit. Yeah. It's very, how to say, tentative to in this field to involve into speculation. You know, about artificial intelligence. So, and I think we have to be more cautious, and that's why. No, that's why I expressed this idea that highly probably we'll have to think about a new conceptual framework if we want to speak about it in the realm of criminal law, because it's so different, you know. Even those parallels with legal person, you know, which are commonly done. The idea behind is that once we invented another person besides human being, like legal persons, why not to do this time the same? Just give personality to artificial intelligence. It was once done, you know, and also the incentives to create a legal person was also to mitigate risk, you know, to how to say, to enable economic progress. You know, but can we do the same here? Because, you know, artificial intelligence, it's another very different. It's even more so in material, maybe aspect. From material point of view, it's even more close to human being than legal person, because it could really exist separately, you know, as a separate being, as individual being, maybe, you know, because legal person is still, it's a fiction, but very much connected to real human beings who participate. And because without human beings, there will be no legal person, they are still connected, But artificial intelligence, maybe one day it become really autonomous, as what Edita told, completely autonomous, being self-learn, yeah, that's a speculation, but what we will do then, so that's the problem, and yeah, sorry.
Yeah, I think it's a very interesting point, but I do have another issue, because we talk about artificial intelligence in general, but I think this is already a starting assumption, because AI is not one concept, of course. If you look at algorithms, there are millions of machine learning algorithms. So I mean, does this not also have an impact on the regime depending upon which AI it is? Because I can well say that machine learning is totally different from expert systems, for example. So I think there we could also make a distinction.
Yes, that's a very good point. Indeed. And we have some more questions from the audience, and I think it's Ignas asking questions. So a question to everyone: AI is often framed as a transformative technology, and would it also be correct to say that AI is also an inquisitive technology, one that constantly inquires into and probes the boundaries of what we consider to be specifically human? A rather philosophical question. I can see that there's been some chatting in the chat on this point, but perhaps you could briefly comment on that.
Yeah, I guess, I mean, the question, even the term artificial intelligence itself, so it refers to intelligence, and there's no clear definition of AI, as we said before in the previous presentations, but intelligence itself, we refer usually to human intelligence as a metric for defining AI. But again, what is, and these are some of the issues that have been pointed out by a lot of scholars. So what is intelligence by itself? How do you define human intelligence? Is it purely logical intelligence? Would it also include emotional intelligence? We're for sure not there with the AI systems at this moment. But I guess, yeah, there are some of these issues of delineating AI, and could question indeed what we understand as being intelligent at the end, yes.
And also word inquisitive, I don't know if it is, it somehow reminds me of inquisitorial, or is it correct? Inquisitive, yeah, I understand, but there are certain consonances with inquisitorial. But I understand the idea. Yeah, that's the problem. But what I commented, that I don't think that it is exactly AI. It's still a matter of speculation that AI makes. It's we who think in the light of those developments about ourselves. There are many now, how to say, approaches like dataism. That everything is data and we are data. And so on. So yeah. It poses those questions.
I can also shortly add that maybe AI is not pushing or probing the boundaries of what we consider to be specifically human, but it definitely probes and help us reconsider how do we define human rights, and to what extent are we defining them and attributing them to humans. Because again, with new economic events, with economic development, with social changes, with all this development, we recognize more and more rights, and we're progressing also in this field. And AI is helping us to understand where this boundary of personality lies. What rights can we attribute only to humans, to living beings? What rights can we attribute to the artificial intelligence? And this becomes more of a permanent question I hear on many legal AI conferences. Do we need to consider AI as a legal person, or do we need to develop a completely new legal fiction for artificial intelligence person, and maybe this, as we have natural persons, legal persons, maybe we'll have AI persons with a completely different set of rights and completely different rules. So in this case, definitely AI probes what we consider to be specifically human rights and what we consider to be legal rights or the rights of AI personality.
Yeah, and closely related, I'm of course not a philosopher, so I really do not say any statements in this regard. But what I've already heard as well is that now we try to give artificial intelligence of humans. But would it not be more beneficial to give it some kind of other intelligence that would complement humans, that humans cannot do? Would this not be very an interesting perspective, that you have actually combination of humans and AI that have different kind of intelligence, just as animals and humans to a certain extent, let's say. So this is also something that may be interesting to define this human element.
That's a very interesting point indeed, and especially when now there is a discussion about humans enhancing their abilities with artificial intelligence. This is very topical as well, and it should be discussed, not only artificial intelligence as such, but how it relates and interacts with and adds to human intelligence. So I think slowly going to wrap up, and perhaps what do you think? Is Europe going the right way? Is it in the right direction in terms of AI and its regulation? Or is it too slow, and is the bureaucratic machine too burdensome? Or should we have perhaps some similar regulation to GDPR, and we have, say, data protection by design and default? Perhaps we should have something analogous for artificial intelligence systems. What are your thoughts on that?
I can give a very, very short, and I think the EU, the white paper, I think is a good step in the direction. This risk-based approach is really the way to go, to take into account whether an AI system is high risk, additional requirements, and it's low risk, not necessarily requirements. So that's a good step. What I think that is somehow missing a bit is that we have to look at the existing legislation and see whether it's already sufficient to cover the challenges. So we might not need a whole new framework, as I mentioned, with specific target challenges. If you say we need a GDPR for AI, I don't know. I think maybe the GDPR might already be sufficient. So there's already a lot of legislation. We should not enact new ones. But I think the risk-based approach is definitely the way forward, according to me.
Yes, I know we don't agree on that, Jan, on the approach, but I understand your arguments. But again, this notion of also high risk, low risk application, to me personally is not very clear how you would delineate these different high risk applications. And to answer the question, is EU going in the right direction at this moment? If we consider the European Parliament URI committee proposal, in my opinion, we're not going in the right direction. As I said, this one-size-fits-all solution for both covering autonomous vehicles, autonomous unmanned aircraft, autonomous healthcare systems does not make any sense because, as I said, there are sectoral specificities. We don't take into account the sectoral specificities. In certain jurisdictions, we have some liability mechanisms that are adapted, but we may want to harmonize them at the EU level, but on a sectoral basis. And I think there was also I think Andrea Bertolini proposes a risk management approach towards regulating liability for AI. I think that's a rather interesting approach. He also says that we need a more sectoral approach to regulating AI. Because AI, if you talk about AI by itself, doesn't mean anything. You have to talk about its applications, which are manifold, and the sector-specific applications may warrant a sector-specific liability mechanism, yes, which are already, for example, autonomous vehicles or unmanned aircraft already have established liability mechanism, usually at a national level. Aviation is a bit different. If you talk about contractual liability, will be internationally based also as well, or some European regulation as well. But if you talk about autonomous vehicles, you do have strict liability, no-fault compensation mechanism, which could continue to work. So why not harmonize at the EU level to overcome fragmentation? And yeah, just some food for thought. But I understand Jan's arguments as well. So.
And if to look from criminal liability and European perspective, we didn't discuss yet this issue. So criminal law is most sovereign issue as such, and Now we have directives on various matters, but of course there can't be harmonization as such, and a lot of sovereignty left to states. And general criminal law as such derives from mentality, from morality of state, of society, and depends on the concepts of civil law, as we have the example of legal personality. First of all, it began and developed in civil law, and as a consequence, it was established in criminal law. So it's the same with AI, I think.
Also, I think one of my fears with granting legal personhood to AI is that, I mean, then AI would be liable somehow, civilly liable, with maybe an attached economic fund in order to compensate the victims. But some have pointed out to the fact that this may de-incentivize other actors, or those who produce AI, also from taking due diligence in producing AI and taking monitoring duties, etc. So that's, we also discussed that with Jan, the notion of deterrence effect of liability, maybe also to take into account when we talk about legal personality for AI systems. Yeah, I don't know, Jan, if you have any.
I can, if I can join from philosophical perspective. So I already heard from you, Orion, probably said, I'm afraid, you know. So, so humanity, I think, became a bit afraid of what it has created, and that's the problem, you know. So there are two so to say goals, or risks. The risks to invent further, and the risks not to invent further artificial intelligence, because, you know, if those legal problems of liability, you know, who is liable, will not be solved. So the creators of artificial intelligence may just stop creating it. So that's one risk. Another risk is to create it to, I don't know, to the such extent when we don't know who is liable, you know, and if persons have damages, how to solve that. So we are between two poles now. And generally, I think European Union incentives are very good, but I think we have to be very careful still, because, you know, legal personality or juridical persons, legal persons were also invented. They do not exist, they are fictions, you know, but they invented to facilitate economic development and to mitigate risks that people would be more risky to take risks to start economic activities. That's why we have legal persons. But here we have rather different artificial intelligence. For me, it's, of course, it's intelligence, but it's more material, and it can be even more autonomous, you know, not fiction. It's not fiction, it's more real. So I think we have to be still more, you know, because to what it leads, maybe then artificial intelligence, if it's completely autonomous, as you told, we can attach funds to it, or maybe it can even start earning funds, you know, and has labor contracts, you know, and its own savings, you know, and so on and so on. So there is the bottom, you know, line of all that development. So yeah, we have to do that, and to somehow to make possibilities, how to say, to platforms to develop it, but still there are, I think, more risks here than with just parallels with legal person, you know, and that's it.
Any more thoughts on that? If not, I would ask you to very briefly sum up the discussion and provide perhaps a short summary or a takeaway point of the day's topic that you wish the audience to take away or ponder upon, but 30 seconds, not more. Fire away.
Yes, for me, just two key takeaways, but in 10 seconds. Data literacy is the most important one. I think education, digital skills is one. The second one, do not drastically change the legal framework that might already apply with sufficiently.
I also go on Jan's last thought. It's not necessary to reinvent everything. We do have certain liability mechanisms which could continue to apply. Then how will we apply it at the national level, continue to apply it at the national level, or at the European level? That's open to discussion indeed.
Thank you very much, Mikita.
Well, I spoke about 5G, so it's a bit of telecom law. Telecom law still largely rests on national governments. So I would like to agree with Jan that we do not need any more laws, and we would rather maybe need some correction by the court. But I would say we will definitely see some sector-specific law coming on AI in the European Union, and also coming on telecommunications and the usage of AI there.
Thank you very much. Thomas and Edita, your brief comment?
I think we should think about providing legal personality to AI, but just from pragmatic point of view, treating it as useful instrument for society.
I still do not want to I still stick to my point that we will have to reinvent or to think about different conceptual framework in relation to punishments, because, you know, I don't think that all those fourth theories are really directly could be applied to artificial intelligence. So that's my point of view.
Brilliant. I thank you all, and it was a lovely discussion, and I loved the fact that Jan and Orion disagree on some points, although present together. That's great, and it's very engaging. And it highlights that the issues that we're talking about are very important, and there are things to be discussed. I thank all the speakers and also the audience for joining us this afternoon, and I invite you all to remain with us till the evening, and would take this opportunity to remind that today at 6 p.m. EET time, which is 5 p.m. Central European time or 4 p.m. UK time, we will have the second keynote address of the day delivered by Professor Leonora Rosati. So you're welcome to join for that or stay with us throughout the afternoon. And I also kindly remind that panelists, all of you are cordially invited to the evening networking session, which will take place on MS Teams after the evening keynote address. So this will be at approximately 7:15 EET time or 6:15 Central European time, 5:15 UK time. Bring a cup of coffee or any other favored drink, and let's continue informal discussions. Thank you all, and the next panel starts in 3 minutes at 3 o'clock.
Thank you.
Okay, hello and welcome to our next, already the fourth panel of today. Time flies, it's already the fourth panel starting. Again, to reintroduce myself once again, I'm Ignas Kalpokas from Vytautas Magnus University, and I will be once again chairing a panel. And this panel is on the military use of artificial intelligence. So we are still staying within the broad artificial intelligence theme, continuing from the previous panel. And the first presenter in this panel is going to be Raphael Georgiadis from the University of Wolverhampton, and he also works as an analyst for NATO Ground Surveillance Force. So, Raphael, the floor is yours.
Thank you very much, Mr. Ignas, for the introduction. First of all, allow me to ask you if you all can hear me loud and clear.
Yes, indeed.
Okay, that's great. Thanks again for having the chance to introduce the military use of AI into our audience. And for the chance you provide me to deploy some of my deepest concerns, ideas and thoughts concerning the employment of AI in UAVs against contemporary threats in the 21st century. Also, since I had not the honor to meet our speaker or to join a conference like this in the past, please allow me to introduce myself, although you did that a couple of seconds ago in a perfectly way. I'm Raphael, coming from Greece, but currently posted in Italy, where I serve as a UAV fusion analyst and at NATO. And as far as my academic background, I'm a postgraduate student at the University of Wolverhampton, where parallel with my studies, I'm conducting my research concerning the employment of AI in UAVs. Since the time is limited, I'll do my best to be as laconic as possible. And for this reason, I'm going to start my presentation by saying that the shift from manned to unmanned aviation happened mainly for two reasons. Firstly, for safety reasons. In other words, the purpose was not to remove physically the pilot from the cockpit, but to replace, because pilot, whenever his aircraft has to penetrate behind the enemy lines and conduct his mission, in many cases, this is a risky mission. So for this reason, I would like to highlight, allow me to underline the word remove, because the human factor is still there, but it's not behind the cockpit, but on the ground. Secondly, the purpose of this shift was to eliminate the human errors. In other words, to increase the effectiveness of these platforms in terms of intelligence, surveillance, reconnaissance, and targeting, or simply what we call in the domain ISRT. This is also the concept of operation for all the common drones that fly around the world today, and you may have seen in the real life or even in science fiction movies. By the time, allow me to clear that terminologies concerning the UAVs, it's a little bit problematic, because most of you may have heard the terms such as UAVs, drones, RPVs, but my intention is to make this presentation as simple as possible. So from now on, you will hear me using the term UAVs. So let's analyze the outcome of unmanned technology in military domain. Indeed, the effectiveness of UAVs against controversial means of warfare in the air, in maritime, or in land domain is beyond all expectation. This is the truth. Their advanced sensor, such as EO cameras or electro-optical cameras or advanced radars, are capable to monitor their targets for extensive periods, literally above enemies' heads. And consequently, they can provide vital information concerning the forces in terms of number and types of the equipment that it's located on the ground, or even to indicate any illegal activity that takes place in this region, or at least what we call, the opposite side, illegal activity, which means that one part may want to describe a situation and providing the term illegal, which means that although it is illegal for one party, for another party, it may not be illegal. So compared to conventional aircraft that subject, to human restrictions, such as the pilot's combat stress, the fear, the fatigue, and all these human instincts that all of us have in our daily life, for more simple things, such as to catch, the bus right on time. So can you imagine, the pressure for a pilot when he has to engage, for example? So UAV's performance is much more effective in all these ISRT missions I've just described. However, casting into a new era where new forms of warfare arise from the horizon, such as cyber warfare, hybrid warfare, terrorism, or cyber terrorism. Unfortunately, today we have evidence that the human factor is still responsible for critical issues such as civilian casualties and collateral damages. With the term collateral damages, we include damages in schools, hospitals, and any kind of infrastructure that is not relevant with military activity, which means that from a law perspective, from a purely law point of view, these targets are not legitimate targets. Unfortunately, both social media and the news can provide us with many examples, with plenty of examples that took place in modern history, in Libya, the Middle East, or in Kosovo, for example. And here comes the question: is the employment of artificial intelligence or the autonomous flight in general the most suitable tool capable to eliminate these issues? To answer this question, it's necessary to define two essential things from a military point of view. Firstly, let's see what's the utility of UAVs in military operation. This is the most important, perhaps one of the most important part of the presentation. And why is that? Because commercial UAVs or simply drones are really effective in taking fancy pictures, from above. But in the military, it's a different story. UAVs are sophisticated platforms capable to fly for hours, many miles away, to interact with satellites in the outer space, or combat ships like frigates or destroyers in the middle of the ocean, and collect data, raw data. The analysts on the ground are responsible for processing all this vast amount of data and produce intelligence products. Intelligence products for the decision makers, both military or political. Based on these intelligence products, the decision makers will have to take serious decisions concerning risky missions. For example, do I have to conduct a strike or not? Will the strike be lethal or not? If yes, what would be the consequences of this strike? And it's really important to have answers in these questions, because we should keep in mind that that any military action has a political cost. At least this happens in democratic states. What is important here also to outline is the importance of time. So If there is something that I would expect from the audience to keep is this simple word, time. I've just described a time-consuming process in just a sentence, but this is not very realistic. Decision makers always ask for intelligence products as soon as possible, whilst analysts ask for more time in order to reach to more accurate assessments. It may sound funny, but intelligence products, just like food and drinks, have an expiry date. What does this mean? To make matters worse, compared to food and drinks that we all have in our daily routine, which lasts for months or even years, some of them, intelligent products last only for a few minutes or even seconds in many cases. Which means the more time consuming the process is, the more we risk to conduct a mission with lethal consequences. We must have in mind that we need time to collect the data. We need time to process the data. We need time to produce intelligence products. And guess what? Decision makers also need time to think what is the best option for them. Needless to say, that things become more complicated whenever we have to engage the targeting process. Targeting process is one of the critical elements of I've just mentioned, and includes to the concept of military operation ISRT. And why targeting process is a very sensitive element of this process? Because from a military point of view, at least in democratic states, we must have in mind that any military action, including strikes, require legitimacy and should be based on the fundamental principles of the humanitarian law. All these principles are included to just war theories and fundamental principles of jus in bello and jus ad bellum. So if someone is interested, he can find plenty of information, concerning the legitimacy in these two principles. In other words, the principles, these are the principles that defines whether we should go to war or not. And if the answer is yes, then to what actions are we allowed to proceed? I will not proceed further to these details because I don't want to drift away. So nowadays, we have also evidence that collateral damages and civilian casualties have the roots mainly on the time-consuming process that is required to conduct the mission, especially in cases such as terrorism, where the battlefield has literally moved to our towns and the enemy is no longer wearing combat uniforms. The time is needed, fused with the distinction limitations of the existing sensors of the platforms, of the aerial platforms, make the targeting process in terms of civil casualties and collateral damages necessary evil from a political point of view for many cases. Taking into consideration that human factor is engaged of the process mentioned above, through the pilots, the surveillance operators, the weapon system operators, the intelligence analysts, the mission directors, and even the decision makers who are responsible for taking the decisions, we can reach the conclusion that the more personnel is in this loop, the more we increase the chances for human errors. To sum up, although semi-autonomous flight in UAVs is no longer a science fiction scenario, at least in the military domain, we do have evidence that this technology exists. As you can understand, most of these programs are highly classified even for the military personnel. However, the aim of this presentation was to provide information concerning the employment of AI in all the steps that exist behind the targeting process. This deployment, the employment of AI is expected to provide precious time to decision makers and increase the confidence level of the intelligence products. Coupled with basic principles of just war theories or deterrence theories, we may prevent a strike with other diplomatic tools. As far as I can remember, our dear colleague, Mrs. Edita, if this is the correct way I am pronouncing her name, from panel 3, made a reference to these theories during her presentation, and probably in essence, UAVs should be used as a tool to prevent a threat and not to suppress it. Otherwise, since the world we live in is not an angelic world, if we proceed to targeting, it actually means that we have to suppress a threat by all means, by any means. In this case, the elimination of critical issues such as civilian casualties and collateral damage will remain a promising scenario for the technology. So my humble opinion is that if we follow that path of targeting, unfortunately, this will be a one-direction trip. So at this point, my presentation came to an end, and allow me to spend a few seconds to show you an image that clearly illustrates the complexity of this process. So, are you able to see my PowerPoint slide?
Not at the moment, no. Okay.
Okay, so that's good.
Yeah, now we can see it.
Okay.
So if we could just focus on that one slide and then move to the next presenter.
It's just in one slide. So we have a saying in Greece, a quote, that an image, a good image, is equal to 1,000 words. So this is exactly where I'll do my best to put to the test right now. So if we see this image illustrates the complexity of the existing interoperability, which means we have hundreds of individual elements behind UAVs, and all these elements, behind all these elements, the human factor is present, which means the more we increase the human factor in all these factions, the more we increase the chance for human errors. And also, the process becomes a time-consuming process. So that was from my side.
Okay. Thank you very much. And now
you,
I would like to invite the next presenter, Ieva Skurdauskaitė, who is a PhD candidate at the Vilnius University Institute of International Relations and Political Science. So, Ieva, please, the floor is yours now.
Thank you, and good afternoon, everyone. So give me a second. I'll try to share my slides with you. I think you should be able to see it. Could you confirm?
All is fine.
Okay, so from a more practical presentation that Raphael just gave us, let's jump to a more theoretical or philosophical, as it was discussed at the previous panel discussion. But I believe we all acknowledge that artificial intelligence is a highly interdisciplinary issue. So saying that, as the title suggests, I am mostly interested in autonomous weapon systems and human relationship. And for this presentation, I focus on a discourse analysis of the Convention on Set and Conventional Weapons discussions, the concept of dignity, and how it affects the way we comprehend human and autonomous weapons systems. So to set the scene of where the main problem of my research comes from, across the literature, there are three main types of arguments against autonomous weapon systems. So firstly, we have technological arguments and autonomous weapon systems' ability to conform to international humanitarian law. Then we have consequentialist arguments about global stability and the conditions of going to war. And last but not least, there are deontological arguments based on the need for meaningful human control and human dignity. And this last group of deontological arguments discussions is the topic that I'm mostly interested in and that my presentation is based on. So some argues that even though there are several types of objections to autonomous weapon systems concerning human dignity, they are not unique in this respect. There are other conventional weapons and technologies that question human dignity. Therefore, the arguments should not concentrate exclusively on human dignity. However, and I disagree with that statement, because I assume that such an argument downplays a significantly different nature of autonomous weapon systems comparing to other conventional weapons. New technologies with increased autonomy in decision-making now represent a qualitative shift in military technology and the way we comprehend warfare, precisely because they embody the emergence of the non-human agency with the abilities to think and execute the decisions made. And since 2013, the issue of autonomous weapons, as well as the levels of appropriate and meaningful human control and autonomy, have been discussed at the political level under the agenda of the United Nations Convention on Certain Conventional Weapons. Throughout the years, the delegations from different countries, NGOs, and other entities agreed that the consideration should focus on the human element in the use of force and aspects of human-machine interaction. Therefore, quote unquote, the use of force must reflect human agency and human intention. However, there is still to this day, there is no compromise on the shared meaning of autonomy, autonomous weapon systems, or meaningful human control, which not only makes these discussions more fractious, but in some way even objectless. So having that in mind, I conducted a discourse analysis of the Convention on Certain Conventional Weapons. And for this presentation, I present my several findings from a pilot study. So I studied final reports from the year of 2014 to 2019. So I was mainly looking for the types of arguments against or for lethal autonomous weapon systems and whether they are related to human dignity, as I've predicted beforehand. Then the context in which the concept of human dignity is used and the way human dignity is understood, namely vocabulary and the arguments that are used in the context of such issues. So here are my four main findings of the study, and I'll go quickly through all of them. So the first one is that, as I've mentioned, there is no compromise on the shared meaning of autonomy, lethal autonomous weapon systems, human involvement, etc. For example, autonomy as human involvement can have several levels, such as human in the loop, on the loop, or out of the loop. And they depend on both technical capabilities of the technologies developed and the state's political will. But when there is no legal compromise on what's going to happen and how should we arrange all of the weapons, and what should be the relationship between the operators and the technology itself, well, simply speaking, we can run into a real problem rather soon. The second finding is that human dignity is important, and in many cases, the most significant argument when discussing ethics, international humanitarian law, and human and technology interaction in general. However, the concept is usually used and understood as an intrinsic justification for other concepts, namely the level of technological autonomy and meaningful human involvement. Therefore, the concept is rarely used straightforward and usually is considered in the context of other concepts. Nevertheless, the concerns about human dignity evolved from two foundational sources. The first one is the technical issues, namely the technological autonomy. Human dignity here is closely related to a human being autonomous in his decisions and the levels of technological autonomy, which leads us to the conclusion that the higher level of autonomous weapon systems autonomy means the lower levels of human autonomy. And the second source is humanitarian laws. Human dignity is understood as universal and inviolable. Therefore, lethal autonomous weapon systems must comply with international humanitarian law as the primary principle of possible future operations. It is said that, well, the delegations are discussing that it is not ethical to leave a lethal decision to a machine because machines cannot die themselves, therefore they are not capable of doing moral justifications. So here we have humanitarian laws. And the last finding is that human dignity concerns are raised mainly when discussing the victims, whether it's a combatant or a civilian, and not the military personnel whose work might be replaced or adjusted by the levels of technological autonomy. It's a very popular topic among the economists that are interested in artificial intelligence and its applications. However, and there is some sort of a discrepancy here, the features that distinguish human from the technology are discussed to be responsibility, accountability, creativity, and even compassion, which are said to be attributed to only humans as their prerogative, and features that make them more special and unique concerning lethal autonomous weapon systems, and which are also assigned to the personnel instead of an unrecognized possible victim. But when the delegations talked about human dignity, they mainly refer to lethal decisions and victims who might be affected by these decisions. So the disagreements about the concepts strike again, and we can witness one of the reasons why such political discussions sometimes reach a dead end. So what does it mean? What does it imply? So the findings suggest that the concept of human dignity is closely related to a human being autonomous in his decisions, or as an inherent value intrinsic to its humanity, uniqueness. Hence, the higher levels of autonomous weapon systems' independence in the decision-making process threaten human uniqueness. So it is said it's unethical to leave the lethal decisions to the machine, that autonomous weapon systems' decisions to attack the target must be restricted by meaningful human involvement. That is, the final decision to release the attack must be made by a human being. Thus, the arguments against technology in these debates focus more on autonomous weapons systems autonomy in thinking rather than in executing the decisions. So to speak, the lethal decision is sometimes considered more unethical than the act of killing or the lethality itself. However, as I've mentioned a couple of times, no disagreements on their understanding of autonomy, meaningful human involvement, etc. One of the main reasons may be the profoundly new nature of autonomous weapon systems that also encourages us to rethink not even the relationship between technology and human, but also the way we understand the human being, his functions and unique qualities, and whether the dignity as understood prior to autonomous weapon systems is still applicable to this case. So I suggest, and to sum up, the ethical and moral concepts should arise from the interaction of autonomous weapon systems and humans, and not be forced as pre-existed property of human beings or technologies, if there is such a case. What I find missing in these debates is the constitution of the ethical and moral standards encouraged by the current situation, and not the strict principles that we try to apply to the new cases. In that way, I assume the discussions on autonomous weapon systems, well, at least at political level, may be more efficient and reflect the most vulnerable issues of technology and human relationship. And that's it for my presentation. Thank you so much for your attention, and I'm looking forward for this discussion.
Thank you. Thank you, Eva, for the presentation. And now let's move to our third speaker of this panel. And that speaker is Marco Marsilli, and he is research fellow at Universidade Católica Portuguesa and research associate at Instituto Universitário de Lisboa and the Portuguese Military Academy. It's been a while since I tried learning Portuguese, so I hope I pronounced the affiliations correctly. Now the floor is yours.
Thanks very much, Ignas. Thanks to all the colleagues sharing this panel, and a great thanks to the organization and to the steering committee of this conference, which topic is timely, is very actual. Now, are you able to see my presentation? Can you see? Can you see it?
All is great.
Yeah. So, my compass has always been in all my research activities and for my overall life, the respect of fundamental human rights. So I had so much to say, to comment on Raphael's presentation, because I spent many time addressing, researching on the liability of the so-called targeting strikes and so on, and on the role of the unrecognized by the United States of the unrecognized International Criminal Court. So they do not abide by this special tribunal that should judge on crimes of war and crimes against humanity and so on, because we all know that a lot of mistakes occur, fortunately, with wars, generally speaking, and with these targeting strikes that should be very precise, chirurgical, but in the reality, they are not so precise as they pretend to be. So, technology, I think that we all acknowledge that technology is the key driver of warfare. It's not since the last century or the last couple of years, but it's always been the key driver of warfare. And it's a real game changer in the defense sector, including the military and users. Technology is currently transforming warfare. I'm citing the capstone publication by the Joint Chief of Staff of the United States, and it's changing how political civilian leaders relate with war and with warfare and with technology. So that they acknowledge, the political leaders acknowledge that they should try to establish some kind of rules for the use of technology in military uses. So military emerging disruptive technologies that became very popular in the last year are deemed to have a rapid and major effect on technologies that already exist and disrupt or overturn the traditional practices, and may revolutionize even governmental structures, economies, and international security. So the emerging disruptive technologies that it's a set of technologies. It's just like talking about hybrid warfare. What is hybrid warfare? It's everything and nothing, because it's like a big pot when you can put inside everything. So this is always a problem with, there's always a problem with definitions when we deal with warfare and military uses of technology. Because just to mention, we all deem that unconventional weapons are nuclear weapons or biological weapons, but there's no international treaty, or there is not any convention saying, spelling out what exactly are unconventional weapons. Is the same as for conventional weapons. So that there's so much to say about these definitions. These are wordings that are much more defined by the literature than by the law, international law. But in my opinion, we need a precise framework in order to frame legally these technologies, these weapons, and to address and to cope with them. So how to use them, which one are forbidden and which one are not forbidden. Of course, in my opinion, all the weapons should be forbidden, but this is another discussion. Now okay. Pardon. Yeah, next slide. So these new technologies, emerging disruptive technologies, and be deemed, I'm citing Margaret Cosell, that we do not, so far we did not have a huge or a relevant literature production. But since 1 year ago, the researchers began to publish on these topics, but there's a few literature on the topics. But one interesting thing is that Margaret Cosell, in one of these few publications, this is from a collective book on emerging disruptive technologies, she equaled the ADTs to nuclear weapons. So she gathers that emerging disruptive technologies, I mean their military uses, have a greater potential than nuclear weapons. So coming back to what I said 1 minute ago, so we still have to define if these new technologies should be comprised among the unconventional weapons, like the nuclear weapons, or not. So far, we have a debate, an ongoing debate, and I'd like to link to the presentation by Raphael, because on one side we have the United States, who does not want to have any responsibility for the use of unmanned technologies, unmanned aerial systems, broadly speaking, unmanned systems. And just to say, the UK, it's whether is an ally of the United States in the NATO, does not share the same position, the same posture of the United States within this body that it's been established within the Convention on the Prohibition on or restrictions on the use of certain conventional weapons. The government of the UK believes that there should be someone liable for the decision of using the lethal force. So they should be at least the final decision should be taken by a human, because the tendency with intelligence, artificial intelligence, and much more there with artificial intelligence, with machine learning, that is the higher layer of the applications of artificial intelligence, the tendency is to leave to machines the possibility to take decisions instead of humans. So in this way, you can easily understand that the politicians would strip from themselves the responsibility of deciding whether to use the lethal force. That means, it's a nice wording, the use of lethal force. That means, in a common translation, means killing someone. But so far, the debate is limited to drones, and it's becoming to involve also a discussion on artificial intelligence. But emerging disruptive technologies that may have military uses, it's not just these ones. It's not just unmanned autonomous systems or semi-autonomous systems. It's not only artificial intelligence. Here you can see a list. So I listed some of these emerging disruptive technologies that include also, I've already heard in the previous presentations, someone talking about cloud computing and 5G networks and so on. So we should also include hypersonic weapons that can fly in the space at a velocity, a length of from 5 to 10 times the velocity of the sound. So this so far hypersonic weapons. There isn't any terrestrial system that would be able to intercept an hypersonic weapon so far. But there are conventions prohibiting the placement of unconventional weapons in outer space. So once again, we have a problem with definitions. What is an unconventional weapon? I mean, hypersonic weapons can carry on both nuclear and, unconventional and conventional payloads. So, and afterwards, what is the outer space? As there is not official definition of outer space, and so on. And we can go on with this discussion. It would be very interesting. So the United States, the Department of Defense, acknowledged a couple of months ago that the general public is becoming concerned about how the military and how the politicians, the senior leaders, will use artificial intelligence, because artificial intelligence is much more popular than the other technologies that I have shown you in the previous slide. So the Department of Defense began to draft rules about how to use artificial intelligence. Of course, machine learning also is driven by artificial intelligence and hypersonic weapons, everything, so artificial intelligence has a broad use, and not only in warfare and in military applications. So it's just like the cyber. Everything nowadays is cyber, and everything is linked, needs electromagnetic warfare, because all the weapon systems are used with electronic magnetic warfare, and communications also. Also terrestrial communications happen in space before coming back to Earth. So the Department of Defense established 5 principles that should guide the use of artificial intelligence. This is the artificial intelligence should be responsible, equitable, reliable, governable, and also traceable. That means that at the end of the chain, it should be possible to trace back the personnel who took the final decision of employing some kind of technologies in military applications, in warfare, that may lead to fatal consequences for someone. I mean, it's the use of the lethal force. So it should be possible to trace the responsibility, the liability. But that's a problem, that who checks? I mean, once some kind of principles have been established. Who checks? Because as I told at the beginning, just to say, because we have a couple of powers, of superpowers. We have the United States, that it's late with the development of this new kind of weapons, because Russia, it's so far is the first one and the only one a nation that developed hypersonic technology. The United States are pushing so far to reach Russia, the Russian Federation, and China is there. So it's three nations competitions. And quantum science, quantum technology, that is very important, because the atomic clocks should be as more precise as they can, so we can all understand which is the importance of quantum computing and quantum science within military applications. And direct energy weapons, laser weapons, are under development. And just 2 days ago, the US Department of Defense said it would take a couple of years to get there, to get the possibility to use these technologies, to employ them within in warfare actions. But it's not so far. It's coming. The future is coming. So the problem, in my opinion, is first of all to establish these rules. That should be legal rules. I mean, should be under international conventions or international treaties, and should abide by customary law. And then we have to establish which will be the body responsible in case of serious violations. Because if the United States, that is one of the major powers, technological more advanced powers with Russia and China, if the United States does not abide, does not recognize the jurisdiction of the International Criminal Court, I mean, it doesn't make any sense to establish rules, to try to establish them, when one of the major powers, one of the few powers that is able to use these technologies, does not feel bound by these laws or by these rules or by these special tribunals. So I think that we have the need to stimulate a public debate, because so far the wide audience is not aware of the perspectives of the employment of these emerging disruptive technologies and their military uses. So the problem is that the research in this area is kept confidential and secret because there are patents, and not only patents, due to national security concerns or national security accusations and defense issues and so on. So they do not circulate, but I think that we, I mean, the research broadly speaking, should trigger or try to trigger a public debate on this topic, and to try to produce much more research on these issues and to disseminate it. So this is, I mean, this is my invitation to all the scientific community to try to keep seriously the future developments and the military employments of these existing and future technologies that are under development and that will be not so far. I'd like to close with this this declaration. It's became quite famous from emperor, the last emperor, the last ruler of German Empire, Wilhelm II, that when the automobiles appeared, he thought that I don't care, I'm not interested in automobiles, because this technology is just passing technology, it's just a phenomenon, it's just a fashion, a mode. I only believe in horses. So I think that we should be we should watch out and stay awake because this is a serious challenge to human rights and a serious challenge to peace. This is a serious challenge, even not only on Earth, but even in space. That should be a place where, according to the International Convention on Outer Space and on celestial bodies, it should be forbidden to place unconventional weapons. Thanks very much for your attention. And here you have all my contacts if you want. I was within the time, Ignas. I'm in time.
Slightly over, but we will be fine with that. I'll just keep silent for a second so that people can note the contacts. Okay. So let's move to the final presentation of this panel, final, but certainly not the least. And it is by two presenters, Maggie Gray, who's from Stanford University, and Amy Ertan, who's a PhD researcher at Royal Holloway, University of London, while also being a visiting scholar at the NATO Cooperative Cyber Defense Center of Excellence and research fellow at Harvard University's Belfer Center. So please, the floor is yours.
Great, thank you. Let me just share my screen quickly. Great, can you guys all see that? Thumbs up for anyone who can. Great,
yes,
okay.
We are very happy with that.
Okay, great. So I wanted to say, very excited to be here. My name's Maggie. I am a master's student studying computer science at Stanford and also was a visiting scholar with NATO's CCD COE, as was previously mentioned, along with Amy. And during our time there, Amy and I basically worked to map the role of artificial intelligence and autonomy in NATO militaries. So you know, a lot of previous research on this topic has focused on the big ones. You know, they focused on the US, on China, on Russia, but, you know, we wanted to see what is actually happening all throughout NATO, from big states like the US, Germany, France, to smaller states like Lithuania and Montenegro, and all that goes along with that. So I will just hop right in. So just, I think this definition issue has already been covered pretty completely by previous speakers. I'll just note that we sort of generally use this framework of first wave and second wave artificial intelligence in our research. This is a framework that's discussed, kind of introduced by DARPA, and it's also used by NATO, basically in which first wave artificial intelligence has been around for decades. It's based on these expert systems, which are, you know, human built models based on if-then statements, does not include any machine learning or statistical learning. And then the second wave of artificial intelligence is machine and statistical learning. This is what we all hear about in the news every day, if you're following these issues, as I am sure everybody here is. And this is where you actually have these large data sets that are used to create statistical models. And we really wanted to ground this research in the reality of what is actually happening. You know, it's very easy to find yourself off in Terminator land whenever you're discussing military AI. We wanted to see, you know, what is actually happening in this space. So, what we learned is that artificial intelligence, at least first wave artificial intelligence, has actually been around for quite a long time, for a number of decades. You know, we see this in things like the Patriot air defense missile system, also in the Aegis system, where, you know, these were built in the 60s and 70s. They use first wave expert systems to have autonomous and semi-autonomous functionality, in which, you know, it says, if I see an incoming missile or plane, then I will shoot this, with varying degrees of human control over that, kind of depending on the mode that you're in. We also see this with autonomous vehicle technology. So for instance, the Israeli Bee Hunter UAV, which was used by the Belgian Air Force until I think just a few months ago, also had this autonomous flight capabilities and was developed in the 1990s. However, in recent years, we've of course seen the emergence of machine learning, second wave artificial intelligence that has made a big impact in this realm and has really accelerated people's thinking and development of these weapons. So just kind of as a comparison, you have the Bee Hunter UAV, which is this drone that flies somewhat on its own, but does not have any real intelligence as we think about it. However, then you can also look at the Turkish Kargu loitering munition, which uses machine learning and deep learning to do facial recognition, such that now all of a sudden, rather than following a more or less predetermined route, you actually have a drone that is equipped with an explosive that can fly around, find the face that it's looking for, and slam into it and kill it. And we've also seen, that all of a sudden this technology is actually getting better than humans are at killing other people. Recently there was this DARPA alpha dogfight challenge in which a US Air Force pilot and an artificial intelligence algorithm went head to head in dogfighting, and the artificial intelligence won every single time this algorithm won. So, it's faster, it reacts better, it has more information to make its decisions. And we started to see militaries kind of publicly thinking about this issue. So for instance, both the United States and France have published, artificial intelligence military strategies in one way or another. And we went through and we looked at what is everyone in NATO thinking about this. And so it turns out so far, only France and the US have actually released military AI strategies, but there are other military AI strategies in progress. We also looked at, just what countries are working on AI strategies. And we did a little bit of thinking about, why would a country actually release an AI strategy versus not? And I'll hand it over to Amy for a bit right here.
Amazing. Thanks, Maggie. So looking at what NATO members were doing around military AI, we started to look at what NATO itself was doing, and NATO does not have a military AI strategy yet. What they are doing is putting out a number of white papers and reports outlining how the NATO perspective on strategic issues. So, for example, the Science Technology Organization at NATO has highlighted AI and autonomy as two priority emerging security areas for the alliance. Activity is happening at NATO itself. There are advisory boards coordinated by by NATO HQ's Innovation Unit, which also consists of the Emerging Security Challenges Division, which looks at policy and doctrinal issues raised by AI in a military context. You also have the NATO Communication and Information Agency, NCIA, which has its own data center. They have the technical expertise to start looking at how NATO can use AI, machine learning, and big data to kind of defend itself as an institution, but not so much for the members at this point. Looking at what NATO's doing as an alliance in terms of agreements, it's more about starting conversations and developing consensus approaches to responsible use of AI, to development and appropriate capability building across the alliance for AI in the military. And it really is quite clear that NATO, in line with its wider identity, is a facilitator, not a driver here. NATO has no mandate to require anything, including information sharing from their members. So it really is a platform in which states choose to bring issues and potential approaches to the arena and develop that consensus-based approach. And of course, that does mean bringing it back to the idea of a NATO military AI strategy, that you have quite a lengthy process, first agreeing on your definition of AI, the challenges of which have already been covered by some of our other panelists, agreeing the scope of what military AI is. NATO's scope is quite firmly military. So what with AI being dual use, there's a lot to discuss and cut there before even getting to norms, doctrine, or kind of policy developments. And of course, as an institution, NATO is acutely aware of the fact that while these consensus building approaches take time and are worthwhile, a lot is happening in the real world in conflict. So I'll hand back to Maggie now to talk about the military applications that came up through our research.
Yeah, thank you, Amy. Sorry, I think I had a brief alarm going off there. So, like I said, we looked at every single one of these countries, we looked at their AI strategies, and then we also looked at what weapons they actually use. What weapons do they own? What weapons do they deploy? And we tried to categorize this very broad array of AI-enabled military systems. So there are lots of potential military AI applications. These are all some of the applications from a NATO document that came out talking about this. So lots here, but what's actually being used? Because of course, not a lot of this thinking about how AI can be used is still pretty early on. And we found that we could sort of broadly classify NATO's use of artificially intelligent systems into 4 broad classifications. So autonomous vehicles is probably, the most obvious, the most evident. This includes everything from UAVs to underwater vehicles to surface vehicles, ground vehicles. And this has already, of course, been talked about by other panelists today. Then they also had a number of air and missile systems and defense. And they're all broad categories, but this is a perhaps particularly broad category. So this includes air and missile defense systems like Patriot, but it also includes 5th generation aircraft like the F-35 or the Future Combat Air System. And also we were thinking in this space about autonomous missiles like the UK's Brimstone missile, which, is fired and then finds its own target in one way or another. Next up, we have data analytics. So these are generally not kinetic systems. These are systems like the United States Project Maven, which collect lots of data, analyze it, and then provide intelligence to analysts rather than actually going out and attacking people or physically doing surveillance. And then finally, we get into logistics, which includes things like predictive maintenance, but also, healthcare for soldiers and personnel management more generally. And, a number of academics say that the logistical area is really where we should be focusing our attention for artificial intelligence, because these are non-safety critical systems. So if something goes wrong, there is not the possibility for mass catastrophe. So these are kind of the 4 broad areas where we saw activity in NATO's military AI systems. I want to just briefly touch on some of the security concerns that come up with having artificial intelligence in your military in the first place. So first and foremost, I'm sure many people here have seen these photos. Artificial intelligence, especially machine learning, is extremely brittle. It's fully based on the data sets that you have, which especially in the classified military arena can be very difficult to actually get your hands on. And it's easy to break these systems. So for instance, on the left, we have these images of stop signs in which people put just a few strategic stickers, and all of a sudden image recognition algorithms, instead of seeing these as stop signs, saw them as speed limit signs. And so all of a sudden, if you have an autonomous vehicle, it is not operating correctly. This photo of a baby with a toothbrush was incorrectly identified by an ML algorithm as a young boy with a bat. So again, you can see that they don't always classify things correctly, and especially in the military arena, that could be catastrophic. If there was a baby with a toothbrush that was identified as a young boy with a bat by a military system, that might be then seen as a combatant. And that could lead to unintended consequences. Or, conversely, it could do the opposite, in which a combatant puts a few strategically placed stickers on themselves, and all of a sudden they're seen as a civilian instead. There's also this big question of automation bias, in which humans tend to overtrust computers. There have been a number of studies that have shown this. And I also just wanted to kind of bring up one case study in which in the 2000s, the early 2000s during the Iraq War, there were several fratricides with the US Patriot missiles in which these Patriot missiles were in semi-autonomous mode and their human operators just over-trusted the systems, and it led to two fratricides. Actually, they were both very closely, they happened very soon, one after the other, which suggests that even after the second operator knew that this system could be flawed, could lead to fratricides, they still continued to overtrust in these systems. There are also big questions for nuclear stability that come with artificial intelligence. Many countries rely on their nuclear submarines and mobile ICBM carriers to ensure their second strike capabilities. However, if we now all of a sudden have autonomous vehicles everywhere equipped with data and analytics capabilities that can go out and hunt for submarines and hunt for mobile ICBM carriers, there's a lot of fear that this could undermine second strike capabilities. And certainly we see countries like the United States actively pursuing these technologies. The US has Sea Hunter, which is an unmanned surface vehicle whose goal is just to look for submarines. And then finally, we're seeing that the nuclear delivery systems themselves are being equipped with artificial intelligence. So France, Germany, and Spain are working on the Future Combat Air System, which will be a nuclear-armed, or a potentially nuclear-armed bomber that is using all kinds of machine learning, deep learning to do data analysis, to be able to fly with drones. And then we also see the Russians have developed or are developing the Poseidon unmanned underwater vehicle, which will be unmanned, will almost certainly use some form of autonomy, and is going to be a nuclear submarine. So we've already discussed all of the issues that come with using artificial intelligence in military systems, and now all of a sudden you're adding the nuclear aspect to these issues. So with that, I will turn it over to Amy for a brief conclusion. I think we've covered all we need to cover.
Thank you. I will be brief. So as Maggie's outlined, looking at NATO and the innovation that's happening, both through the alliance system, but also by member states, reveals a huge range of deployed and in development capabilities, and also a huge amount of challenges as well, in terms of how do you ensure that states cooperate, questions around interoperability, which we haven't touched on, but will be of major concern for NATO, how you secure these systems, and of course, what happens when you throw nuclear into the mix too. So loads of incredible questions, which complement, I think, some of the very valid ones asked by other panelists on responsible use and ethics as well. Thank you very much.
Thank you very much. That was really interesting. And now I would like to encourage our audience to ask questions by typing them into chat. In the meantime, I'm going to ask questions that I have in the order of presentations until somebody loses their patience and asks a question of their own. So I will, of course, then start with Raphael, who was the first to present. And my question is this. So given what we have already learned just this year about Russian and Chinese capacities to hack into very sensitive systems, both in the US and internationally, can remotely controlled or fully autonomous even drones with their multiple data streams and choke points be considered safe at all?
Excuse me, sir, can you repeat everything after Russia?
Okay, so yeah, so we've learned much about Russian and Chinese capacities to hack into even very sensitive systems already this year even. And given that drones and other remotely controlled vehicles rely on so many data streams and data choke points that can, of course, then be hacked, can these technologies be considered safe at all?
So thank you very much for the question. It sounds really interesting. However, to be honest, I think that the answer depends on the myopic prism that somebody wants to analyze this question. The truth is that indeed we have a lot of indication and a lot of evidence that China and Russia indeed use, although they are in experimental level, the employment of AI in UAV vehicles. In Syria, for example, we know for sure that the Syria was the perfect region, superpowers such as Russia, to put to the test these advanced and sophisticated technologies. However, actually, unfortunately, we don't have the chance of this data, and since all of them are classified, so we can assess which of them were really effective, which of them hide, risk behind these attacks, etc. As far as Russia, from a personal experience, I can also say that we have a lot of activity in the Baltics as well, in Syria. I'm not very familiar, with the Chinese activity, but indeed, this area is going to be really, really open to experiments for the next couple of years. Thank you.
Thank you. Now moving to Yeva, finally I have somebody to discuss new materialism with. And so my question to you is, so according to some of the new materialist thinkers, such as Deborah Lupton, for example, we are now constantly embedded within those more than human assemblages. And can this approach help reframe our relationship with technology, including with artificial intelligence for military purposes?
I think it not even can to reframe it, but it actually does it right now. I'm working with, I haven't mentioned it in my presentation, but on my final thesis, I'm working with Karen Barrett's new materialist approach, a gentle realism, and which got its inspiration from quantum mechanics and stuff. So yes, the aim is to reframe the conceptual framework, which defines the properties assigned to what is considered to be humane or technological. So it basically argues that there are no properties pre-existed to human and technology interaction. So yeah, just the brief answer would be that.
Thank you. I think
also, if I can interrupt, I have a question for Amy and Maggie. So if I can just ask it right now.
Of course, feel free to hijack the discussion.
Okay, so thank you. Very interesting presentation. And I, while listening to you, I was interested in just your take on this issue, whether it would be more efficient for NATO to have its aligned AI strategy, military strategy, or separate countries to develop their own military AI strategies, and wouldn't there be an alignment problem in that case? So it would be interesting to hear your take on that.
Well, Mag, if you're okay, I can take first shot. I think the purpose of a NATO military AI strategy would be different, because it would be more about, rather than national capabilities, obviously, it would be more about the alliance approach and consensus between members, whereas your national AI strategy would tend to, by definition, put your nation first. If we look at the wording of the US Department of Defense military AI strategy, it does talk about cooperation and consensus building, but very much, of course, it talks about maintaining the order that it sees of technological superiority, and it has its own lens. But also, when we look at when we talk about states bringing things to NATO, to the table, it probably will be the US or the UK. They are the most advanced when it comes to the resources and finance that they've put into military AI. They'll be bringing ideas across. So it's about what they want like-minded states, what they want alliance members to do to support them. Because it becomes like any other security challenge at NATO, your security depends on that of your alliance colleagues as well. So the US can put out doctrine, it can put out principles, responsible use, but it will be much more helpful if there was a consensus agreement on that and the alliance actually would make a statement supporting that.
Yeah, I'll just add on. I'll add on. Certainly, if we could come up with some kind of NATO consensus alliance, I'm certain that would be good for the alliance as a whole. But when you say, is that going to be an efficient process? I cannot possibly imagine it would. One of the things we saw is just how different NATO countries' thinking is on military AI. You see some countries who are like, we will never use it. Human controls everything. And then you see Turkey, who's, has loitering munitions equipped with machine learning and deep learning, which is, the opposite of having human control over artificially intelligent systems. And I think a lot of NATO countries, because there are, intra-NATO tensions, don't want to share all this, cutting edge technology with everyone else. It seems hard to imagine Greece and Turkey at this current moment sharing their most cutting edge technology with each other.
Okay, thank you. Also, have you published your analysis in some policy paper? It would be interesting to read it all in once.
We're hoping it will be something. It's currently going through a review process with the Cooperative Cyber Defense Centre of Excellence, at which point it will be open access. So we'll definitely keep as many people informed of that as possible.
Okay, thank you. Thank you.
Okay. Thank you very much for both the answer and the discussion that ensued. So if there's still nobody else, I would like to talk to Marco next. And my question to Marco is, to what extent, in your opinion, is an international regime on regulating ETDs feasible? And under what conditions would states be able to come to an agreement?
Thanks very much for the question, Ignas. My opinion, we have there's a big problem. We still rely on bilateral agreements that belong to the Cold War era, that were signed between the Soviet Union and the United States, that at that time were the only two so-called superpowers. Now, we all know that after the fall of the Berlin Wall, we remained with only one superpower, that is the United States. The United States thought that there were not any threat coming from the East. I mean, the Russian Federation was dealing with a huge economical, social crisis, etc., and China was very, very delayed. But China recuperated the technological gap. Now we all know that 60%, about 60% of the 5G patents belong to the Chinese industries that are controlled by the Communist Party of China. So this technological gap became increasingly tighter and tighter. And currently, China has developed the capacities that are beyond the one of the United States in some technological areas in defense. And Russia, I told you before that Russia, it's the only country so far that owns the hypersonic technology. So the United States are stay back, but are pushing since 2017. The Trump administration, Trump woke up one day and discovered the United States were sleeping, because they thought that this one were only regional powers. It's how Barack Obama characterized China. You are a regional power, but they are not regional powers. And just to close, so we have this old treaties that are bilateral, but at that time, nobody was worried about China. So China, in the last years, arose as a real world power, high-tech power, also in military applications with military weapons. But there's a problem, is that China is not interested in signing this agreement. This agreement should be multilateralized. But we have one country that is not interested, that is China. And once more, Biden, the new US president, on the 5th of February, asked the Russian President Putin to renew the so-called New START treaty that was going to expire that day. Putin agreed, so they renovated the agreement that was going to expire. But there's a problem that this agreement, it's about weapons that are obsolete. So they do not include the weapons that have been developed in the last years. That's why Putin did not did not refuse to sign the agreement, because it's about weapons that are so old that, I mean, that they are almost unuseful. So we have these problems. Just to update with new weapons, I mean, you know, treaties take a lot of years to be discussed within the international community before you come to sign it. But in the meantime, new technology arises. So they born old. They are already old. And finally, we have to multilateralize these treaties also with China, that does not want to be abided by international law. A lot of problems, you know. A lot of challenges. And just to close, just one more thing, because Maggie also in her presentation said something about kinetic. So it was just to come back to that the discussion, the question that I posed before in my presentation, is that we also need definitions, legal definitions. What is kinetic? We all know what is kinetic, but it's doctrinal, you know? It's in literature. There's not any treaties like conventional, not conventional, and so on. So we can go with this discussion until the end of the world, but I think that we need rules, and the rules should be clear rules. Thanks very much.
Thank you for the answer. And finally, I then turn to Maggie and Amy, and my question is, to what extent do you think will the employment of AI in military affairs, including lethal autonomy, become a race to the lowest common denominator, fueled by less scrupulous actors such as Russia and China? So essentially, if they allow artificial intelligence to make decisions on life and death, it will suddenly become counterintuitive and also strategically nonsensical for, let's say, NATO countries not to do that. So do you see that as a likely outcome? And if so, what does the future hold?
So there are concerns, especially when we do talk about things like an AI arms race. And of course, we've all probably seen the kind of US-China kind of AI debate about, you know, you got to do something or your adversary will do it faster. But actually, if you look at security and the fact that any Ministry of Defense is trying to be more secure, it's not really in any state's interest to engage in this race to the bottom. We think about any state that has or is thinking about AI capabilities at the moment. They aren't rogue states. They do have an interest in maintaining their security. So I take that line of argument to say there are aspects where actually there's such an important role for you know, consensus opinion and agreement on what responsible use looks like. That would be brilliant. But even if that doesn't come soon, we won't see this horrible Terminator-esque thing, because it's not in, that's everyone's worst nightmare. You wouldn't want to start that, I hope.
Okay. Maggie, do you want to add something?
Nothing to add, Amy. Amy covered it. Actually, I'll just make one statement, which is not actually related to this question necessarily. I will just note, I think I'm maybe the only American at this event. Definitely very interesting seeing the discussion in Europe versus in the United States, because it's certainly a different discussion. You know, in the US, of course, people are talking about ethical, legal, humanitarian stuff, but there's also this whole like strategic element to the discussion about, you know, Russia, China. That is very different. So I just want to note that it's very interesting to see this perspective.
I just want to jump in to reflect the Maggie statement. That's why I asked the question whether we should have separate strategies or whether we should have an aligned one, because of the US approaches, and for instance, ours are very, very different in many, many aspects, technological, economical, and any other aspect that you can imagine of. So again.
Yeah, and indeed, we are very happy to facilitate this, you know, what turns out to be almost intercultural dialogue in artificial intelligence, security, and other matters pertaining to our conference. So because I can't see any more questions, I suggest that we take a 5-minute break to recuperate, and well, 4 minutes now. And after that, we will tune into the final 5th panel on new technologies and disinformation. And because I think you have looked at my and Julia's faces enough today, I will hand the reins of moderating to Professor Aukse Balchitiene, who will be your guide through the final 5th panel. But we will, of course, stay in the loop very much. And let's meet again in 4 minutes.
Thank you.
I think it's time for us to get back on track with the final session of the conference. And the topic is, as Ignas has announced, the panel on new technologies and disinformation. Very interesting panel indeed. We will have 4 papers in this session. And to keep the same plan as in our previous sessions, and I'll invite all speakers to present their topics and their ideas, and then we'll go on into joint discussion. So it is my great pleasure to invite our first speaker. One moment, Anam Qureishi from University of Essex. And the topic is on insights from South Asia, a case of post-truth discourse in Pakistan. Anam?
Yeah, hello.
Are you ready?
Thank
okay,
you.
thanks a lot.
I'm ready. I'm just going to share my screen in a bit. Thank you, Ignas, for organizing this and inviting me to participate. Give me a second. I'm just going to share my screen. Can everyone see the screen, like my slides now?
Yes, that's correct.
Great. I'm Anam. I'm a doctoral candidate at the University of Essex, and I work on theorizing post-truth and the empirical illustration of post-truth as well. And for me, my interest lies within researching on South Asia specifically, hence the empirical illustration of post-truth texts in the electoral discourse of Pakistan. Right. I'm just going to, okay. So basically, with regards to research on post-truth, the gap in literature remains pertaining to the empirical illustration of post-truth. Most of the empirical studies that have been conducted rely majorly on misinformation and its influence on public opinion, not necessarily operationalizing the term post-truth and how that actually can influence public opinion, or rather even how that terminology can be used to assess certain texts to be categorized as being post-truth texts. Right, and the second limitation of current literature is that there is lack of research outside the Western Hemisphere. So a lot of research on post-truth has been done within the context of the United States, or the United Kingdom, or Europe, etc., but nothing has been done as pertaining to South Asia or Pakistan in particular. So what does my research really do? My research actually tries to devise an operational definition of the term post-truth, and then using that definition, it tries to qualitatively assess texts that can be categorized in post-truth. And the texts that I use are pertaining to newspaper articles that cover the electoral discourse in Pakistan. So basically what I'm doing is trying to devise post-truth or understand post-truth as an objective term. Right, and I identify 3 traits that are peculiar to post-truth narratives, post-truth texts, about whether they're in newspapers, whether they're presented as statements, and so forth. And the 3 traits that I identify refer to the Lacanian concepts of fantasy, of lack, and then emotionality. Right, and my definition, of course, is then within the context of political theory, ideology, and discourse analysis. And when it comes to the qualitative assessment of text that could be categorized as post-truth, I rely primarily on discourse analysis, specifically using the phantasmatic logic that Finnis and Howard actually proposed, and the Lacanian logic of lack and fantasy. Quickly going over the data, and then I'll spend most of the time discussing what a post-truth narrative looks like. I coded 1,205 news articles and opinion pieces on major incidents, trending political issues, and statements made by various politicians during 3 different electoral years in Pakistan. So there were 3 major English newspapers, Dawn, the News International, and the Express Tribune. The timeline for data collection was 3 electoral years, so newspapers from 2008, 2013, and 2018 were looked at. The coding there was a 4-step process for coding these particular texts to be categorized as post-truth in the end. The first step actually was reading all of these 100,205 articles in their entirety to highlight the main themes, such as politics, military, foreign relations, etc. The second step was to actually identify issues within these main themes, which were then further subdivided. So for instance, The theme of electoral campaigns, government incompetence of future political parties, was then subdivided into taking the concept of electoral campaign. So electoral campaign was then subdivided into the particular political party's manifesto and what they promised and so forth, right? So after that second step has taken place, a descriptive note was constructed comprising of all these themes of what these subdivisions actually really corresponded to. And the themes that were indicated of those three attributive traits that I will briefly touch upon in the next slide were then selected for further analysis for categorizing them into post-truth, right? And so what was the mechanism of categorizing those particular texts as post-truth? There was to identify a specific lack that the narrative actually discussed. It was to identify the fantasy that the narrative actually propagated. It was to identify the emotional element that was present within that narrative. And then lastly, it was to tie it all together and look at what the purpose, what was the phantasmatic ideal that was propagated, along with what was the purpose of the constructed narrative. And if a particular newspaper article did tick all of these boxes, or several articles that came under a particular theme of, let's say, democracy, ticked all of these boxes, we would categorize, or I categorize them as being post-truth in nature, right? So briefly touching upon what these three terms or attributive traits that I'm looking at. The first concept is the concept of lack. So in the Lacanian psychoanalysis, the idea of the subject of lack in very simple terms means the absence or the deficiency that an individual, or the aspirational tendency of a subject towards something that they feel that they do not have or possess right now, and they aspire towards achieving, right? So that's what the element of lack actually really means. In order to fulfill that lack, what we look at is the second term, which is the fantasy. It acts like a fantasy, then acts as it provides meaning to the world. It provides meaning to the reality, or like gives particular meaning of understanding how we perceive things, right? And so fantasy then operates to bring forth a closure for the subject's identity, right? And Glennis and Howard actually talk about, or they develop this idea of like, there are two dimensions of a fantasy that you're looking at, both the beatific and then the horrific. The beatific dimension is the one that would fulfill that lack for an individual, for them to feel whole or complete, for them to actually have fulfilled their aspirational tendency. And then the other side of it is the horrific dimension, which would perpetuate or sustain the status quo, sustain the lack. And that's because of a certain obstacle that is being presented, which would prevent from the lack being fulfilled. The third element obviously is looking at the phantasmatic logic of how it actually operates. And the logic of practice also, like taking a lot of my research actually does take a lot from Glennis and Howard's research on the logic, the critical explanation of logics approach, in particular the phantasmatic logic, where the phantasmatic logic tries to talk about how certain social practices and regimes or certain discourses are able to maintain their grip in their society. So on the one hand, the logic of practice comprises rules of grammar of the practice, the conditions which make the practice both possible and vulnerable, right? So on the one hand, logic is offering the continuation of practices, but it also actually is providing challenges for certain practices. And they identify three different logics: social, political, and phantasmatic. And I particularly focus on the element of phantasmatic logic and seeing how discourses do grip the society, how discourses are able to then fulfill a lack by propagating a particular fantasy. And the element of emotionality then in a narrative or in a particular newspaper text, there are various phrases that are used, various phrases that actually sort of create this fantasy of addressing a particular lack, right? So one of the examples in one of the themes that emerged through the coding process was that of democracy and democratization in the electoral discourse for all these 3 years. And so one by one, I'm just going to go over how it actually then fits the 4-step process, eventually being categorized as being post-truth in nature. The first step was to identify a specific lack that the narrative is offering, right? And we have various examples. The theme of the lack was the degeneration of livelihood of people by dishonoring their right of choice, right? And there are various statements either made by political leaders during their speeches or by opinion piece writers when they're writing like an op-ed in newspapers. And so one of the quotation, that's the first quotation, is that the rulers had also miserably failed to launch any welfare project for poverty-stricken masses. The incumbent governments had totally failed to deal with militancy and restore peace. So the lack here would be, let's say, the lack of welfare project for poverty-stricken masses, the failure of the government to actually deal with militancy or restoring peace, the fact that there's unemployment, the fact that there's poverty. All of these elements are sort of highlighting the deficiencies that are being perceived, or the deficiencies that do exist when it comes to the citizens of the country, right? And so that's particularly, so the fantasy that the narrative or the particular text is going to be addressing are these particular issues that are present in society. So the second step then is that the rhetoric of change that was highlighted in various newspaper articles was that it is only through the true restoration of democracy or democratic principles where the supremacy of citizens' welfare, the right of choice, can these deficiencies actually be eradicated, right? So you have the idea of what true democracy means. It means where the people's will prevail. It stands for justice, equality, and accountability. How everyone will be equal in the new Pakistan that will actually have after the elections. So we see how it is on the one hand, under this theme of democracy, the identification of a particular lack, and at the same time, offering or fulfillment to that lack is the idea of fantasy of how it's sort of addressing that. The third step was to identify emotional elements in the text, right, that were used to create the narrative. And so various phrases that were used in newspaper articles, such as the word inqilab, which means justice, Safar Inqilab Pakistan, which means journey towards justice and accountability, vote ko izzat do, which means give respect to vote, or tsunami. And so these words sort of, and then moreover, these words actually emphasize the importance or like the need for a true democracy to be present, where the will of the people would prevail, where the right of choice would be actually honored. And that is the only way where individuals will prosper in Pakistan, right? So all of these elements then leads to the fourth step, which was the identification of phantasmatic ideal and the purpose of the constructed narrative, right? And it is here that when you tie all of these elements together, you see that democracy does indeed act as a promise for citizens to honor their vote, their right of choice, to choose their leaders, to hold them accountable, and for them to actually feel that their voice matters, and that it is only when there will be true governance or proper governance that Pakistan could actually prosper, right? So what exactly is the phantasmatic logic and how it operates? We see that the narrative reflects ideals of redemption, of progress, of freedom and welfare, and that is exactly what the beatific fantasy or the beatific dimension of fantasy actually says, where it's like a positive fulfillment towards a particular deficiency or lack. But at the same time, we also do see that there are opposing identities that the discourse in democracy actually do propagate. And that is, for instance, for an example, is the Islamist discourse in democracy being an antithesis to Islam, or religious conservatism, which is in stark opposition to the ideals that is propagated by the fantasy of democracy, which is freedom of movement. And this is where we see how the horrific dimension of fantasy also does operate, where if indeed democracy does not take root in the society, it does continue the lack of Pakistan being in the middle of a hybrid democracy, right? So the obstacle then refers to two things. It refers to the inability of the change advocated through democracy being unable to take root because of an internal obstacle, which is the enemy within. And here we see it refers to the internalization of the conservative values. So the reason why the narrative would not resonate is because you think that democracy is potentially antithesis to Islam, that it is talking about freedom of movement or freedom of actually reclaiming public space, which is necessarily, and this is in context to an example that I would give further, which is about women mobility in public spaces, right? So on the one hand, it's the enemy within, or the individual, the subject themselves, that would resist the acceptance of such a discourse to take place, not accept it, would not vote for elected leaders, would rather actually not have a true democracy present. And then the ideals of democracy will not resonate with the individual, so that they don't identify with what democracy really means. Either of these issues would prevent democracy as a fantasy to actually take root, to actually to prove or to provide fulfillment to the subject. An example that I wanted to talk about with regards to internal obstacle was with the idea of how women mobility in public spaces is something that would come naturally, or would be assumed that is a part and parcel of what democracy has to offer. So it's freedom of movement under democracy versus society's conservative and religious values of parda, of a will, in terms of segregation that exists between men and women. That women are supposed to be part within the household and not be outside the household. So these internal obstacles, the resistance that exists within the subject to prevent from a narrative to be accepted, to prevent it to resonate from them, is the other side of how the idea of fantasy does actually operate. So it's not just the fulfillment of it, but it's also the lack of fulfillment of it, the lack of the discourse to entrench itself. So overall, what then happens is, if like a particular theme is able to tick boxes on all four of these elements, that it addresses the lack, that it has provided us with a fantasy, that it has provided us with emotional elements, and the overall story or the narrative that is created does sort of highlight of what the purpose actually was, how the fantasy does operate, whether it does address a particular lack. Do we then categorize that particular theme as being post-truth in nature? And that is what this particular paper tried to do, with highlighting the various themes and then categorizing them as post-truth, or discarding them as being regular narratives or regular electoral discourses. And that's where I will wrap up. Thank you very much.
Okay, thanks, Anam. Thanks for opening our session with such sort of locally focused, but actually insights that you are transferring also, and opening the floor for global interpretations. In our second paper, we are switching into Brazil, and I would like to invite Salvatore Solimano from University of Toronto in Canada to present his paper on Brazil's platform governance challenge, containing a new digital culture of disinformation. Please, Salvatore.
Thank you. Can you hear me?
Sure.
Great. Given that I'm joining from Toronto, good morning. I thought what I would do today is to take this whole debate of platform governance in the developing world and to problematize the dynamics of disinformation that we've been seeing in Brazil thus far. Now, just to put ourselves into context, of course, Brazil has been one of the hardest hit countries during this pandemic. These statistics are nowhere near comforting, but of course, with the rise of the vaccines, the light at the end of the tunnel, the good light at the end of the tunnel can be seen. Of course, it is not the purpose of my presentation to discuss why Brazil has been having a poor record with the pandemic, but maybe this man can give us a clue. Of course, Bolsonaro has been one that not only hindered progress against the coronavirus, but also tried to push back against it. And one of the many ways in which he has done this is by putting forward a continuous wave of disinformation. Now, Bolsonaro is not a very staunch fan of wearing masks. He's not the biggest proponent of lockdowns, but he's also a supporter of scientifically unsupported treatments, such as ivermectin or hydroxychloroquine. He's also one to warn against the side effects, which we all know of vaccines. Of course, they can turn us into a crocodile, and if they do, that's not his problem. If they don't turn us into a crocodile, they might make women start growing beards, or make men start speaking with effeminate voices. These whole blatantly false messages, we know that they can be resumed into one goal: to make the pandemic as inoffensive as possible so it can reopen. The agenda of Bolsonaro is clear. This is only a little flu. Es una gripezinha. The false messages, we know that they're being disseminated mainly in WhatsApp. I will explain why WhatsApp in a brief moment. But the question is this an unprecedented phenomenon? The media, pundits, experts tend to say that this COVID-19 disinformation wave is something new. It's a new phenomena. It's a separate instance of disinformation in Brazil. But in fact, I find that it isn't. To go back to see where the seeds have been planted for this phenomenon, we have to go back to 2018, to the Brazilian general election, which pitted Fernando Haddad of the PT, the Workers' Party, against Jair Bolsonaro of the Partido Social Liberal. Right? Just to provide some context, it's important to understand the dynamics of this election. At the time, the PT was in remarkable decline. Lula had been imprisoned, and Dilma Rousseff had been impeached. Distrust against the PT, given various corruption scandals, perhaps some of you are familiar with the Operation Car Wash, which was quite literally the political execution of the PT, it fueled a populist force in favor of Bolsonaro. And of course, the lying impulses of Bolsonaro and of many populists were flexed during this campaign. So some of the anti-petista disinformation messages, anti-petista being anti-PT, were of political, social, and religious matter. So one of the messages was that the former PT presidents Lula and Dilma colluded with Chavez Venezuela. Of course, it doesn't take much to realize that Chavez has been dead for almost a decade. The PT also was framed as those who plotted a failed attack against Bolsonaro. Some of you will remember that Bolsonaro was stabbed in campaign. And lastly, speaking to the sensitivities of evangelicals and conservatives, it was framed that the PT was promoting homosexuality in Brazilian schools, promoting gay kids and bottles with the with the heads shaped as penises. Now, of course, this is all false. Fabricated images also circulated. Here is the running mate of Haddad at the time. She seems to be wearing a t-shirt that says that Jesus is a transvestite, when in fact, the real image indicates that it's just saying rebel. A message that, by the way, for the deep state of Brazil would also be highly problematic. This is not an unprecedented phenomena. Again, this is part of a whole network called the pro-Bolsonaro WhatsApp ecosystem. I'm not the one to coin this great term. It's actually a scholar from the University of Virginia, David Nehmer, who came up with this description. Now, the organization of the pro-Bolsonaro WhatsApp ecosystem is quite clear. A few influencers, and I denote the word a few, are those to come up with these fabricated images, are those to come up with these false messages. And then a separate group of what you would call trolls, but here I call Bolsominions, are those to share the messages from one group to another. So here each node is a group, each edge is a Bolsominion sharing a false message. You can see that some groups are larger than others, some groups are smaller. After Bolsonaro won the 2018 election, David Nehmer himself said that the pro-Bolsonaro groups on WhatsApp will not demobilize after the victory. On the contrary, they would be more radical. I find that this prediction might have been a bit mistaken. What I argue here is that the pro-Bolsonaro has shifted its purpose from anti-petismo to COVID-19 disinformation. In doing so, I would like to lay a term that I call Brazil's new digital culture of disinformation. The pro-Bolsonaro WhatsApp ecosystem has become Brazil's new digital culture of disinformation. Now, what this culture is, for me, it's a niche environment where the broadcast of Bolsonarista falsehoods has been normalized, incentivized, enabled, and organized by a hierarchical digital network. Now, I want to just stop for a second on the word niche environment. Brazil has a remarkably regulated media environment. This goes back to its experience with dictatorship. In 1937, the military dictatorship of Brazil gave the government full rights to determine which news the population was going to get. Now, today, this hugely and vastly regulated media market takes the form of media conglomerates, the UOL network and the global network. What this means is that we're framing the pro-Bolsonaro WhatsApp ecosystem as a challenge to a tightly regulated media market, as a particular instant where one crack in the system was exploited. All right, how do I highlight this digital culture of disinformation? Well, what I look at is that the 2018 phenomena of disinformation, at the 2020 disinformation phenomena, we can look at it as two icebergs. Of course, the part above of the surface looks different. The messages are different. We are no longer opposing the PT, we're now opposing lockdowns. Still, what I argue is that, and this is perhaps a better way to understand it, even though the tip of the iceberg has changed, the submerged part is largely the same. What is driving these different messages, it may be different content that we receive, but it's the same structure that is allowing for the dissemination of these news. Now, I give two explanations here as to why we are seeing a new rise of a digital culture of disinformation. The first is that WhatsApp is the most widespread application for communication in Brazil. Right, you do not need internet to use WhatsApp in Brazil. There are partnerships, which means that, and this is important, poor Brazilians are also able to use WhatsApp. WhatsApp allows you to make groups. These groups can be public, and in particular, WhatsApp is not very well regulated. This may be because WhatsApp has end-to-end encryption. We can see what you share on Facebook, but we can't really see what you share on WhatsApp. Perhaps more interestingly is to look at the user. So what I'm proposing here is an explanation that works on a platform level and a user level. At the user level, how do we explain who these Bolsominions are? Well, I propose three explanatory variables. Note explanatory, not predictive. Now, high distrust. Bolsominions are highly distrusting of both the PT and of the lockdown and the measures. They're ideologically motivated. In the election, they were not so much with Bolsonaro as they were against the PT. Right now, they seem to have changed this. The nuances might have changed here because they're more behind Bolsonaro. And then secondarily, against lockdowns. I hope the nuances come through there. And of course, they're highly exposed. Now, 98% of Bolsonaro supporters are exposed to disinformation. And close to 89% of them believe them to be true. And this might be problematic, but it's even more problematic because 6 on 10 Bolsonaro supporters get their news from WhatsApp. This is highly problematic. Now, as I finish my presentation, what is the future of the pro-Bolsonaro WhatsApp ecosystem? Well, Lula's back. Lula is out of prison. His corruption charges for Operation Car Wash have been dismissed. And there is say that he might run in the 2022 election. Let me emphasize that. The election is next year. The campaign is starting this year. I expect this information in Brazil to come back to its anti-petista impulses. Why? Because the PT now is no longer delegitimized as it was in 2018. Now it's Bolsonaro. These dynamics might be, of course, I'm not interested in speculating here. But what I tried to highlight here is that the dynamics of the 2018 election have been reversed, where Bolsonaro is the one being delegitimized, and the PT has the strength, the upper hand, if you will, the moral upper hand, if you will. What will this look like? This is up to speculation. Now, what to do? Of course, I started this by saying that my objective was to problematize the issue of platform governance. And I'm afraid I have. I'm afraid I'm leaving you with little solutions and even more problems. One of them would be, of course, to say that we should increase the costs of Bolsominions to share disinformation. This is something done on Facebook, this is something done on Twitter, this is something done on YouTube, but the platform nature of WhatsApp will not allow this. It's important now to reconsider to reconsider the structure of WhatsApp and to propose networks that, let me highlight this, would make the cost of sharing this information on WhatsApp even higher. What this looks like is up to discussion. So thank you very much. I hope you now have a clear sense of what's going down in Brazil. The Lula news came last week, so this is very much a chapter that I had to add literally yesterday. So I hope you have a clearer picture now.
Okay, Salvatore, thanks very much for your inspiring presentation. I would like also to put a notice to Anam and also Salvatore, please take a look at the chat area, at comments area, and you have already some questions there. So meanwhile, we move into some other presentations. So please take a look at the questions and we'll go back to those when all the 4 papers will be ready. So now I would like to invite our next presenters, Alex Hardy, probably the main speaker, and the paper is presented by Alex Hardy, Nicholas Robinson, and Martin Brown from Royal Holloway University in London. And the topic is Russian digital diplomacy, the Baltic states, and contested memory. Very hot topic. Thanks.
Thank you very much. I'm just going to share my screen, if that works.
That's okay, we see it.
Wonderful. Okay. Okay, can you hear me?
Okay.
Oh, it's okay to continue. Okay, thank you. Okay, thank you very much, and thank you to our organizers for organizing what's been an interesting day so far. So today I'm going to discuss what I hope is an interesting topic, both for the resident university, but for everybody. Russian digital diplomacy, the Baltic states, and contested memory. So I'll begin by providing us with some context, and I'm just going to make sure we're on full screen mode, so you're not looking at nonsense. So some context for our study. Now, I'm sure many people are familiar with the context of Russian digital diplomacy in the modern world, particularly on Twitter. The background for this research is a growing academic interest in digital diplomacy and suggestions that Russia is becoming an increasingly aggressive cyber actor, utilizing both softer forms of power, such as battles for information. We also have an interesting domestic context within Russia at the moment. We have seen something of a rehabilitation of the Stalin era. Of note, perhaps last year, was Putin's war essay, where he contested some of the topics we will discuss further. And also we've seen a certain amount of domestic stagnation from continued sanctions from the West. What is also worthy of note is the continued poor relations between the Baltic states and Russia, which are possibly at their lowest point in the post-Soviet era. And this plays out digitally as well. What we see from diplomatic accounts from both Russian and Baltic sources are continual attacks from both sides in disagreement, particularly over memory of the Second World War or Great Patriotic War. It's important to note this is not just coming from Russia. There is a contested Baltic relationship with the Second World War, memory of the Second World War, particularly in reference to the Holocaust and some of the events of that era. We have also seen a mirror image of this in Central Eastern Europe, some of the laws passed in Poland regarding the Holocaust. And also, we can also see elements of laws which have prompted a Russian response. This can be seen in terms of the platform of European memory and conscience, and also memory entrepreneurs and legislation in the European Parliament, which has prevented the discussion around these areas. Next page. So, to discuss some of the methods and analysis which the paper addresses, largely this paper is driven by content analysis, and also it's a form of a digital ethnography. We have identified exclusively the MFA Russian account as the source to study this form of digital diplomacy. Why? Well, this is the most notable English language account of the Russian Federation. Now, what we also see are individual embassy accounts. However, the MFA Russia account in English has been labeled by Ilan Mana, a digital diplomacy expert, as a driver of disinformation. And this appears to be, when we study individual embassy accounts, the real source of much of this information, which is then strategically retweeted and elevated and interacted with by different individual embassy accounts. So we decided to focus entirely upon this and entirely upon the English language account. It is notable there is a Russian and also a Spanish account, as we can see from the image displayed on this slide. It is noticeable there are almost 300,000 followers of this account and is regularly interacted with by MFA officers within the Baltic states, notably former Estonian President Toomas Ilves, frequently argues with the account and its interpretations of history from 1939 onwards. In terms of the data we have used, now there is a serious amount of data put out by the MFA account because it's talking about basically everywhere in the world. We chose to focus primarily upon the post-Crimea era to the present day, as we mark that as a severe departure of relations between the Baltic states and Russia. Relations have been poor generally since the collapse of the Soviet Union, but markedly worse since that date. We chose to focus on dates from the very beginning of 2014. The Crimean annexation was in May that year, up until the end of 2020. So we have a 6-year time period. In terms of the data we have accessed, we have identified a series of terms, ensuring that tweets are relating to the Baltic states and some of the key debates around that area. So search terms included, of course, the names of the states, the Baltics, Baltic states, and various also battles from the Second World War, which have become sources of contention, and also the argument of occupation versus liberation, which will be discussed further in this presentation. So what we see, we accessed over, I think it was 216, yes, 216 tweets, which refer to the Baltic states, coming from the Russian MFA account in that time period.
Alex, may I intervene? We just see the first slide. Are you changing your slides?
I am, yes. Okay.
Now we see codes and results.
Okay. That's unusual. Okay, but you can now see the codes and results.
Yes.
I'm sorry, so we've missed the other pages.
Methods and analysis, codes and results now.
Okay, thank you very much for highlighting that. I did not realize that was happening.
That's okay, thank you.
Okay, thank you. So, I apologize, you've missed the other information, but we're on to codes and results. So, we can see from the 216 tweets that we have accessed in this time, after conducting a content analysis, we identified a number of important codes. What we found are 3 particularly dominant codes, 1 slightly minor code, which may also be expected, and then a series of miscellaneous as displayed in our graph here. Now, we found somewhat alarmingly that 15% of all tweets sent in that 6-year period were essentially labeling the Baltic states as Nazi sympathizers or as Nazis in some way or another, or collaborators during the war period, which is an interesting way of conducting digital diplomacy. On top of that, as has been seen and evidenced by President Putin's essay published last year, this notion of contested history and differing historical accounts, which vary between official Russian accounts and the accounts of the Baltic states. We also see what is a consistent theme throughout this period. We have labeled this as Russophobia. Now, of course, we can argue whether Russophobia is actually a thing. This is the term that the Russians use to describe discrimination against Russian speakers in the Baltic states, or that is how it is perceived by Russian official sources. Now, that entails usually how they perceive issues of citizenship and also of Russian language speakers, primarily in Estonia and Latvia. Lithuania does have a very small Russian-speaking community, and there are different political contexts there in terms of citizenship. So largely those tweets target Estonia and Latvia, and they frequently also discuss the presence of Russian language media, which they perceive as being under threat. The minor codes, which we have largely disregarded for the rest of this study, of course, we see NATO here, 2.9%, and this is largely to do with the NATO enhanced forward presence in the Baltic states, which has been a continual source of anxiety for the Russian government ever since it was introduced. Of course, they heavily opposed Baltic membership of NATO, as they felt it was encroaching upon their near abroad. And finally, we have a series of miscellaneous tweets. That's not to say that some of these miscellaneous tweets are always inoffensive. Some of them are often quite combative. Overwhelmingly, nearly every single tweet in this series was combative and attacking the other side. But we will focus next on our three dominant codes, which form the base of our analysis for this paper, which is the Balts as Nazi sympathizers, contested history, and Russophobia. Okay, so the first theme, contested history, and this is largely driven by this debate of occupation versus liberation. It frequently takes a combative tone, and crucially, what is interesting, and one of the key questions this paper poses, is why exactly Russia uses such combative language to essentially diplomatically interact with the Baltic states, because they know that this is offensive, yet they continue to do it. And we can see an example of one of the tweets that we accessed here, the occupation doctrine. And this is essentially tapping into contemporary Russian political debates, which suggest that the three Baltic states were actually willing participants in the Soviet Union. And what we see now is increasing efforts to whitewash that history. We see various imagery, and this is heavily promoted. So, for example, this tweet was also retweeted by Russia in Estonia, Russia in Latvia, Russia in Lithuania. And you can actually see the Russian accounts often seem to be ratioed, which for those unfamiliar with that Twitter parlance means that more people are actually arguing with it than retweeting it or favoriting it. They know that this is offensive to local Baltic populations, but they do it anyway. Similarly, the second theme that we come is the debate around Nazism. Now, perpetually in these tweets, as we can see as an example here, the Russian MFA account likes to portray the Baltic states as hives of Nazi sympathizers and revisionists. Regrettably, this is not always without a shred of truth. In fact, all of these three dominant strains do have a shred of truth. What you can see in the image here is the Lihula monument, which is in the outskirts of Tallinn, which commemorates Estonian soldiers who fought in the Waffen-SS. This is still standing, and it is far from the only monument within Estonia. This has also been widely researched by researchers such as Anton Weiss-Wendt, who has discussed why the Baltic states have particularly strained memories with the Holocaust. We also see, as the tweet is highlighting and heavily elevated, the unveiling of a bust of a former Waffen-SS soldier, Nugi 6, which was unveiled in a school. And this is not an isolated incident. These monuments aren't everywhere, but they do continually exist in all three Baltic states to some degree. Now, the Baltic narrative around these is these people were fighting to defend their homeland from perceived Soviet aggression. However, the way the Russians perceive this is that the Waffen-SS was entirely volunteer. These people were not conscripted, and they were also involved in acts in the Holocaust. Finally, Russophobia and the debate around Russian speakers' rights and, of course, citizenship. Now, as I mentioned before, this is primarily targeting both Estonia and Latvia, where this is a stronger debate. We see strong clusters of Russian-speaking populations in both the Latgale in Latvia and in Iraviduma in northeast Estonia. These people largely live on the borders, and they are deprived of certain rights of citizenship. We see grey passport holders within Estonia, which are not full passport holders. They have certain rights that are recognized within the European Union. However, they cannot vote in local elections, and there is still roughly around 5% of the Estonian population who are disenfranchised. This debate is also extended and elevated by the Russian MFA, who claim that this is also linked to discrimination of rights in education, which has been a contentious source of debate in Estonia, essentially since the collapse of the Soviet Union. So while there are shreds of truth within all of these themes, what the Russian accounts do is elevate and heighten concerns because they know that these are divisive and they are problematic for the society, particularly in Estonia and Latvia. So to conclude, it has been argued that digital diplomacy is revolutionizing the way in which politics is conducted. Based on this study, we are not entirely convinced of the revolutionary potential. These are essentially a continuation of squabbles that have been going on between the Baltic states and Russia since the collapse of the Soviet Union. Very little has changed in terms of what is being said. If you look at diplomatic communications and statements going back to the early 90s, and even in the collapse of the Soviet Union, they were equally as combative as they are today. The difference is that digital diplomacy provides a much larger audience, and it also allows people to engage with these accounts. There's an everyday reach to this information, and there's a greater volume of it as well. The trouble with this, it's very difficult to measure how effective this is. It is worth noting in context that, for example, in Russia, Twitter is something like the 8th most popular social network. It is very limited in terms of how many Russian users engage with Twitter. And similarly in the Baltic states, Twitter is not all that popular. This is all conducted in the English language, so it's clearly intended for an international audience. What we do see, however, is that this debate is now far more widely noted, and it reaches a much wider audience because of Twitter and the way that these are played out. Arguably, figures such as Thomas Ilves, who is now probably the most noted former Baltic president, who has a very big profile on Twitter, and he's also a US citizen as well. He's a key figure on Twitter, and he argues with these accounts constantly. Now, arguably, by doing that, he both legitimizes the debate and he also elevates it to a wider audience. But in terms of conclusions we can draw right now, largely business as usual. How effective it is unclear. It doesn't seem that it's effective diplomatically, but that is possibly not the goal. This is just simply a continuation of domestic politics playing out on an international scale in English. And I think that's my 12 minutes. So thank you very much.
Thanks very much, Alex. That was really eye-opening again presentation. Thanks very much.
Thank you very much.
So I would like to invite our presenters for our last paper, the 4th paper. And I'm addressing my colleagues, Kristina Jureite, and I just saw that Inessa Bunavicene has entered the room. But the presenter of the paper is Kristina Jureite. So the topic is Reinventing Evidence-Based Journalism in a World of Toxic Information. So Kristina, please, the floor is yours.
Hello, everyone, and thank you, Alex, for introducing us. It is a pleasure to be part of this international conference and networking on the most recent technologically driven transformations in different spheres, political, social, also media, and sharing insights from different research angles and approaches is of great importance, value, but also academic privilege. I would say privilege in this new pandemic reality when we are forced to stay online, and there are not so many other opportunities to engage, to discuss, to collaborate together. So that's a great chance indeed. And Also, I wanted to start from a little bit further, as this conference has been supported by IREX, Media Literacy in the Baltics program. I just wanted to inform that we in the Department of Public Communications at Vytautas Magnus University also implemented an educational project addressing educational needs of media literacy for future journalists, for citizens in general. And also this has been a great opportunity for us to extend media literacy research. So the presentation of today is focusing on the situation of journalism, on the opportunities and challenges of journalism in a world of toxic information. So why journalism? Why should we consider it in this discussion? So the main point of departure in this presentation is that it is vital to understand the transformation and value of journalism in the changing media ecosystem. We believe that more emphasis to evidence, facts, research, and transparency may improve the quality and credibility of the news media, which is of great demand in the times of flux and deep uncertainties. We've been talking and heard today speakers addressing the changing media ecosystem, which requires knowledge and skills for users to tackle very complex and dynamic and often toxic information and communication environment. Furnished by technological innovation, platformization, datafication, and many different channels available, which of course are shaping news production and consumption processes, including user-generated content, opinionated content, inaccurate reporting, poor quality of journalism, etc. Apart from that, the pandemic environment, coronavirus outbreak in the world boosted dissemination of disinformation, half-truths, conspiracy theories, different information disorders have been accelerated, which became even more challenging to discern between reliable statements, arguments, facts, and different kinds of falsifications. Recent research shows that the lockdown significantly affected media consumption practices and especially boosted online news consumption. So on the other hand, we could also witness increasing polarization, discrimination, loss on sensitivity, moral blindness, lack of trust and solidarity, apart from information overload and emotional fatigue. So this is a very challenging and complex environment we are dealing with, we are all living in, and we are coming to the point how to support, how to make media more resilient. And we believe that to support media resilience, news media resilience, cooperation between professional journalism and public is needed. Talking about media literacy education, we believe that it provides with critical competences and skills of critical thinking, creativity, collaboration, communication. And this is the framework which can increase public resilience, immunity to false information, This is the way citizens can self-protect against disinformation, take responsibility, join the dialogue, collaborate on a common cause. Also, professional journalism, with its key mission to expose what is true and what is important for the public. In this sense, the role of journalism is becoming critical in the times of controversial information. So while very challenging, this transformative moment might also be seen as an opportunity and a new chance for journalism to improve itself and in some sense to make or remake itself. So with these ideas in mind, we did inquire journalists and media professionals about their work practices, challenges during the pandemic, also those in relationship to disinformation and changing information infrastructure. So we will share the main results of the research in the following slide, but I just want to briefly address the question, why evidence-based journalism? In terms of future journalism, its health and quality, we think it is of great importance to look for new ideas and concepts that can be helpful. In this sense, our idea is that science journalism based on evidence-based paradigm could be a model for the future journalism and news media industry. Giving the reader the evidence rather than opinions or only comments, providing facts and research in a transparent way may improve the quality and credibility of journalism and build trust in news media, as well as promote informed decision-making and democratic discourse. Well, in the project funded by Erasmus Plus program on the topic of enhancing research understanding through media, we conducted an online survey of journalists and news media professionals in the fall 2020, with the aim to better understand how current reporting practices are shaped by the challenges, technological challenges, pandemic challenges, disinformation challenges. What are the values, standards of journalists' everyday professional activities? The online survey was conducted with the help of our partners. So the data comes mainly from 4 countries, Lithuania, Austria, Greece, Cyprus, and other countries which were less represented in this survey. The total number of respondents was 197, and the online questionnaire was using closed and open-ended questions. There have been lots of data, of course, but we think we would like to point out 3 main points or 3 pillars to consider building a sustainable and responsible future for evidence-based journalism. The most recent changes in media ecosystem suggest that future professional journalism is not so much about information dissemination, but instead about being reliable and trustworthy, credible. It's not about a set of some required skills journalists have, but it's about ability to grow and learn continuously. And indeed, it is still about the same professional ethics and integrity. Talking about social responsibility, of course, the professional ability to verify, check information, distinguish true and false news is of great importance, especially in times of disinformation, in times of vulnerable and toxic information environment we are living in today. So educating and empowering people for better informed everyday decisions through professionally selected and covered news is essential, and it should be seen as an opportunity for media and journalists to move forward and start a new and more socially responsible era of journalism. So we feel quite optimistic in terms of the potential of journalism and journalists, while also we were interested and inquired about the major challenges. Yeah, disinformation has been one of the major problems news industry is facing with, but even more challenging for news environment is that journalists feel very skeptical about readers' media literacy skills, their ability to distinguish, to discern facts from false information. Although their own skills and abilities are assessed as quite important and quite strong. In terms of measures, what could be the main ways to improve media or journalism situation and to support media resilience? Of course, the financial investments in professional journalism and different types of journalism, including investigative journalism, evidence-based journalism, were mentioned, but also improving public media skills has been assessed as one of the main measures necessary to address the toxic information environment, rather than technological solutions which are available and which have been exploited, however, not so often. And as we provided with a question with different technological tools, it appears that most often respondents would verify information using reverse image search tools, as well as fact-checking websites. So in this slide, we list the main measures or solutions to strengthen media resilience, and the answers selected as most important, as having strong impact on media resilience, are highlighted in bold. Talking about the growth mindset or values, attitudes, commitments of journalists to news media industry, we asked what makes a good journalist. And here you see the most popular answers in terms of values like journalistic independence, reporting the facts, ethical standards, investigative reporting skills, passion was also mentioned as an important stake, important value in journalistic occupation. And interestingly enough, degree in journalism has been assessed as the least important in this case. We also were interested what are the stakes and what are the challenges for journalists in the pandemic times, in the coronavirus outbreak. And most of the challenges are related to the increased coverage of the pandemic as focus to the health issues, to the reporting on pandemic situation has increased a lot, as well as other issues have been ignored or were not addressed in sufficient way. Also, journalists feel information overload during the pandemic, and this shows that the real challenge for journalists was not related to the professional skills, understanding, verifying information, but rather escaping from the bubble of the COVID-19 information and being able to see a larger picture, which requires flexibility, adaptability, ability to react in the professional way and using based on professional standards and principles. So the final point in this presentation is professional ethics. And of course, it was interesting for us to learn, so what is the role of professional ethics in the daily life, and the answers illustrated support the idea that professional ethics, ethical standards are very important in journalistic occupation, in everyday reporting or work practice. And that's again shows us some kind of continuation of the journalistic norms and mission to keep up with most important standards of journalism: truthfulness, accuracy, fact-checking and verification. Also responsibility and transparency. So in conclusion, while very challenging, this transformative situation with new communication infrastructure and media configuration, it also can be seen as an opportunity, as a chance for media and journalists to reflect on their practices, to reconsider their mission, values, to grow stronger with a new vision and with new future. And we hope this is a chance for journalism to improve itself and in some sense to remake itself, being more reliable and trustworthy. And evidence-based approach in journalism has a lot to offer to the public in terms of truthfulness of information, transparency, responsibility, and intelligent democratic discourse. In this way, evidence-based journalism or science journalism can be an exercise in truth-telling and democracy, as well as an important actor in a new information and knowledge ecosystem. Thank you.
Okay, thank you, Christina. So now we have some 20 minutes or so, and I would like to invite all presenters, Anam, Salvatore, Alex, and Christina. We have quite a number of questions in our chat area. I hope you have looked at those. Listening to all the presentations, I was really not surprised, but I felt well, empowered, since we live in an interconnected world. But the interesting issue is that we cannot ignore culture, we cannot ignore context. So in everybody's presentation, culture came out in one or another manner, and we cannot ignore history, we cannot ignore our past. It kind of sits with us and shapes the way we even nowadays deal with such a burning issue as disinformation, and we are looking for new means to combat it. So I would like to go then into the chat area, into the list of questions, and I would like to start with the first one. Then Ignas has asked Anam the question that how would you relate your emphasis on lack and democracy to Derrida's claim of democracy as something that is always to come? So would that suggest that democracy is always a fantasy that is open to post-truth?
Thank you for that question, Ignas. And the short answer is definitely yes. And I feel like it's the reason when I actually categorized this particular theme under the label of post-truth and had a discussion about it recently as well, the idea was the only reason why democracy in the Pakistani electoral discourse is being categorized as post-truth is primarily because of the way that it has been illustrated in these news articles and so forth. Right, and so the way that it's portrayed actually does sort of indicate towards the idea of it could be labeled as being post-truth versus the concept not being categorized as post-truth if it was reported in another context or another geographical context, for instance. Right, so the idea of whether it is something that it has to come, whether it be open to, whether the fantasy would always be open to being labeled as post-truth, it could be, because it depends on what tenets of democracy are being discussed, or what exactly is the fantasy that democracy is sort of advocating in, let's say, in a Pakistani context versus in a United States context, right? And that is very much, and that then sort of then is very important, becomes pertinent when we label certain discourses as being post-truth versus not labeling other discourses on post-truth. So in the Pakistani context, yes, I can actually defend that the way that it has been presented, the idea of like what a true democracy could entail for the Pakistani society, it does offer insights on it being post-truth. I hope that answers your question. Thank you.
Ignas, would you like to react, respond? Okay, maybe not at this moment. I would like to go then back to another slot of questions. There is Dimitrios asking, and he's addressing a question to Salvatore. My question goes mostly to Salvatore. What is the interplay between the citizens' duty to critically view news sources and the weaponized dissemination of disinformation? And then I think a related aspect is that Anam is referring also, how do we expect citizens to critically view news when they are constantly surrounded with a specific filter bubble, feeding them with a specific version of reality? I think those two questions can almost go to all four presenters.
Right. So thank you for those questions. The questions highlight the problem in many ways. What I would respecify is that this is not something that is done against citizens. This is largely something that comes up out of civil society. This is something also that happens underground, as opposed to the Chinese 50 Cent Party, as opposed to Russian trolls, as opposed to Saudi hackers. This is not something government sponsored. The Bolsominians are average Brazilians. They live an average life, and they have a WhatsApp account. What I would highlight again is not necessarily the issue of culture, it's the issue of the political atmosphere. No one is left indifferent in Brazilian politics. Something that I find extremely interesting is that this is not my idea, this is something well established, is that in Brazil, you're either for or against the PT. And if you're for the PT, you will engage in motivated reasoning. This is by a study by Samuels and Zuko. If you're against the PT, you will try to cast the PT in an immoral light. This is why we see those types of disinformation, right? That the PT is, spreading homosexuality. The PT is with Venezuela. We speak of a citizen's responsibility to counter this, but I speak of a citizen's ability and capability to actually discern what's true and what's false, what Pennycook and Rand at MIT call bullshit receptivity. Can you really discern the facts from the disinformation? In many ways, I think the genius part of this campaign is that it masks itself as news. That's often a problem. I think in many ways, Christina's presentation is a great answer to those two questions. I think the parallels are just extremely relevant there. The role of media is not lost in Brazil. This is not something, Christina might be an optimist about it, but I'm more of a pessimist that wants things to go well. What I would say is that the media still has a role to play. There are fact-checking agencies that have quote unquote infiltrated the pro Bolsonaro WhatsApp ecosystem. I think if anything, that is the best shot. But I would again point to the political atmosphere. This is a general question, but the answer will always be context specific.
Thanks, Salvatore. Would anybody of you would like to continue on the same note on the role of citizens, or maybe of the availability of arenas, of platforms where those kind of highly polarized discourses could meet and be discussed?
I probably could jump into, because I also see a question from Irene about the responsibility of platforms and also the role of I don't know, responsibility and collaboration with the news media. I think that should be also addressed, that yes, platforms are part of this new information ecosystem, and they definitely play the role in making citizens informed, and they should be responsible. This is their responsibility. I see some good examples too. For instance, in Lithuania, we have the main news media outlet Delphi working with Facebook in terms of fact checking or monitoring the information environment in the social media. We also see legislative instruments introduced, newly introduced, coming from the European Commission initiative, again, to encourage platforms to work with or to implement democratic principles and become more transparent, also contribute more to the democratic dialogue and less toxic information spread. But of course, these examples are only few, and they have been political, sociocultural, economic challenges too, which affect news media for sure, journalists for sure, and yeah. There are many obstacles in the way, but I think again, looking at the broader picture and again involving different actors, working together, collaborating, sharing, and coming up with the same ideas, that could work.
I think sometime earlier today we had a discussion about conceptual kind of neatness in different definitions. So whether even there is ongoing a discussion on what the platforms are these sort of publishers? Should we treat them as publishers or as kind of content disseminators? That's completely different sort of conceptual framework is needed. So we are still quite young in defining different conceptual definitions for the phenomena that is already taking shape, that we already have a history of living with those. But here I would like to go into the question that Yeva has formulated to Alex, and I hope Alex has read the question, and I will quickly read Yeva's question. I understand the COVID-19 narratives were out of the timeline of your research. However, have you looked into recent Russian MFA tweets, whether they do employ those narratives? Like Sputnik vaccine, etc. So Yeva is just interested how Russia is adjusting its public diplomacy to some fresh issues.
Yeah, so interestingly, yes, the Russian MFA account does discuss it, but Sputnik vaccine, as far as I'm aware, is the only vaccine that has its own blue tick Twitter account. So there's actually an officially recognized Sputnik vaccine account, which is again strategically retweeted and elevated by these different accounts. It strikes me as that it's very coordinated in the way that this is done, but of course, without actually speaking to someone at the Russian MFA and then being prepared to give me those answers, it's difficult to say. But yes, short answer, they are definitely using this as another tool of soft power, not just within the Baltic states, of course, but promoting it much wider. I believe on that account there is also a tracker of now how many countries have approved it for use, and they are constantly arguing that it is safe, arguing for the efficacy, publicizing news, and how wonderful it is. Now, there would be a very good argument that perhaps the Russian MFA and the Russian government should be looking closer to home in terms of trust in that vaccine, because trust in the vaccine in Russia is remarkably low, most polling suggests. So yes, they are using it as a diplomatic tool, and of course they were very keen to rush the approval. When it became clear that Pfizer was going to be approved, the Russians and President Putin exclusively issued a decree to make sure that it was the first one that was approved globally. That was a big win for them. And in terms of, to bring it back to the Baltic states and what we were talking about, will Sputnik be used in the Baltic states? Possibly. Now, what we've seen so far in terms of discussion is that everybody has deferred to the European Union. So if this is ever deployed in the Baltic states, it will be bought under the EU program of vaccine purchases, and that's a big win because they can't be seen to be taking this vaccine from Russia. From a public diplomacy perspective, local population will be resistant to it, which we've seen play out in Ukraine, which is of course not part of the European Union vaccine purchase program. and it's just political poison. So even if we have proven efficacy of this vaccine in Ukraine, it will not be deployed. It is quite possible, and there has been discussion of this in the media, where both the Estonian president and the former Prime Minister Jüri Ratas spoke of this, basically saying that they would not actively be looking for the vaccine, but if it is sort of distributed by the EU via an EU purchasing and distribution act, then yes, it will be distributed. So absolutely, they're using it as a tool of soft power, along with many other different things that's going on. It's difficult to keep track of absolutely everything the Russian MFA is doing. They are doing this digital diplomacy thing very well, and we're arguably all trying to keep up with it. The UK account is very prominent, as well as it became apparent during the skip roll poisonings, and they reach a very wide audience. So yeah, COVID-19 is absolutely a part of that.
Okay, thanks, Alex. Certainly, we see that disinformation is such a phenomenon that cannot be approached just from one disciplinary perspective. We need historical knowledge. We need kind of awareness on how new media and how new media logic functions. So we need a lot of information, but also we know that again this sort of phenomenon cannot be approached also by kind of one taking. So we need help from journalists, from classical news media, from academia, think tanks, citizen groups, policy, and regulatory decisions. So thanks very much for this really interesting panel. We still have 1 or 2 minutes maybe before we go into our next and probably it's called the final session for today. Maybe you would like to say a sentence as a closing statement for your presentation. Please go ahead if you would have to.
I don't quite know how to summarize mine in a sentence. I'll have a go, I suppose. Digital diplomacy, certainly within the context of the research we've been doing, is simply diplomacy via other means. It's more everyday, it's more accessible to ordinary citizens, perhaps. But this is all, you know, this is new. It's largely being done for show. It's not for domestic Russian citizens, and arguably not for Baltic citizens either. This is playing into a wider geopolitical narrative. Is that a sentence? I feel like that.
Yeah, that's very good. I think exactly, Alex, from your presentation, when you finally said that we do not know what's the goal, what's the point why Russia is doing that. Probably it's just messing up everything. So we know that there are not only attacks into Baltic countries, informational campaigns, but there are many old democracies in Europe that are under the focus of Russian disinformation campaigns. And it seems like there is no clear target, but just messing up. And we have had this history for about 30 years already in this part of Europe.
Mm-hmm. And some of the arguments are, of course, that the Baltic states are more naturally resilient to this because they became accustomed to it during the Soviet era. So one of the questions we were grappling with in this paper is actually how effective is this in terms of hitting the local population, and largely the conclusion is not very. In terms of the voting numbers, we don't see any great influence that way. But right, how do we measure this? Mm-hmm. How we measure what some of these narratives are? Because, I mean, looking at those key themes identified within that research, they're not really achieving anything. I mean, some of it's just insulting, and it's deliberately so. But it's playing to a domestic Russian audience, but also trying to shift wider public opinions. Mm-hmm. It's the best conclusion I can offer.
Okay, thank you. Christina, Anam, Salvatore, would you like to finalize?
If I may, I would respond to Kaspar's question about the low ranking of journalism education among journalists we interviewed or who responded to our questions. So yes, indeed, this is very low ranked. But I would look at this again more globally, and think that journalism, news media industry is undergoing transformation. Journalism education must change too, in lines with the changes. So that would be the solution, as well as educating public on the role of journalism. In terms of media literacy package, I think that's also the idea, and that's how we can strengthen media and both the society in these challenging disinformation times.
Thanks, Christina. Anam? Would you like to say kind of final statement, or are you content with your presentation?
My internet is being unstable, but I think, can you hear me? Because my internet is being a bit unstable here. But I think just adding to the discussion right now was regards to the comment that I just made in the chat as well, that when you talk about creating resilience against disinformation or misinformation, we need to go back to the basics. We're talking about what exactly are the constitutive elements of discourse, why such discourses are able to entrench within a society. And I think it's really important to then target those particular elements, or to look at how to change the discourse, or how to change the narrative where it would not be riddled with misinformation, where it would not be riddled with emotionality as an appeal, and that's literally the only thing that is appealing to the audience. And so any intervention that is designed to suppress misinformation, to suppress disinformation, needs to look at the type of discourse that is resonating with the public right now, and not to treat individuals as passive recipients of information. They are experiencing information. Why are they doing so in such a manner? What exactly is changing in the political narrative in the current status quo? And I think looking into that is probably the only, coupled with educating public, coupled with creating awareness, is the way forward if we're to sort of suppress misinformation or the spread of misinformation further.
Thank you. And Salvatore?
Yeah, I think Anam and Christina summarized my thoughts very effectively. I'll say instead, thank you for having me.
Okay, thanks very much. Now we are moving to our last speaker, and thanks a lot for this panel.
Thank you.
Bye-bye.
Thank you very much. Now I'll
Thank you
take over at this stage, and we swiftly move to the final part of the conference. And I'm very pleased and delighted to introduce our evening keynote speaker, Professor Eleonora Rosati. I'm very humbled that Eleonora agreed to address us all tonight, and I'm pleased to welcome her here at Vytautas Magnus University, albeit virtually. Professor Eleonora Rosati is an Italian qualified lawyer with experience in copyright, trademarks, fashion, and internet laws. She's also a full professor of intellectual property law at Stockholm University and the director of the Institute for Intellectual Property and Market Law. She's also of counsel at Bird & Bird, an international law firm. She also holds a number of additional positions, including co-founder of Fashion Law London, editor of the Journal of Intellectual Property Law and Practice, and permacat at award-winning IP blog, The IP Cat. I'm sure that those that follow IP news know this blog well, and if not, if you haven't read it yet, have a look, especially if you're a cats person. Eleonora has written extensively in the IP field, and she's very thorough and an expert on copyright, and yet approachable, able to present her arguments clearly and in an engaging way. And I very much look forward to her tonight's address, Copyright Protection Systems, Intelligent and Autonomous. The floor is yours, Eleonora.
Good evening, everyone, and thanks so much, Julia, for the invitation and your warm words. I'm very sensitive, to praise, so I thank you for them. You've been too kind. Something that perhaps the participants to this conference might be interested to know is that yourself, and I see also other people in this call, such as Edvinas, have also published in the Journal of Intellectual Property Law and Practice. So I would like to thank you as authors of very interesting pieces, and I invite everyone to read your work in this journal and in other publication venues. Okay, so when Julia invited me to speak at this conference, she kindly said very generously that I could speak pretty much about anything. The topic of the conference was intelligent and autonomous, and so the challenge was to come up with something that would sit well with the program of today's conference. So let me start by sharing my slides and then explain what topic I have chosen. So when the title is Copyright Protection Systems, Intelligent and Autonomous, and when we think about the words intelligent, autonomous, and copyright, there might be quite a few things that come to mind, but I guess that right now there is one topic that dominates the debate, and I also understand that you've looked at that from the point of view of different areas of the law, and it is the relevance of artificial intelligence, what role it plays within the copyright system, and what challenges it presents for this area of the law. Here in this slide, I'm just presenting a few, really just a very limited number of examples of exercises that are currently being undertaken to understand the relationship between artificial intelligence and copyright and intellectual property more at large. So here we see the IEP, which is a professional organization of intellectual property lawyers, studying the relationship between AI and copyright in one of its study questions. So we have efforts being undertaken at the level of the World Intellectual Property Organization, the European Parliament, the European Commission, which published early last year a white paper on artificial intelligence, and then public consultations that are currently being undertaken by offices and authorities in several countries. Here's just an example from the United Kingdom. So we are really seeing an influx of studies, and I have to say that sometimes it feels a bit messy because so many ideas are being proposed, and yet so little so far is known as regards the correct relationship that there should be between these technological innovation and indeed traditional copyright and IP systems. For this talk, I thought of discussing three topics, which I hope will serve to find a common thread in this thorny relationship between AI and copyright, and also serve to answer the question whether indeed we can speak of intelligent and autonomous copyright protection systems. And in this respect, I would say that there are three key topics that dominate. The first one is training the artificial intelligence. So how we get to the point that the machine is in a position to predict facts, events, or it is in a position to create. So we have AIs that paint paintings, compose music, poems. They do pretty much anything that a human author can do. So what happens before that? What can be the legal restrictions to the training of the AI? You might have looked at these restrictions from the point of view of data protection, privacy, principles of public and private law, contractual restrictions, but of course also copyright plays a significant role because it is an overarching intellectual property right. It subsists in many different things, and of course the material that is used to train the AI is often something that is either protected by copyright and or is included in databases that can be protected by copyright or database rights. So this is the first issue. The second issue is what happens once there is an output created by artificial intelligence. Is that something that can and should be protected? If we think about paintings, music, films, books, etc., etc. If they are created by human authors, of course, they are protected by copyright. But can we say the same when these objects are created by artificial intelligence? Should we say the same thing or not? And then the final point, which is now particularly pressing also in the context of the EU policy discourse and also at the level of individual member states, is the use of filtering systems to protect copyright. If you have looked at the discussion around Article 17 of the Digital Single Market Directive, which was adopted in 2019, there is indeed an indication that AI-trained filters might need to be used by platforms to prevent the uploading and making available of unlicensed content. So these are all things that belong to the same cycle. On the one hand, training the AI, protecting the output of the AI, and using the AI to protect third-party copyright. We shall see in the end what conclusions can be drawn by these relationships and these different issues. Let's start from the first one, training the AI. Here, there are two key applications that those working in copyright have been thinking about. Using the AI to predict facts and events, and using the AI to create. And here I'm just proposing some examples of both. First of all, using the AI, train the AI to predict events. We have examples from the film industry. Indeed, the movie studios use these techniques to predict whether a certain film will be a success or not, and whether to decide if an investment makes sense in a new production. This is something that can be obtained, for instance, by mining hundreds, if not millions, of social media accounts, also to detect what sentiments we express when we say something, or we use this increasingly broad variety of like buttons. We cannot just simply like now. We can say that we care, we can say that we support, we can say that we are we find it amusing. So the range of sentiments that we can express has increased. And this is also very useful to have a more refined understanding of what we as users and consumers might or might not enjoy. Same thing happens in the music industry. Before a record label decides whether to invest in a certain artist or a certain genre, it uses these predictive tools to understand whether it is a move that makes sense from a commercial standpoint. Same thing in the fashion world. If you follow the work of Vanessa Friedman, the lead fashion critic of the New York Times, then you will see that she often writes articles in which she speaks about algorithmic fashion. When it was still possible to go to fashion shows in person, now things of course have moved to the online dimension. She said, you go to New York Fashion Week and it is really a feeling of deja vu all the time. Everyone proposes the same things, same ideas, same styles. How is that so? One might think perhaps because there is one leading house and then the rest copies. Or can there be another justification? The justification is that they all have the same technologies to understand and anticipate what consumers will want to buy. So in a sense, this reduces the risk of the uncertain. On the other hand, of course, it also reduces the risk of the unknown and the surprise effect. And she says that this is something that, of course, is potentially problematic because one of the tasks of fashion is to surprise, amaze, scandalize, to elicit a reaction in the consumers. If you are giving consumers what they implicitly or explicitly know they will buy already, where is this surprise effect? And this need to engage with technology is something that is also well expressed in this interview with the founder of a brand known as Theory, in which he said that indeed the fashion is no longer about the survival of the best designer, the most inventive designer. It is about the survival of the fittest, the one that is able to reduce risk. So how is this all done? Here I'm proposing an example, not from a commercial context, but rather from the context of an anthropological study. You can follow the link and read the full study. What was done here is that researchers at Cornell University wanted to understand what types of garments people like to wear in different parts of the world. And to do that, they mined 100 million photographs from Instagram. And they were able to access things that copyright law does not protect. Copyright does not protect facts, ideas, information per se. And so information such as that men of a certain age in Mumbai like to wear yellow, or women of a certain age in Mumbai like to wear bright pink, is something that copyright does not protect. However, to reach this conclusion, it is apparent that the AI needs to make copies of these 100 million Instagram photographs. And from a copyright standpoint, this is potentially problematic because the doing of acts of reproduction is something that falls within the power of the copyright owner. So if one also reads the terms of use of platforms like Instagram, they will see that when you upload content to Instagram, you retain the copyright in the content, and you just give a license to Instagram and its affiliates to indeed use the content that you are uploading, but this license is not given to anyone else. So it is clear that if someone reproduces these photographs, there is potentially a copyright problem. So the training of the AI, also in a predictive function, raises copyright questions. And then we have other applications of trained AI to create something new. Here's an example from Google Doodles. Not too long ago, Google, to celebrate the anniversary of the birth of Johann Sebastian Bach, made available a doodle that would allow Google users to compose music with the AI in the style of Bach. So this, from a copyright standpoint, is a really innocent example because the repertoire of this composer is, of course, in the public domain. But you understand that to make it possible for the AI to understand what the style of Bach is implies that it has been fed with the Bach repertoire, so that copies of these works have been made. Other examples of inventive AI, the one that you see on the right-hand side is a painting that represents a member of a fictional family. It is the portrait of Edmond de Bellamy, and the author of this work is the algorithm that you see signing the painting on the lower right corner. This is an example of AI trained on figurative materials and being trained to learn how to paint. Here we have other examples from the music industry. The first one, which I'm about to show, is just use of the AI as a tool. So from a copyright standpoint, it's not problematic. But the second one is an example in which the AI on its own creates music. I can play just a few seconds of these videos just to let you listen to what I'm speaking about.
I am the shape of a whisper that I am, the whisper of a good man. Feeling the space where the light goes missing, but I will be missing where the night lands. I'm a whisper, but it is not
etc. This is not too problematic because here the AI is a tool. What is problematic, however, is the fact that this AI, to help the human musicians, will need to be trained on musical materials and, of course, be fed with reproductions of musical content. To get to what point? To get to the point that the AI is able to create music on its own. And here we are not speaking about fantascientific issues, because it has been widely reported that, for instance, record labels like Warner Music have been increasingly concluding contracts with AI performers and musicians. And indeed, we are seeing an influx of AI-generated music, for instance, in the context of meditative music and disco music. So here's an example. Etc. I guess that some of you might have thought that this song reminded them of something. It has undoubtedly a 1960s vibe, no? And this is in fact a song created entirely by AI in the style of the Beatles. But to understand what the style of the Beatles is, of course, the AI had to be trained on the Beatles repertoire in order to create something that would sound alike. Again, from a copyright standpoint, this is a matter of reproduction and potentially copyright infringement. Other examples, the AI is able to write poems that sound like those of a teenager, but they're good enough to make a professional jury think that they're written by a human poet. The AI is so funny that is able to make better memes than what humans will be able to do. So, all situations in which the AI is really booming and potentially its applications span predictive tools, instruments to indeed creative outputs. So from a copyright standpoint, what is the answer that has been given so far? The answer has been to look into allowing the making of copies of works, indeed for mining purposes, to access what copyright does not protect. Facts, what the style of a musician is, what the people like to wear, all these things are not protected, but to get to this point, copies need to be made. And what is the approach that we are seeing across the world? We have jurisdictions such as Japan, which fairly early on adopted specific copyright exceptions allowing these activities. Then we have had other jurisdictions thinking about doing the same. In Europe, the first one to legislate was the United Kingdom in 2014. We have had a discussion about this in Israel. There is currently a consultation going on in Singapore, whether this is something that should be allowed by the law. In the US, there is not a specific approach. As you may know, there is an open-ended fair use clause under US law, so there is no need to identify a specific exception, but there is some indication at the level of case law that indeed these mining activities could be regarded, at least in certain cases, as fair use and therefore non-infringing. Now, at the EU level, what we have since 2019 is two new copyright exceptions, which are mandatory for member states to implement, and which would allow the undertaking of unlicensed text and data mining activities. So the doing of all these copies for training and predictive purposes. The first provision, Article 3, is aimed at those who undertake scientific research. So cultural heritage organizations and scientific institutions. And the second one, which is perhaps more important from a commercial standpoint, is Article 4, which allows the doing of text data mining for any purpose without any particular restrictions in terms of beneficiaries, but it is something that right holders can reserve. So currently, the transposition of this directive is ongoing across the various EU member states, but it is interesting on an international level to see that concerns about how these activities can be allowed is growing. The second topic is indeed what happens with this output. So we have seen AI creating paintings, we've seen AI composing music, but is this stuff protected or not? And should it be protected? For copyright protection to arise, there are 3 key requirements that need to be fulfilled no matter what jurisdiction you are being based in. There must be a work, and so that means there must be something that is sufficiently expressive. This something must be authored by someone, and it must be sufficiently original. Then there are other requirements in other jurisdictions, such as fixation and categorization, which are something that I will leave on the side because they are not really topical to what AI is concerned with. When we think about AI outputs and whether they are protectable by copyright, as it will be the case for any kind of human creation, there are 3 key issues we need to think about. Authorship, and that is key. Can copyright law recognize authors that are non-human? And then if the answer is in the affirmative, are these creations original, so to trigger copyright protection? And again, if the answer is in the affirmative, who owns the rights to this output? You understand that the relationship between these 3 topics is actually a hierarchical one. You can speak about originality only if you admit that there can be non-human authorship. So it is really a cascade kind of situation. So authorship so far is the big question mark. Why? Because there is no clear consensus as to what or who can be an author in a copyright sense. And this is a bit strange because indeed copyright is premised on the idea of an author. Yet there has never been a real investigation as to who could be regarded as an author, probably because it was believed that it will be something that you recognize. Of course, the person who made the painting is the author. Of course, the person who makes the music is the author. Yet, also in practice, there are many disputes concerning authorship. The most frequent ones are those when there is more than one author, but indeed, now also non-human authorship is posing quite a few headaches. At the US level, we have now clear guidance from the US Copyright Office that no registration of works will be granted to works that are authored by animals and machines. The examples that you see in the slide are not made up. They are actually taken from actual cases in which there were people who tried to indeed protect photographs taken by monkeys, paintings made by elephants, claims based on something that had been authored by the Holy Spirit. But of course, all this is something that is very important insofar as AI is concerned. And the position in the US seems to be that no AI authorship can be recognized. In Europe, things are a bit less clear-cut, I would say, because there is no real definition of who an author is. We have some indications at the level of EU directives that in general terms, the author, for instance, of a database, a computer program, is a natural person. But it is not excluded that member states can recognize also other types of authors. So here I don't feel like providing a definite answer, and this allows me to move on to the second issue. Assuming that there is room for non-human authorship, can the creations by AI be regarded as original? And here we need to understand what originality does mean. I think that it is difficult to provide a definition of originality when we speak in lay terms. That when we say that someone or something is original, what do we mean? Something never seen before, someone a bit weird, a bit out of the ordinary, someone with a lot of personality. It is difficult to make sense of what originality means. And things are even more difficult when this becomes the most important legal standard under EU copyright law. And the same goes for the copyright laws of other jurisdictions around the world. And the difficulty is made even greater by the fact that nowadays copyright vests in many different things, not just books and paintings, but also technical works such as computer programs and databases. So what we have seen around the world is a variety of approaches as to what indeed can be regarded as original. Traditionally, if you take the UK, the threshold was not too high. It was considered that originality meant sufficient skill, labor, or effort, and that what was worth copying was worth protecting. And the truth is that under UK law, there have been very few actions that failed on grounds of insufficient originality. For instance, there is an old case in which copyright protection was denied in a work written by someone while he was drunk. If you think about that, perhaps it was more about a moral judgment of the person rather than a technical assessment. And indeed, this has remained an isolated case. In the US, for a long time, the standard was that of sweat of the brow, so not dissimilar from the UK approach. And this standard was refused by the US Supreme Court in 1990 when the matter to decide was whether a telephone directory could be regarded as sufficiently original. Of course, this is something that takes sweat of the brow to realize. But according to the Supreme Court, this is not enough to satisfy the originality requirement. What is needed is a modicum of creativity. If we look at continental Europe, countries following the French approach, originality has been traditionally associated with creativity, personality of the author. And now, following a consistent string of decisions of the Court of Justice of the EU, we have an EU-wide standard. So what does originality require today in Europe? It requires the making of free and creative choices and that the personal touch of the author is visible in the creative result. So from an AI standpoint, what might be the issue? The issue is whether we can think that the AI is currently capable of creativity and personality. And these perhaps are more philosophical than legal questions, but indeed, while we can think about creativity and personality of a person, I think that it is more challenging to think of those attributes in relation to a machine. Let's assume, however, that originality is possible for an AI, then the final question becomes ownership. Who should own the rights to the output created by the AI? And here we find different approaches that are adopted across the world. For instance, in the UK, there is a provision that has been in place since 1988, which provides that for computer-generated works, the person who made the necessary arrangements is the author of that work. Why a provision like that seems odd, especially in 1988? The reason was that at that time, satellite photography was considered the next big thing, and therefore it was necessary to find a way to accommodate these photographs in the Copyright Act, and hence this legal fiction. According to some, it might be something that helps accommodate AI creativity. It is a fiction that is actually in place not just in the UK, but in most Commonwealth copyright laws, which conform and follow the traditional UK approach. But it is a fiction that perhaps does not solve all the problems that the AI in the future might create, including in particular when the AI becomes increasingly autonomous and, so to say, creative. So I feel that in relation to this second issue, the question that we need to ask ourselves is what is copyright for? What are we trying to protect when we think about rights in AI creativity and its outputs? copyright traditionally is regarded as either a natural right of authors, but for the AIs, I don't think that this argument would hold a particular strength, or as an incentive. Copyright is an incentive granted by the state to stimulate the production of items, objects that are considered valuable to society and to the public good at large. We all benefit from creativity. We are made emotional by good music, a good book, etc., etc. So here, who needs the incentive? Does the AI need to be incentivized to create? Probably not, at least not at this stage. So who needs to be incentivized? Probably is those who are investing in the development of the AI. But is copyright the right regime for this type of rationale? Probably if we want to safeguard this investment, we may think about sui generis special regimes, which might be indeed tailored based on the needs of the sector. This seems to be a more sensible approach and is the one that so far has been endorsed more widely. Copyright has also many other problems, including the fact that the term of protection is calculated on the life of the author, the fact that it comes with moral rights, the fact that in certain situations it has a personal right that is known as a resale royalty right, etc., etc. So probably copyright is not the solution to this type of creativity. And then a final thing, using AI to protect copyright. This is something that is now enshrined, of course not explicitly, in EU law. In 2019, the European Union adopted this directive, which indeed mandates a requirement on certain platforms like YouTube, user-uploaded content platforms in general, to seek a license from right holders to allow the displaying of user-uploaded content. In parallel to that, there are also attempts to strengthen the position of users by indeed making the character of certain exceptions mandatory, etc., etc. What is key to the discourse that I'm trying to develop is the fact that this provision also mandates upon platforms to prevent the making available of unlicensed content. And how do you do that when millions of hours of footage are being uploaded in a very short time span on your platform? Certainly, this is not something that you can do manually. And so the solution might be indeed in technological filters, or more precisely, AI filters. But how can an AI filter recognize that the parody that is included in a video is in fact a legitimate parody and not a copyright infringement? It will need to be trained on examples of permissible and non-permissible parodies. And here we go back really to the beginning, and this indeed shows how what we are speaking of is indeed a cycle. We are going back to the text and data mining exceptions. Indeed, for a company to be able to develop an AI filter, it will be key to be able to rely on the mining exceptions. And here we are closing the cycle. So, coming to a conclusion of all this, intelligent and autonomous, but insofar as mining exceptions are concerned, we are getting towards greater intelligence, perhaps not entirely autonomous, considering that right holders can still reserve the doing of these activities. But the approach of allowing the unlicensed doing of these mining activities is certainly more intelligent than not allowing that. Insofar as copyright protection of AI outputs is concerned, probably we are neither intelligent nor autonomous yet. In what sense? We lack the intelligence to understand what the correct approach should be. So far, we are navigating in a sea of question marks, and the AI is not yet at a point of being fully autonomous. The examples that I've shown to you are all examples of rather primitive AI. There is always the need for human output, the training of the machine by a team of human researchers. We are not yet at the point in which the AI is able to feed itself and create something in complete autonomy. So not there yet. And then insofar as AI filters are concerned, I would say that the answer is towards greater autonomy, but necessarily not always intelligence. A big criticism that has been presented against AI filters is that they are not able to recognize the context, and context is always key to understand whether a certain use is or is not infringing. And here's an example of successful AI. Pinocchio was born a puppet and then dreamt of becoming a child and eventually succeeded. So the plan is indeed to get to this point, but we are not there yet. So what we know so far, and coming to a conclusion of my talk, when we speak about the issues that surround AI and copyright, probably we need to worry more about potential liabilities, potential infringements, what we need to be wary of, rather than rushing towards discussions of whether these outputs are protectable and who owns the rights is able to make money out of them. We are not there yet. Perhaps a greater emphasis on the responsibility and liability angle is more important at this stage in the AI development. And indeed, when we speak about rights, we also need to speak about potential liabilities. When we say that, for instance, an AI creativity is something that is protected by copyright and its trainer, so to say, owns the rights, are we also ready to say that if the AI infringes some person's copyright in the process of creating, the trainer is responsible for this infringement and liable for it or not? Probably we need to think about this issue as two sides of the same coin. Rights go hand in hand with responsibility and liabilities. And the final point concerns the DSM directive, this piece of legislation that was adopted in 2019. And what I think is apparent from the text and data mining exceptions in Article 17 is that a common accusation that has been thrown at the directive, that is very heterogeneous, is probably unfair. These provisions probably are more interlinked than what one might think at first sight. And so also in the national transposition phase, it will be important to see whether a balanced interpretation and implementations of the relevant provisions can be achieved. Of course, the obligations under Article 17 will need to be fulfilled by also relying on the possibilities that are opened under the new text and data mining exceptions. And with that, I thank you for your attention. I shall stop my screen sharing. And if there are any questions or comments, I'm very happy to take them. Thank you for your attention.
Thank you, Eleonora. Thank you a lot. So, is it the end of a human author then? AI created content is cheaper, more effective, less risky. What about, so to say, crazy creativity and out-of-the-box thinking? Is it the end of human author?
But potentially for certain industries, it is a big problem, no? If you take, for instance, stock photography, there are entire agencies that have as their core business doing stock photography. Just, to explain what I mean, if we think about the distracted boyfriend meme that has dominated social media, that was born as a stock photograph, no? And we are seeing now applications of AI that indeed create photos that are as good as those, but without the need to hire models, without the need to secure releases. So this is an industry that is likely to be greatly affected by AI authors, filters, and creativity, and probably risks being seriously harmed, if not be bound to disappear to poor. So this is something that is happening, whether we like it or not, but perhaps we need to have a more thorough discussion as to whether we want to go in this direction.
Perhaps one could also ask whether it's the end of copyright as well, because if we incentivize authors to create, but then AI is more productive, when is AI no longer a tool to achieve a creative output, but is creating by itself? And can then authors that are not using AI compete on the level field with those that employ AI? So quite a lot of issues.
But if you also think about the issues around authors and performers contracts, those of you perhaps work in a new context might be aware that also those have been considered recently by EU legislatures, and now there are provisions in place to ensure fairness in authors and performers contracts. So also from the perspective of a record label, a publisher, etc., and you need to ask yourself whether you want to deal with some human author that is not happy about their contract, they want to renegotiate it, they want more money, and then you have an AI author or performer that doesn't tell you anything about that, they don't even want money, and certainly they don't criticize you for your attitude. So I think that this is also something that we need to think about, because I feel that the ideas that you're expressing, Julia, raise some concerns also about who the competitors of human authors and performers will be, and indeed whether this competition will turn to be something that favors the artificial creators over the actual human ones.
Also, I invite the audience to raise their hands if they want to ask, or type their questions in the chat box, and I can see that we've got a question following on my previous question. So what is your take on virtual computer-generated influencers, particularly as they are now moving from Instagram to music and advertising? Example, Calvin Klein's ad with the virtual influencer Lil Miquela.
I think that the kind of issues are more or less the same. Again, if you think about a virtual influencer, is someone that doesn't need to engage in any particular contractual negotiations. They don't need to agree to a certain use of their image. They don't need to have claims concerning their performers' rights, because one might think that an influencer is akin to a performer, and again, there are rights that are given to performers. So I feel that this rise of the robots is something that is coming to different fields and might, in certain instances at least, displace the need for human influencers, human authors, human performers, at least in situations of low creativity, I would say. There will be always the need to engage meaningfully, and I guess that we all feel this, especially now after 1 year in COVID lockdown. We want to engage meaningful with fellow human beings rather than Lil Miquela. And I think that we are getting there. That will be a desire after, this terrible period in our shared history. But I feel that this is a change that is there to stay, and at least in low creativity situations, there will be an increasingly fierce competition between humans and machines, and probably the latter will be winning in the long term. Also, if you think about models, a common remark that one hears about is that a model is asked to gain weight, lose weight, change their appearance, change their hair color, have a different way of walking the fashion show, etc., etc. Also, in those cases, probably having a virtual model will solve any problems. She can have, or he can have, the body shape you wish them to have. They can have the expression you wish them to have, and so it is much quicker, easier, and probably less expensive than thinking about engaging a real model. So in these situations, I think that the path is already set, and likely will be one that many companies will want to walk. What is your take? You think I'm being too pessimistic?
No, I would probably concur with your view. But then what do you think if we look at TDM exceptions, for example, if we look to America, and if we say in certain circumstances fair use exception is applied, do you think that human authors should be somehow compensated for their works being used to train AI?
But I think that if on the one hand we have exceptions, it seems in Europe that they cannot be remunerated once, no? So they're different from private copying. There will not be a fair compensation requirement, so to say. But I feel that also by introducing these exceptions, we are getting another message. And it is the fact that if you do these activities outside a license or the exception, then you are doing an act of copyright infringement. And this is important because for a long time, text and data mining was a very big gray area. There were, mottos being put forward: the right to read is the right to mine. So this is something that copyright should not restrict. But now, if we have copyright exceptions, the answer is that copyright does indeed restrict these things, because if you are outside the exception and the license, then you are potentially infringing. And so, to answer your question, I feel that right holders might seek remuneration with greater clarity than what might have been the case in the past. The issue will be, however, to know when your work is actually being used to train, because I guess that from an evidentiary standpoint, it will be a very difficult task to perform successfully. Also because of the volume of the corpus with which an AI is being trained. Like, for instance, if you take, the AI has been trained with my Instagram photographs. How can you know that they used your Instagram photos? I think that it will be very difficult to think of concrete cases in which one can demonstrate that indeed the AI was trained with those, unless we come forward with an obligation of transparency and that it is necessary to disclose what you used to train your AI. I don't think we are there yet, but it might be an idea for future legislative interventions if this is deemed something worth pursuing.
Or perhaps collective compensation methods or something along the lines. But yes, detection and enforcement is always an issue, especially when we talk about digital technologies. Do we have any more questions?
I will try one. Yeah, so do you, Eleanor, think that in the future AI could get like personal rights? I mean, because at the moment I understand we still think about the creator of AI, right? But going further, there are talks that AI can create another AI, which then learns itself. And then I know that it might be problematic because in US it was rejected in regards to animals, stating on the fact that animals cannot not only create their copyright, but also cannot claim for infringement. I'm not sure if AI possibly could do that, but what are your thoughts on that? And yeah.
But we've had an example in Saudi Arabia, if I'm not mistaken, there was that robot, Sophia, who was granted citizenship. So that is already going in that direction. But as I said, in another event at which Julia was present, why, for instance, the UK fiction is not really appropriate long term, because we are getting towards an age of increasingly sophisticated AI. So this legal fiction might become increasingly unsuitable. Why? Because you tell me that the person who made the arrangements for the AI creativity is the author of the work, no? If we end up with an AI that is so sophisticated, that is able to select the materials to use, actually acquires their own personality, because each robot of the same brand is different from others because it has its own personality, etc., etc., then a fiction like that might be like telling you that your parents are the authors of the works you create just because they made you. And I think that it sounds absurd if told to a human person, and it might become also this way when we are speaking about an AI author.
Okay, makes sense.
What
Great
is your
analogy.
take? What do you think, Edvinas? How would you respond to your own question?
Well, I totally agree. Until certain limit, it's good for lawyers, you know, to think about the fiction, but if we would go too further, it could actually, well, we can end up that also we destroyed someone's emotions of the AI, and then maybe some intangible or immaterial damage should be claimed. But at the same time, the problem could be that someone, if we do not grant certain responsibility, it could be that, well, humans, the creators of this AI, could overcome the restriction to infringe someone's IP rights and use AI to actually falsify or to duplicate, say this. So, well, it's gonna be interesting to see where it's gonna end. With animals, it was clear, and I totally agree with that decision. With AI, well, it's still fun. Let's see how far can it go.
But of course, you know, there are also examples of bad AI, you know, a topic that you know better than me, deep fakes, no? This is an example of how AI might be used for the good, but might be also used to deceive, confuse, spread indeed the misinformation. So this is an example. And from a legal standpoint, of course, there are criminal law issues to consider, but if we look also about if we look at the intellectual property dimension, copyright issues, when the AI creates a deep fake based on footage representing someone, image and publicity rights, etc. So this is a topic that you know much better than myself, but I think that there are also, you know, concerning applications, at least in certain instances.
Yeah.
I see that someone is asking about the papers on my talk. I'm happy to send you an article that I've published on some of the issues that I've spoken about. So we'll send you an email after the event.
If we don't have any more questions, we might conclude this session, and I thank you, Eleonora, for your presentation, for joining us tonight, and I give the floor to Ignas to conclude the conference, and then to all the speakers that have received the MS Teams link. Let's meet there in a few minutes' time.
Thank you very much for having me. It's been an honor.
Thank you very much. And for me, there's not much left, actually, just to give special thanks. First of all, to give special thanks to the organizations that supported this conference. So this conference was supported by IREX Media Literacy in the Baltics, and also the public discussions that took place in this conference were part of the integrity study of future law, ethics and smart technologies a project run by Vytautas Magnus University. For organizational support, I would also like to thank the university's UNESCO Chair on Media and Information Literacy for Inclusive Societies. And of course, our hosts, the Department of Public Communication and the Law Faculty of Vytautas Magnus University. And last but not least, all of the speakers of today and all of the keynote speakers of today as well. It was really a pleasure organizing this event, hosting this event. And I really hope that this is not the last event of this kind and that we will meet again, perhaps in a year's time, perhaps, hopefully, in a more kind of in-person setting than Zoom. So Fingers crossed, and hopefully see you next year. So goodbye, good luck, and stay safe, everyone.